Sriram sir.
ಹೇಳಿ ಸರ್.
Sriram sir.
ಹೇಳಿ.
Sir, serial number 38 ಒಳಗೆ needful has been done, sir. List 1, sir.
ಸರ್ ಬಂದಿನ ಮೆನ್ಷನ್ ಮಾಡಿ ಸರ್.
ಹಾ sir.
First preference 230.
ಹೌದು ಹೌದು.
First preference 230.
ತೊಗೊಳ್ಬೇಕಲ್ಲ.
ಹಂಗ ಕೇಸ ಹಂಗಿರ್ತಾವ.
ಅವನೇ ಇಲ್ಲ ಅವನ ಆಗೋದು ಒಂದಾಗಲ್ಲ.
और परचेस करा है ट्रू कलर भी नहीं आता फिर.
ಭಯ ಪಡಿಸ್ಬೇಕು ಅಂತ.
This is waves, tsunamis.
Mob is gathered.
230 because 230 6 meters.
My lord.
ಅದು ಕೇಳಕ್ಕಾಗಲ್ಲ ನೋಡೋಣ.
230. Inform ಮಾಡಿದ್ದೀನಿ.
ಜೈ
My lord.
ನಿಮ್ ದಿನಕ್ಕೆ ಬೆಂಡು ನಮ್ಗಲ್ಲ. ಏನು
230.
ಕೊಡಿ. See,
My lord.
tomorrow no problem.
tomorrow.
Today, tomorrow, whatever.
One matter pertaining to CH6 for tomorrow,
ಕೊಡಿ.
being spoken to ಇದೆ.
ಕೊಡಿ.
Tomorrow.
My lord.
Being spoken to ಅಂತ ಕೊಡಿ. Yes.
My lord,
My lord.
in regard to list number
My
3,
lord. My lord.
serial number.
I moved the memo.
ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
230, my lord.
Am I audible, my lord?
230. ಕೇಳಿಸ್ತಾ ಇದೆ.
Both of you are audible. Are we audible?
Yes, my lord, loud and clear.
Yes.
Serial
ಹೇಳಿ.
number 7 and 8 in the third list. Serial
We'll
number
come, we'll
8,
take it up. List will take it up. Any mentioning?
no, my lord, it will be taken up right now, my lord.
Yes, Ms. Devraj? ಅವ್ರೇನಿಲ್ಲ ಆಯ್ತು.
My lord.
List 3 ತಗೊಳ್ಳಿ.
My lord.
Yes, ಹೇಳಿ.
ಇದ್ರ ಮೆಮೊ 230 my lord.
ಯಾರ್ ಮೆಮೋ ಮೂವ್ ಮಾಡಿರೋದು?
Oh, ಪ್ರಕಾಶ್ ಬಿಡ್ಕರ್. ಕೋಟಿ.
ಯಾರಪ್ಪ?
230 similar matter as disposed of.
ಅವ್ರ ಪರವಾಗಿ ಯಾರು ಮೂವ್ ಮಾಡಿದೀರಾ? ಯಾರು ಮೂವ್ ಮಾಡಿಲ್ಲ. ಮೂವ್ ಮಾಡಿದ್ರೆ ತಗೊಂತೀವಿ. ಕೊಡಕ್ ಹೇಳಿ.
230 disposed of similar matter.
Yes, 230, all 230 allowed ಅಪ್ಪ. ನೋಡೋಣ.
Please, my lord.
These three matters, total number 6. 1, BB Bajantri.
Well, I request on next week. I have to file a reach on the statement of objection. Man.
2013 fresh matters.
Yes, sir. Hard matter, man. Hard matter taken, man.
All disposal matters were taken for fresh.
ಹಂಗೆ. ಅಲ್ಲೂ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಮಾಡಿ 230 ಲಿಸ್ಟ್ ಮಾಡಿ. ಯಾವತ್ತು ಹಾಕ್ಬೇಕಂತಮ್ಮ? ಇಲ್ಲ ಅವ್ರಿಲ್ಲ. ಏನ್ ಡೇಟ್ ಕೊಟ್ಟಿರೋದು ಲಿಸ್ಟ್ ಇದೆಯಾ? ಏನಾದ್ರು ಡೇಟ್ ಕೊಟ್ಟಿರೋದು ಏನಾದ್ರು ಲಿಸ್ಟ್ ಇದೆಯಾ? ಯಾವ್ದು ಕೊಡೋದಿಲ್ಲ ಏನು ಗೊತ್ತಿಲ್ಲ. At the request of counsel for the counsel for the petition, relist after 2 weeks.
Yes.
2, J Shetty.
Same order.
3,
Same.
4, Ravi Hegde.
3 weeks. 4.
5,
2
Vijay.
weeks.
6,
Lordship,
6 has been settled.
6 has been settled. Petitioner is before this court seeking for the following reliefs. A memorandum of agreement has been filed, which reads as under. The said memorandum of agreement has been signed by the petitioner, advocate for petitioner, manager of respond number 3, and the advocate for respond number 2 and 3. Both the counsel for the petitioner and the respondent submit that the matter has been amicably settled, the amounts due have been paid, and the documents
DD, they have to give, today they'll give the DD.
and the documents would be returned.
Yes,
When?
within 20 days.
Within 20 days from today. Placing their respective submission, the petition stands
From-
dismissed as settled out of
From
court.
the date of certified copy, because I have to send the certified.
From today, ಮುಗಿತು DD ಬಂದಾಯ್ತು. ಅದಾದ್ಮೇಲೆ 20 days ಏನು?
Please.
7,
My lord, for the petitioner in this matter,
Yes.
this matter, my lord, this matter pertains to bonded labor. If the matter can be listed early next week, my lord.
7 release next week.
8,
8, my lord, is I'm appearing for the petitioner. Actually, the matter today was listed for dictating of orders, my lord. The synopsis has been submitted. Arguments were completed on the last day.
Relist next week. Next week.
Grateful, my lord.
8, DM Malli.
ಅಲ್ಲ ಇದೆ
8 ಆಯ್ತು. Next week.
9,
9, 2 weeks.
please
10, KL Patil.
2 weeks.
11, HM Darigon.
2 weeks.
12, Harshvardhan.
2 weeks.
13, SR Hegde,
2,
14, GA Gachinmat,
But I request for March 10th.
ಯಾವುದು 14 2 weeks. 2 weeks granted to the counsel for respondent to file statement of objections.
Any particular date?
15,
Release thereafter.
Kishore Sutat,
My lords, there is interim order. I seek for 2 weeks.
3 weeks interim order is extended.
16, Sadiq
Flash.
Budwala,
Tender matter, release next week.
17, Rajshekhar Gunjali,
2 weeks
18, Sadiq Budwala,
next week.
19, Nilendra Gunde,
Next week.
27.
20,
Next week.
21, SC Kadkati,
Administrator.
21 to 26, 2 weeks.
Serial number 33, my lords.
Next week edit.
Service matter appa 2 weeks wait madam.
27, KL Patil,
Kindly pass over, my lords.
ಏನಕ್ಕೆ?
Urgency, my lords, since matter pertains to election, my lords, election not.
27 pass over.
Please.
28, Prashant F. Gaudar,
2 weeks.
29,
My lord, 26, my lord, next week.
Service matter.
No,
ಏನು?
it is mandamus. The petitioner is getting superannuation in the month of May. And it is mandamus to the appellate authority to dispose her appeal.
Dispose the matter. 26 next week.
27, my lord.
Hmm.
27, my lord, 28.
Pass over.
28.
Yes.
Release of sugar, it
2
seems.
weeks.
Release of sugar.
2 weeks.
29, Ramchandra Mali,
There is some urgency. It could be taken up on Monday or Tuesday. In fact, it is covered by my lord's decision, my lord.
ENCS. Release next week.
Grateful.
30,
Next week.
31,
31, 32, 2
My
weeks.
lord,
31.
30.
ಒಂದೊಂದೇ ಕರೀರಿ. ನಾವೇನೋ ಶಾರ್ಟ್ ಕಟ್.
31, it's a suspension matter, my lord.
Yes.
Covered by my lord.
We're not dealing with all of it now.
Next week.
Next week.
My lords, 32.
ಮಧ್ಯಾಹ್ನ ಒಳಗೆ ಮೆಮೋಸ್ ತೊಗೊಳೋ ಒಳಗೆ ಸಾಕು. ಇನ್ನ 230 ಲಿಸ್ಟ್ ಸ್ವಲ್ಪ ಪ್ರೀಪೋನ್ ಮಾಡ್ಬೇಕು ಅನ್ಸುತ್ತೆ. ಯಾರ 230 ಲಿಸ್ಟ್ ಏನಿದೆಯೋ ನಮ್ ಕೊಟ್ಟು whoever is ready will take it up before lunch only.
My lords, 32. My
32.
lords, mandamus, my lords, seeking a direction to enroll, my lords, the list of members, my lords, because there is a,
Last time, Lords, Honorable Court has directed me to secure Lords instructions. Next week, any date, my Lords?
32 release next week.
Please.
34 next week.
34,
may I request for a password? 34 ಅಲ್ಲಿ it was only for consideration of interim prayer. The rowdy sheeter is opened, Lord, against the order passed by Lord.
I will get,
Yes.
I will get instruction on next week, my Lord.
ಅಲ್ಲ interim order ಅಲ್ಲಿ ಕರೆಸ್ಬಿಟ್ಟು harassment ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಷ್ಟೇ.
ಅದು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಬಂದಿಲ್ಲ.
Previously it was for instruction.
For release, finally release next week at the request of the learned AGA.
35, DM
My lord, 35, I appear for the petitions council, my lord.
Yes.
My lord, this is a sugar matter release. 235 crores is outstanding to the farmers. My lord, I was unable to sell without the permission. Your lordship granted several orders, my lord, even in Bangalore bench. In fact, I myself appeared before my lords. It's only that one, 50% of the stocks may be permitted
Mr. Alakeri.
sold. My lord, it was told last time to other side, and we have to be asked to file an appeal.
Yes, but whole problem, Mr.
Please, my lord.
Shridhara, is you sell and then don't
No,
pay
no,
them.
I'm
You
sorry,
use
my
it
lord.
for various things.
My lord, that is
That
the
is what
reason
we are
why-
seeing in 2-3 matters now.
I'm sorry, my lord. That is the reason affidavit has been filed in this case on behalf of the managing director, chief CMD. Therefore, kindly grant an interim
Pass
order.
over.
Grateful, my lord.
36,
2 weeks to comply.
37, Sabil Ahmad,
Lords, may I request, my lord, next week, my lords.
2 weeks.
Please, your lordship.
38, AB Patil,
Next week, any date, Lords.
Next week.
39, Kishore
2
Sutar,
weeks.
40, Sirajuddin Ahmad,
Next week.
Next week, please.
41, Gauri
2
Shankar
weeks.
Moore,
Only mandamus, I'm seeking only mandamus. It is perishable goods, my lord. Rice has been seized. Since 1 year, they have not released my rice. Now even the criminal case is quashed.
1 year wait ಮಾಡಿದ್ರೆ 1 week wait ಮಾಡಕ್ಕೇನಪ್ಪ?
Case ಮುಗಿದ ತಕ್ಷಣ ಬಂದು ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ರು.
Monday, my Lords.
Next week 41. 42
My
next
lords,
week.
my lords, my lord, my lords, rowdy list, removing name from the rowdy list, my lord, mandamus I am seeking, my lord.
ಅದಕ್ಕೆ
No,
next week
The next
ಆಗ್ತದೆ.
week.
my lord, date Monday, my lords, may I request.
I'll
Monday,
get instructions by
Monday, may I request, my lords.
ಡೇಟ್ ಕೊಡಲ್ಲ.
date next week, please.
43 KL
ನಮ್ಮ
Patil.
ರಾಷ್ಟ್ರ ಕೊಡೋದೇ ಡೇಟ್
Please,
ಕಷ್ಟ ಇನ್ನು.
please, your lordship.
43 KL Patil.
This case, my lord,
ಹಾ
the wakalat was filed by taking no objection.
ಹಾ
The wakalat while writing the name in the column of that is wrongly the one of the other person's name was written, but signature is correctly taken and number is also mentioned. For that, your lordship may please to see the deputy registrar while passing the impugned order directed to initiate 379 proceedings against.
Where is the wakalatnama? VD Kuldekar, respond number 5.
That is also NOC.
But signature is of AV Bairangina.
Bajrangi sign. He is A5. Kuldekar is one of the respondent.
Kuldekar, respond number 5 and ಬರ್ದಿದ್ದಾರೆ.
ಅದು
ನಿಮ್ ಕ್ಲರ್ಕ್.
respond number 5 is AV Bairagi. ಆ ಹೆಸರು ತಪ್ಪು ಬರ್ತದಕ್ಕೆ it is a offense and 340 earlier 340 now 379 is initiated.
And AG accepts notice for respond number 1. No, issue notice to respond number 2 to 5, returnable by 23rd April.
3 to 5
The
suspension.
further proceedings. The order dated 21/1/2025 and the further proceeding case number so and so at Annexure G is stayed till the next date of hearing. Process fee and copies to be furnished by end of day 28th, failing which interim order will stand automatically.
3 to 5 dispensation. 3 to 5 dispensation.
ಬರ್ಲಿ.
Okay. 44 Shant Kardevar.
2 weeks.
45 Vijayendra Bhimaknawar.
ಏನಪ್ಪ 2 weeks.
ಅಲ್ಲ, I seek not interim order. It's a service matter.
ಏನ್ interim
Krishna,
order?
my lord, is working. Lord, she is working as a helper in Anganwadi Center, lordship. Now, my lord, the authority has issued a notification for appointing of the Anganwadi worker within the 3 kilometers parameters of that Anganwadi worker, my lord. As per the, my lord, notification, if it is within 3 kilometers, if any post of Anganwadi worker is vacant, if the helper is, my lord, already completed 3 years of work, lordship, she has to be given promotion and she has to.
ನೀವು ಎಷ್ಟು ದೂರ ಇದ್ದೀರಾ?
Within 3 kilometers. That
Within
certificate.
3 kilometers.
That certificate is also produced.
But then you'll have to apply with the details.
No, lordship. That cannot be, my lord. There is a government order, lordship.
ಎಲ್ಲಿದೆ government order?
Annexure G.
Page?
Please.
Annexure?
G, lordship.
There is no annexure G. Annexure F is the last annexure.
Your lordship. Page number 26. Hello. Urgently runs. Lordship. Page number 26. Formal.
26.
Please, lordship.
Yes.
It's a government order. 5/6/2020 ನೋಡು ಒಂದು ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತ ಹುದ್ದೆ ಖಾಲಿ ಇರುವ ಅಥವಾ ಹೊಸ ಕೇಂದ್ರ ಪ್ರಾರಂಭಿಸುತ್ತಿರುವ ಗ್ರಾಮದಲ್ಲಿ ವಾಸಿಸುತ್ತಿರುವ ಸಹಾಯಕರಿದ್ದು ಅವರು SSLC ಉತ್ತೀರ್ಣರಾಗಿದ್ದು ಕನಿಷ್ಠ ಸೊ ಇಲ್ಲಿ ತಿದ್ದುಪಡಿ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತ ಹುದ್ದೆ ಖಾಲಿ ಇರುವ ಅಥವಾ ಹೊಸ ಕೇಂದ್ರ ಪ್ರಾರಂಭಿಸುತ್ತಿರುವ ಗ್ರಾಮದ ಯೋಜನಾ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ವಾಸಿಸುತ್ತಿರುವ ಮಿನಿ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತರಿದ್ದಲ್ಲಿ ಅವರು ಅಂಗನವಾಡಿ ಕೇಂದ್ರದಿಂದ 3 ಕಿಲೋಮೀಟರ್ ವ್ಯಾಪ್ತಿಗಳಿಗೆ ವಾಸಿಸುತ್ತಿದ್ದು ಕಾರ್ಯಕರ್ತ ಹುದ್ದೆಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದಲ್ಲಿ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತ ಹುದ್ದೆಗೆ ನೇರ ಅಭ್ಯರ್ಥಿಗಳಿಂದ ಅರ್ಜಿಗಳನ್ನು ಆಹ್ವಾನಿಸದೆ ಆದ್ಯತೆ ಮೇರೆಗೆ ಸದರಿ ಮಿನಿ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆಯನ್ನು ಸಾಮಾನ್ಯ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಹುದ್ದೆಗೆ ಆಯ್ಕೆ ಮಾಡತಕ್ಕದ್ದು ಹಾಗೂ 3 ಕಿಲೋಮೀಟರ್ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ವಾಸಿಸುತ್ತಿರುವ
The government order is there. There's no.
Please.
Why invite?
Whether she is residing in that parameter, your lordship, I had to ascertain.
that
your
certificate also.
Say it for now and post it next week. You can get the instruction.
Please.
Learned AG accepts notice for respond number 1 and 2. The further proceedings in person of the notification bearing number so and so dated 15/10/2024 issued by respond number 2 at Annexure C is stayed till the next date of hearing. In the meanwhile, petitioner is permitted to submit an application.
In respect of the petitioner only, your lordship, that.
In respect of the petitioner is concerned, meanwhile petitioner is permitted to
I have
submit an application in terms of annexure D to the concerned authorities.
Please.
please. Much obliged.
45, Vijayendra Vimaknawar.
My only request in this, lots, let the respondents file statement of objections in this. He is
Our
78,
respondent.
78 years old.
ಯಾರು ಫೈಲ್ ಮಾಡಬೇಕು?
All the respondents, boss.
ಯಾರು ಮಾಡಿಲ್ವಾ?
He is 78 years old. Section 17 has been
Time is
withdrawn.
finally granted to the respective respondents to file their respective objections. If objections are not filed by 14th March, the same will be taken as not filed and the matter proceeded with. Relist after 3 weeks.
Please.
46, Gangadhar Uskeri.
2 weeks.
47, Anand Kumar Astekar.
Pay for the petitions, my lords. Interim order was granted, my lords. I'll comply.
Counsel for the petitioner seeks and is granted a week's time to make payment of necessary process fee. Full is done by 7th March. Issue notice to the unserved respondents. Return by 29th April. If needful is not done by 7th March, relist on 12th for dismissal.
Great, my lords.
48, Sunil Desai.
Some urgency, my lord. Second is the election.
Yes.
For yes, my lord.
I'm led by a senior counsel, but may I request at 2:30?
Pass over.
Please,
Please.
obliged. Please.
Obliged.
49, AC Chaklapi.
Petition. Writ of mandamus, lords. It is covered by judgment of this honorable court.
Thanks.
Where refund of GST, lords. Post GST and
Post GST.
is covered, lords.
ಯಾವ್ದೋ ಇದ್ರಲ್ಲಿ ಇದೆಯಲ್ಲಪ್ಪ. ನೋಟಿಸ್ ಆಗಿದೆ.
ಹೌದಾ?
ಏನ್
In this
GST
case, ಇಲ್ಲ. ಇದರಲ್ಲಿ, my lords, already endorsement has been issued in this case itself, my lords. Regarding his claim, annexure Q is already, my lords. It requires hearing.
Q eligible.
ಸರ್ಶ್ವರ ಕೇಳಿದ್ದೀರಾ? ಅದು ಬರೀ ಮ್ಯಾಂಡಮಸ್.
ಸರ್ ಯಾವ್ದಿದು? serial number 49.
Sorry.
ದೊಡ್ಡಗೌಡರು ನೀವು ಕಟ್ಟಿದ್ದು ಮ್ಯಾಂಡಮಸ್.
ಪ್ಲೀಸ್ ಲರ್ಡ್ಸ್, mandamus.
Please, please.
ಇಲ್ಲ ಅವ್ರು ಯಾವ್ದೋ ಬೇರೆ ಫೈಲ್ ನೋಡಿ.
ನೀವು ಸರ್ಶ್ವರ
Sorry.
606 ಇದ್ರಲ್ಲಿ ಸರ್ಶ್ವರ ಕೇಳಿದ್ದೀರಾ? Page 13.
No, ಇದರಲ್ಲಿ endorsement ಕೊಟ್ಟಿದ್ದು.
Title declaration.
Declaration.
Certiorari and declaration that entitled to. Certiorari for annexure K to K9.
ಅಂದ್ರೆ
certiorari ಇಲ್ಲ.
My second writ petition is writ of mandamus directing the respondent to consider my representation to refund the GST. It is covered under the Justice Krishna Kumar Sahib judgment.
This matter requires, my lords, hearing. We have already given, my lords, the endorsements.
ಎಲ್ಲಿದೆ?
My lords,
K1 to
please, my
K9.
lord. That's why
K1
I'm
to
saying
K9
requires.
is my representations.
Certiorari.
ಎಲ್ಲಿ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಎಲ್ಲಿ ಇದೆಯಪ್ಪ?
There is no endorsement.
But why are you seeking for quashing of K1 to
I
K9?
am seeking declaration, Lord. Declare that
ಮತ್ತೆ ಏನ್ certiorari ಕೇಳ್ತಾ ಇದ್ದೀರಾ ಇಲ್ಲಿ?
declaring that the petitioner is entitled for reimbursement of the defendant differential GST amount paid by the petitioner for the works executed as per the representation dated K2 K9.
Issued an endorsement.
ಇಲ್ಲ.
ಇಲ್ಲ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ.
ಫೈಲ್ ಏನೋ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ.
ಇಲ್ಲ. ಸೇಮ್ ಆರ್ಡರ್ ಇದ್ದಲ್ಲಿ.
Much obliged, Lord.
May I make mention, the advocate, Mr. Allikeri is there, my lord. Serial number 35 may be taken.
35. ಮೈಕಲ್ ಮಾತಾಡಿ ಅವ್ರು ಕೇಳಿಸ್ಬೇಕು.
My lord, the union has passed an order, my lords, in order to prevent rush of all the sugars in the market and or, my lord, holding of the sugar, my lords, in order to control the price, control the supply, and, my lord, the entire chain, my lords. It is not, my lord, prohibited from sale. What union has done is only they pass an order that every month how much sugar can be brought to the market, my lord. That's all is the restriction that is held by them.
The quota given to the petitioner.
My lord, your lordship, my lord, monthly quota my lord, at annexure B, annexure A is a January month quota.
Hmm.
Your lordship may take page 28.
Yes,
Serial number 88 is there, my lord.
Siddhapur.
Siddhapur, my lords. My lord, 12,273 metric ton, my lords, for December, my lords.
Hmm.
And then, my lords, your lordship would find for January, my lord, at page 42, 12,682 metric ton,
Serial number
88,
12,682.
88. Yes, my lord. And in the similar fashion, my lord, previous, before the December also, October, November, all that is given. But they want, my lord, a permission from this court to, my lord, sell entire thing, my lords, as an interim order.
I don't
And,
request entire thing, my lord. Now 235 crores is outstanding. I have sold the sugar which was permitted by them. I cannot make the payment. My lord, law says I have to make the payment within 15 days from the supply of sugar
This
cane.
quota is fixed before production or after production?
My lord, it is, my lord, on every month basis, my lord, from long time, my lord, this is being done. And my lord, the power, my lord, and jurisdiction, my lord, was called in question before several high courts. The High Court of Bombay and High Court of Madras have already dealt with the issue, and they have said, my lord, there is a power for and it is a reasonable restriction, my lords. They claim a right under 19(1)(g).
But do you fix this quota beforehand or after the month?
My lord, their crushing, my lord, started.
Monthly statement ಕೊಡ್ತೀರಾ quota for the whole year?
Then, my
In
lord,
advance ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
advance ಕೊಡ್ತಾ ಇದ್ದೇವೆ.
Advance ಕೊಡ್ತೀರಾ?
Advance.
ಯಾವಾಗ ಕೊಡ್ತೀರಾ? ಇವಾಗ ಅಕ್ಟೋಬರ್ ಯಾವಾಗ ಕೊಟ್ರಿ?
My lord, this
But every month they issue the release order at the end of the month to be sold in the next month. But the crushing
Give it in advance. 30th October you are giving for November.
November.
Yes,
That is how they are doing it.
2025. No, my lord, this annexure B, my lord, order is passed on 31st of December 2024. My lord,
January.
taking the sugar, my lord, stock tentatively till 31/1/2025.
But let the government of India take over my sugar and make the payment to the farmers. I am holding 10 lakh quintals of sugar in my godown.
Mr. Shashidhara, you know that you will be entitled only around 12,000 in all these 3-4 months that they have given you is 12,000. Who asked you to produce more?
No, that is the area reserved in my favor. My capacity is 15,000 TCD. Union of India has given the permission. License was given. But farmers cannot suffer. Within 15 days, if I don't pay, I may be prosecuted. I am liable for 15% interest.
One more, that if they make a representation before the commissioner, my lord, bringing their grievance, he will, my lord, take into accounts of everything, and my lord, he will, my lord, forward it to us for the additional, my lord, release or anything. Instead, my lord, they are rushing to this court.
But every year they don't have objection at all. In fact, this restriction has been removed in 2013. For 5 years there was no restriction. Again 2018 they clamped. Unless until I have a grievance, and if the bank finances, I have no difficulty. Bank is not ready to finance for the sugar industry now as a working capital. All this has been considered in the previous matters. His Lordship Justice Satyanarayana has considered elaborately the objections.
Where is the order?
Objection.
Where is the order? Where is the order?
Page 135.
135.
135. It was in 2018. All these objections were raised. May I read, madam?
That's a team.
It is impossible with this quota which they are releasing it. And I have been permitted to sell the sugar and make the payment. Even your lordship in principal bench have granted an interim order of 50%, my lord, subject to condition.
We have granted, but this aspect was not been considered.
Please, my lord, this was considered.
This submission of Mr. Alkeri, we have not considered in any of the matters.
Identical objections were raised in the past also. My plight is, my lord, this way. 15 days, within span of 15 days from the supply of sugar cane, I have to make the payment under class 3 of the sugar cane control order. Otherwise, I attract 15% interest and prosecution under section 7 of the EC Act.
Mr. Alkeri, you are now issuing this for the purpose of controlling the price. so that the price doesn't go down.
There are two aspects.
It is coming in the market. We would understand if you were issuing the directions to produce and give it in the market so the price is maintained.
But price
By
today,
this
as on today, it is too high.
Virtually acting against the general public.
No, my lords. Your lordship may kindly take the Mumbai High Court judgment, the Madras High Court judgment, my lord, in which the matter is dealt in detail. All the reasonings, aspects, everything is covered, my lords.
Let the Union of India take over my sugar. I have no difficulty, and make the payment to the farmers. One way they say that.
Do that, you are free
So,
to
my
do
lords,
that.
please, my lord.
The sugar is produced.
The sugar
Farmers
is,
have to be paid.
yes, my lord.
We would understand if they were hoarding and you had given a direction to them, don't hoard, sell it.
Yes.
But here is a situation, you are not permitting them to sell on the ground that by permitting them to sell, the prices will come down.
In fact, prices are shooting up now. Well, now 38,
Prices
35,
down is in the
39.
interest of the general public.
Please, my lord.
You are not required to maintain an artificial higher price.
No, my lord. Artificial higher price is not done because entire national stock is, my lord, taken into consideration. And state, my lord, district wise, every stock is taken into
What
consideration.
happens if there are more stock which comes into the market?
Then, my
In
lord,
fact,
they
it
can
is benefit. It benefits the public. I'm sorry, man.
Don't keep on interrupting.
They can release it stage wise, my lords.
What is the purpose of it?
My lord, one is the price, my lords. Price has to be maintained, my lords.
Why do you need to maintain the price?
Because, my lord, some of the
Price
sugar
at a
companies.
higher level.
Please, my lord.
You are maintaining a price at a higher level.
We are maintaining price at a higher level is one that's one aspect, my lord.
That we are not
Now, my lords.
acceptable.
No.
If you are doing it for a lower level, yes. Not for a higher level.
Now, my lords, we have fixed a slab for the price, my lord. At this price, it should be sold, my lords.
You have fixed a price that it should not go beyond that price. 45 ರೂಪಾಯಿ ಅಂದ್ರೆ 48 ರೂಪಾಯಿ ಹಾಕೂಡದು. But 45 ರೂಪಾಯಿ ಇರೋದು 30 ರೂಪಾಯಿಗೆ ಬರಂಗಿದ್ರೆ, what's your problem?
That's what, my lords. Now, our price fixation is, my lord, suppose if it is 45, nobody can sell below 45. They have to sell above 45 only, my lords. Then, my lord, then there are the smaller mills, my lords, and other mills who will, when this bigger stock comes into the market, they will not be able to compete with them with respect to price just above that 45 rupees. So, my lord, on those scores, your lordship may kindly take your lordship may kindly take the Madras High Court, or else, my lord, they may be permitted to sell it in, my lords, as per the quantity that is prescribed, or, my lord, they may make an application before the sugar controller.
Permit them to sell, you come up with your policy. For respond number 1. 2 ನೀವು accept ಮಾಡ್ತೀರಾ?
Please, my lord.
2 ಗೆ.
2, my lords. 1 and
of sugar.
1 and 2, Allikeri will appear, man, for Union of India.
Yes, Allikeri, who has filed caveat for respond number 1, accepts notice for respond number 2.
2. I take for 2 also.
AGA accepts notice for respond number 3 to 5. Where is that order we have passed earlier?
My lord, your lordship's order is not passed, my lord. I mean, produced. Annexure
140,
page 140, annexure W. My lord, of course, full permitted. I don't want, my lord, let your lordship pass 50% only.
Number 140.
Page 141.
May I make one submission, my lord, just? That, my lord, they have called in question the order passed by the sugar controller, my lords, where they are directed to pay a certain amount, my lords. Now, my lords, my lord, if that order could be, my lord, stayed, immediately we will file our statement of objection, and this matter could be, my lord, heard and disposed of in a couple of days itself, my lords.
What is the then in the meantime?
Instead of passing a release order, that's my humble submission.
I'm sorry to my learned friend.
You are asking for quashing of A, B, and C.
No, D and E also, my lord. D and E is the recovery certificate issued by the state government. Otherwise, they will seize my stocks and sold it in the action to make the payment.
C will pass an order.
My lord, D and E
will pass an order. B, since you asked for quashing, without that we can't.
Yeah, please, my lord. D and E may be stayed in the meantime. I may
D and E
permit
will
to
stay.
sell.
The operation of the recovery certificate at 4/2/25 issued by the fourth responder annexure D and the notice of respond number 5 at dated 5/2/25 at annexure E are stayed till the next date of hearing. It is for the respond number 1 and 2 on the respondent number 3 to 5 to come up with a solution for the problem which is being faced by the petitioner herein, inasmuch as the respondent number 1 and 2 have imposed a restriction on sale of sugar, whereas respondent number 3 to 5 are calling upon the petitioner to sell the sugar and make payment of the monies to the cane growers. Thus, both the instructions of these two set of respondents has put the petitioner into the dilemma requiring the petitioner to approach this court. This court believes by the next date, a resolution to this embargo would be arrived at between respondent number 1 and 2 on the one hand, and respondent number 3 to 5 on the other.
My lord, only one submission I may be permitted. My lord,
yes.
The same central government has permitted 10 lakh metric tons of sugar to be exported. Now the prices at the domestic market is 38, 39 as against the minimum rate of 32.
Since you have asked for stay of quashing of ABC, it will have to be considered.
My lord, your lordship, without seeking such a quashing, I can't seek for an interim order. Because
released on 6th March.
But it is really causing.
It is made clear that no adjournment would be granted on that day.
Please.
It is causing hardship to the farmers moreover.
Yes, we have stated the recovery notice. That problem is not there.
But not only recovery, whatever the farmers, 235 crores is outstanding.
Yes, but your ABC will have to be first quashed, Mr. Shashidhara, before that order can be passed.
My lord,
it cannot be interim order.
I have argued several matters. My lord, it is not the first time, but permission was given, and that is the reason why I have been asked to file an affidavit by His Lordship Justice.
In none of those, ABC had been the kind of relief that you have sought for had been sought before us.
It was there, my lord. It was there. No. There was an affidavit I have filed. May I take your lordship to take the affidavit? Affidavit ತಾವು ನೋಡಿ ನಾನು ಹಾಕಿದ್ದೀನಿ ಮ್ಯಾನೇಜಿಂಗ್ ಡೈರೆಕ್ಟರ್.
See, we have listed it on 6th.
Serial number 28.
Please.
28.
Similar.
Same. 28 connect to 35. Same order.
No, my lord. My lord, it's only connection because they have not sought for such an interim prayer. Maybe connection, my lord. It may be connected, my lord.
Interim order ilva
ರಿಲೀಸ್ ಕೇಳಿದ್ದಾರೆ ಅವ್ರ ಮೇಲೆ ಯಾವ್ದು ಸ್ಟಾಕ್ ಇಲ್ಲ ಇದಿಲ್ಲ.
ರಿಕವರಿ ನೋಟಿಸ್ ಇದೆಯಾ? ಕೊಡಿ 28 ಕೊಡಿ.
Recovery, I have filed a separate petition.
ಕೊಡಿ petition.
And I had also filed, my lord, undertaking.
Question ಕೇಳಿದೆ ಆನ್ಸರ್ ಮಾಡಲ್ಲ ನೀವು. There is no such interim.
Please.
Connect ಅಷ್ಟೇ.
Please.
27 KL Patil. KL Patil.
Pass.
48.
230. Shivraj says Jaykumar Patil sir is appearing for him.
Yes.
He requested 230.
230. Pass over.
230. Please.
230 ಗೊತ್ತಿಲ್ಲ.
ಏನೋ ಸ್ವಲ್ಪ 2ನೇ ತಾರೀಕು ಎಲೆಕ್ಷನ್ ಇದೆ ಅದಕ್ಕೆ
ಗೊತ್ತಿಲ್ಲ ನೋಡಿ.
List 1.
Please, my lord, small one submission will be there.
Yes, madam.
List number 3, my lord, serial number 9, my lord, missing the person in 2020, my lord. 5/10/2020 in already investigation report in submitted public prosecutor. Anyone report not will be.
Serial number 9.
Yes, my lord.
Next week, any date, report is ready. We will file. We will file.
Delay, my lord. 2023 filing, my lord. Anyone report.
ಒಂದು ವಾರದಲ್ಲಿ ಏನಮ್ಮ ಆಗುತ್ತೆ? 23 ಅರ್ಜೆಂಟ್ ಇದ್ರೆ ಹೇಳಿ. 23 next, sorry, serial number 9 next week.
Please.
2 weeks ಅಂತ ಹೇಳಿ next week.
List 1. KS Patil.
Appear for the petitioner.
Yes.
Entries are made on the basis of the will. Anna Sahib Patil. He died in the year 2006. In the year 2016, a stranger to the family files application enclosing a will. That will was executed in the year 2003. And demands his name be entered in the record of rights.
Yes.
The mutation entries were made. the name of Anna Sahib Patil is deleted. Then, my lords, the name of respondent number 4 came to be entered. We challenged it before the DDLR. My lords, the order came to be set aside, reinstating the name, my lords.
Any suit has been filed?
My lords, no suit is been filed. The will, may I take, my lords, to the will itself appears to be suspicious.
You are a third party, not a family member.
Family member.
Son is excluded.
No, my lord, sir.
He is
No,
he's
all of
bachelor.
Petitioners
He's
all are
bachelor.
class 2 here, my lord. She is also class 2 here.
Class 2 year.
She is class 2 heir, sister. She is
Filing
spinster.
girl.
She is spinster.
Neevaru.
My lord, I am one of the sisters' son.
No. He is a far relative,
Are you
not
related?
blood relative.
Will says that so, my lord.
He is far relative.
I am saying I am have.
You have to establish the will.
Let them establish.
That is true, my lord. I cannot. I had informed the party, but he is insisting to file objection, and that is.
I the objection file madi will state.
Well, sir,
already
stay is
stayed.
there. Already 4 adjournments are sought by my friend.
I have taken a time.
4
also, my lord,
times he has taken time.
The operation execution of the order dated 27/1/23.
He is already stayed, my lord.
Stay ಆಗಿದೆಯಾ?
Stay ಆಗಿದೆ.
I am not saying this statement. It's already this.
ಇನ್ನೇನು?
I am only request, my lord, any date may be fixed. By that time,
Allah.
I will get instruction. If my lord, I'll instruct my party to file. a suit.
Kindly.
Instruction of respond number 4 at the fervent request of the council for respond number 4. 1 week's time is finally granted. It's made clear that no further adjournment would be granted. Relist on
6th or 6th or 10th.
Released on 7th March.
Please.
Grateful.
2,
Lord,
Deshpande.
may I seek for a pass-over,
Paso.
please?
3,
Joyce is here. Paso.
Like, Lordship has directed me to produce 4161 and award, and with regarding to the payment having been received. For that reason, I am seeking pass-over.
Paso ಆದ್ರೆ reach ಆಗೋದು doubt ಇವತ್ತು.
ಅಲ್ಲ
Only one.
ಅಲ್ಲ ಅದಕ್ಕೆ we have not furnished for that reason.
ನೀವು ಅದೆಲ್ಲ ಆಗಕ್ ಮುಂಚೆ ಜೋಯ್ಸ್ ಅವ್ರನ್ನ ಯಾಕೆ ಕರ್ಕೊಂಡು ಬಂದ್ರಿ ನೀವು? ಇದೆಲ್ಲ
My
ಮುಗಿಸ್ಕೊಂಡು
lord, we had secured all the records only insofar as disbursement to the petitioners.
ಆಯ್ತು, paso
ಅದು
inspection
ಒಂದಕ್ಕಷ್ಟೇ
ಕೊಡಿ.
it was a.
Inspection ಕೊಡಿ before.
Yes, madam. I have to pay.
ಏನ್ ಮಾಡಿದ್ರು?
3, Girish Adjournment.
May I make a small request? Even after inspection, but your lordship's earlier order is that copies of the save it, notice, please. I would be grateful if your lordship sees the earlier orders.
Dated
Last date.
last date.
24/2, this is what your lordship was pleased to say. The AGA submits that he has secured records today which contain notification 4/1 notification 6/1 award, as also the details of payments made to the predecessor of the petitioner. He seeks for and is granted 3 days temporary place the same on the record after due service on the council. Even if it is inspected, madam, and if they are placed on the record, we must have copies of them so that we can make our submit. This is one aspect. Second aspect is that there is no statement of objection filed by any of the respondents, including in my petition.
We have filed objection statement through the
Come
second
on,
petition.
if you don't mind, let me come.
I'm
Sorry. In my writ petition, none of the respondents has filed any statement, but the earlier order is on
Sir,
6th,
appearing
your
from
lordship
Mr.
said,
Deshpande.
because they said objection statement filed in the other petition of Mr. Wadier be treated as they kindly
Yes,
have a look
we
at.
have already
Therefore,
passed an order on 6/2 on that basis.
Yes.
for that matter, we intend filing a rejoinder statement without which pleadings. Sorry.
AGA.
I'm sorry for it.
Submit that inspection of the documents would be furnished, the copies of the documents.
Yes.
Nam copies good buddy.
Then AGA submit that a memo with the concerned documents would be filed within 2 days' time after serving a copy thereof on the counsels for the petitioner in both the matters.
Please.
Then counsel for the petitioner seeks for and is granted 2 weeks' time to file a rejoinder to the statement of objections filed by respondent number 4 in WP 146863 of 2020, since the said statement of objection has been treated as statement of objection in WP 104351 of 2023. Relist after 3 weeks. Relist rejoinder and or objections to be filed on or before 21st, relist on 27th. Please.
3, Girish Advard.
Lord, in this, on the last occasion, on my request, the Lordship has adjourned the matter to file an affidavit of the Principal Secretary.
Order dated 21/1/2025.
Lord, we have not yet received affidavit. On my request, the Lordship's 2 days time quoted.
This is very clear. This one Tahsildar has said that he.
Yes, my Lord, I agree with in the affidavit at para number 6. He has stated that a communication having.
Only 1 day's time in this.
How though? And my request, my Lord, the Lordship has granted.
We'll give you tomorrow.
Please.
If tomorrow is not there, we'll draw adverse inference and go ahead.
Please.
And AGS seeks fund is granted a day's time to file the affidavit of the Principal Secretary. If the affidavit is not filed by 28th February, adverse inference would have to be drawn and the matter proceeded with.
Please.
Released tomorrow.
It's on 20.
Please.
4, Lakshmesh Mataguppi.
Here in the petitioner card in question, the annexure.
Yeah, your purchaser.
Lord grantee.
Legal heirs of the grantee. The respond number 1. Consider the violation.
Learned AGA accepts notice for respond number 1 and 2, issue notice to respond number 3 and 4, returnable by 25th April. The execution operation of the order bearing number so and so passed by respond number 1 is stayed till the next date of hearing. The petitioner as also respond number 3 and 4 are restrained from in any manner alienating, dealing with, encumbering or creating charge over the subject properties and or putting up any construction thereon till the next date of hearing.
Please.
Process fee and copies to be furnished by end of day 28, filling which interim order will be.
5, M. Keri.
Petitioner applied for conversion of his land for non-agricultural land. By the Assistant Commissioner and Tahsildar has given matters. It is a pit and.
Certiorari.
Yes, ma'am. Annexure D.
Yes,
Notice agide direction.
But your lordship again, because my learner friend reliable connected matters order, but your lordship in 2 writ appeals are filed, your lordship that are pending.
2
writ appeals are filed because your lordship he is claiming conversion, your lordship, for less than 5 guntas. To that extent, your lordship, I have filed a writ appeal, your lordship.
Yesterday the extent to
4
guntas.
This honorable court, my lords, already disposed of similar situated and.
In 4 guntas,
it is very. Is there none part of
Jameen property of 4 guntas is 4,500 square feet.
But similar matters, your lordship, dispose of the matter. But your lordship, we have filed writ appeal, your lordship, questioning that.
Same village matter limits on the same, just 42 bar for A per Borbe, 4 per 4. It just.
What basis do you say that because it is less than 5 guntas, you won't grant conversion? There is no such rule.
But your lordship, it is the.
There is a government circular of 2000 and 2021, wherein, my lord, only insofar as Uttar Kannada and
that is
Kannada, less
only
than 5 guntas.
they can be converted.
For conversion. Insofar as other districts are concerned, it is not permissible. That is the circular which has been issued. Based on which, my lord, we have all the conversion orders where writ appeals have been filed by the state, seeking with regarding to that government circular.
Stay agide alli.
But your lordship,
about 30 to 40.
They are not posted, your lordship, we have filed writ appeal, phone number, your lordship.
That is the part which has been.
Yes.
Lord, extent of land kadimi ittandre.
Petitioner is before this court seeking for the following leaves. The petitioner, being owner of land bearing survey number 42/13 measuring 4 guntas, situated at Kalagadgi town, Dharwad district, had made an application for effecting conversion of the said property from agriculture to non-agriculture purposes. The said application came to be rejected by respond number 2 while its endorsement dated 8/1/2024 at Annexure H on the ground that the
less than 5 gunta.
Extent of land owned by the petitioner is less than 5 guntas. It is challenging the same, the petitioner is before this court and has sought for the aforesaid relief. The particular statute relating to conversion and the applicable law is covered under section 95 of the Karnataka Land Revenue Act. In terms of said provision, there cannot be any restriction as regards the extent of land as regards which conversion is sought for, which would be considered an artificial requirement of 5 guntas being sought to be imposed on the petitioner. And since the land of the petitioner is not more than 5 guntas, conversion would not be permitted, is not sustainable in view of section 95 of the Karnataka Land Revenue Act. In that view of the matter, I pass the following order. Writ petition is allowed. The endorsement issued by second respondent bearing so and so at annexure E is quashed. Respondent number 2 is directed to consider the application of the petitioner afresh, if necessary, by calling upon the petitioner to furnish such other and further documents as may be necessary and pass necessary orders in terms of section 95 within 30 days from the date of receipt of a copy of this order.
But earlier, Your Lordship, this honorable court on 28/2/2025 directed to file affidavit, Your Lordship, but in view of the
ಇದನ್ನ ವೇಟ್ ಮಾಡೋದು ಬೇಡ. ಒಂದ್ಸತಿ ಬಂದಿದ್ರೆ ಕ್ಲಿಯರ್ ಆಗಿ ಎಲ್ಲದಕ್ಕೂ ಆಗೋದು, ಬಂದಿಲ್ಲ.
But I brought
ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಕೊಡಿ.
same Lord.
Next same ಮೇಲೆ 3 gunta ಇದೆ. 3 gunta 8 anna.
ಇದು 3 guntas 8 annas.
Same village.
In 42/A2 Kalgatti zones.
Yes.
Same order.
Please.
Pending I does not survive.
6 SK Kakmat.
Yes.
It's appear for respond number 4, my lord. The
And you have blocked it.
My lord, so this CDP, my lord, is of the year 2031. In the earlier CDP of 2012, no road was shown. And this property, my lords, was acquired for the purpose of NWKSRTC. We have built a convention hall. The compound was built in way back in 2006. In 2012 CDP, my lords, there is no CDP road shown. And this 2031 CDP, my lords, is notified in the year 2019 itself. My lords, this building, this compound, my lords, was existing since 2006. It's not that we have blocked any road. In fact, there was never a road.
So you should have challenged that CDP.
A CDP, my lords, we have raised objection with the HDMC. That is still under consideration. And my lord's judgment, my lords, which my lords, while delivering my lords regarding this Jai Mahal Hotel case, if they don't acquire the land after notification of the CDP within 5 years, then that part of the my lords change of land usage lapses. So in 2019, my lords, this 2031 CDP, my lords, was
2 days back Supreme Court judgment bandid. All that has been validated by the Apex Court. Maharashtra Town and Country Planning Act, section 127. No reservation in perpetuity.
That, my lords, I have not. Nam
actually for the road is in perpetuity.
The road, my lords, they say street patterns, highways, state highways. Here, my lords, it is a road connecting, my lords, the.
And place it on record.
I'll file necessary application.
That counsel for.
Respond number 4.
Respond number
4. Shri
Prasant Toshmani has entered appearance for respond number 4. Delete MC Ukkeri as that appearing for respond number 4. Shri Osmani submits that the construction put up by respond number 4 was during the existence of the CDP of the year 2012.
Even prior to the 2006, my lords, in 2006 we have put up the construction.
Very recently, they wanted to construct they started a construction in where the road passes. The compound has been constructed long back. There was an opening.
Road agalalla, Mr. Kai.
There was never a road, my lords, until the 2031.
Part of it, it can't be formed. There is a mistake by the HDMC. They could not have shown a road in a building.
Because already opposite road has been formed in the case at itself. There is the connected one is connected to the Court Lingeshwar Nagar, another one is Jamarkopa.
Plans Burley, we'll have to. HDMC in party madidira?
Party madid.
So you will have to say why you have made that. A CDP of the year 2006.
2012.
600.
6 we have constructed.
was construction in the year 2006, the CDP having come into force in 2012,
There was no road.
no road was shown as regards the location where the construction is put up by respondent number 4. And it's only in the year 2019 that a modified
They, my lords, came up with a new CDP of 2031, which
revised
was notified in
CDP
2019.
The year 2031 came into force, wherein a road has been shown, as regards which respondent number 4 has submitted objections to the SDMC. He is directed to place all these factors, documents on record. The SDMC is directed to make the submission as regards the status of the road in the CDP, and if there's any proposal to form the said road by acquiring the land of respondent number 4. Released on 14th March.
My lord, my name may be deleted since.
Deleted.
7, A. Veeranna.
Purchaser or landowner?
Landlord, my lord. Children of landlord.
And AGA accepts notice for respondent number 1 to 3, issue notice to respondent number 4 and 5, returnable by 24th April. The operation of the order passed by respondent number 2 dated 28/8/23 at so and so, and that of respondent number 3. So, idin stay madakagala. Your resumption is being dismissed. Then stay illa. The petitioner and respondent 4 and 5 are restrained from any man alienating, dealing with, encumbering so and so of the any scheduled property, subject property, or any part thereof till the next date of hearing. Process fee and copies to be furnished by end of day 28, failing which interim order will stand.
8, Girish Bhatt.
Yes.
Mandam must to rectify the revenue entries, the covered by my lords.
8 and 9.
8 and rectification of the revenue entries, my lords. Land was given in the name of governor.
In same property, na? 81
Adjacent,
bar 12. Same order, 81 bar 5 barley, 81 bar 12. And AGA accepts notice for respondent.
9,
Same, 9ers.
This number. AGA 81 bar
81 bar 13.
81 or 13.
81 bar 13.
Please.
10, Vishwanath Hegde.
Previous date, my lord, I want to.
Plan sanction and photograph.
Oh.
ಇದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲಿಲ್ವಾ ನೀವಲ್ಲಿ?
Produce ಮಾಡಿದ್ದೇವೆ.
Where is the reference to it in the order?
My lord, at the time of appeal, my lord. But absolutely no material produced before the trial court ಅಂತ ಹೇಳಿ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. My lord, the encroachment, my lord, the contention taken by the plaintiff, my lord. Page number 27 ಅಲ್ಲಿ document place ಮಾಡಿದ್ರ ಬಗ್ಗೆ relevance ಇದೆ.
Commissioner appointment application ಹಾಕ್ಲಿಲ್ವಾ ನೀವು?
ಇಲ್ಲ ಇಲ್ಲ.
ಯಾಕೆ?
ಇನ್ನು because my lord, the common wall photograph shows, my lord, the wall is adjacent to each other, my lord. My lord, the plaintiff.
We'll appoint a commissioner. Issue notice to the respondent. Returnable by 28th March. The ADLR, yavidu? Shiggaon. He is directed to cause an inspection of the property bearing plot number 8 in RS number 223/5 and plot number
17.
17.
ಹೌದು.
8 and 17 adjacent ಹೆಂಗ್ ಬರುತ್ತೆ?
ಹೌದೌದು ಇದೆ. ಅದನ್ನ ನಾನು ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಜರು ಮಾಡಿದ್ದೇನೆ ಸ್ವಾಮಿ.
8 and 17 ಅಕ್ಕಪಕ್ಕದಲ್ಲಿ ಇದೆ.
ಹೌದೌದು ಇದೆ. My lord, document number 3, page number 6, my lord, along with memo, I produced the map, my lord. My lord, this is the plaintiff's property. 8. Plot number.
Page number?
Page number 6, my lord. Document number 3.
ಹಿಂದೆ ಮುಂದೆ ಇದೆಯಾ?
ಹೌದು.
8 and 17
Please.
in survey number so and so, RS number 223/05. Ascertain the length and width, the area of both the properties, as also if there is any other open space between the said properties.
Please.
The inspection to be carried out commencing from 14th March 2025 at 10:30 AM. After issuance of notice to the respondent herein. Since the order is passed in the presence of the petitioner is at liberty to be part of the said inspection and measurement. If the petitioner were not to participate, the petitioner would not be entitled for any equitable remedies. Equitable consideration. Report to be filed on or before 21st March.
11, Santosh Raut.
Yes.
For respond number 13 and 14. Gave it a file.
The petitioners filed the application for regrant of the land under provisions of Village Office Abolition Act.
Yes.
The said application came to be rejected by Tahsildar, holding that the said lands are not the Inam and Marki Jamins. Agreed by that, the petitioners have prepared the miscellaneous appeal before the district court. District court's rejection, holding that there was a compromise between the purchaser and the petitioners, and they are not entitled. And the more interestingly, my lord, as on the date of passing of the order by the Tahsildar, the applications filed by the petitioner as well as the respond number 14 were not before the Tahsildar, as he has issued the endorsement saying that the applications were not found.
You did not file the application Village of Inam's Abolition Act. You filed it under the SCST Act.
No, my lord. That is subsequent, my lord. Prior to that, the applications were pending. One miscellaneous order is there.
Illi.
If my lord may peruse annexure D. D. Wherein the respondent number 2 and 2 has got the land granted in his favor, saying that page number 82, annexure D.
This is filed by Kolkar. Kalappa Chandrappa Kolkar. Their ancestors, sir.
Yes, my lord.
Balappa.
Tippanna's LRs, my lord.
Tippanna. Yes.
Son of Tippanna, my lord.
The respond number 2 herein in this miscellaneous appeal has been granted with the land under the provisions of Village Office Abolition Act. That was assailed before the district court, wherein district court observes that considering the application of present petitioner as well as the respondent, same may be considered. Thereafter, after 1987, there was no action taken by the Tahsildar. Therefore, after issuing the notification at annexure F, my lord, the present petitioner filed application for regrant. That application was came to be rejected. If my lord may peruse the
These were proceedings under the, 3(2) of the Village Office of.
yes, ma'am.
Yes. ಅದಾದ್ಮೇಲೆ ಏನಾಯ್ತು?
ಅದಾದ್ಮೇಲೆ ಅವ್ರು ಏನು ಆಕ್ಷನ್ ತಗೊಳ್ಳಿಲ್ಲ. ದೇರ್ ಆಫ್ಟರ್ ದಿ ನೋಟಿಫಿಕೇಶನ್ ವಾಸ್ ಕೇಮ್ ಟು ಬಿ ಇಶ್ಯೂಡ್ ಬೈ ದಿ ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಫಾರ್ filing of fresh application, my lord. If my lord may peruse the notification at annexure F.
Annexure?
F, my lord, in page number 124. Pursuant to, in page number 124. It is issued on 15/2/2022.
Yes.
Pursuant to this notification, again the present petitioner filed application for regrant. Annexure G. This application has been opposed by the respondents and the Tahsildar passed the order. At annexure K in page number 186. If my lord may peruse the operative portion of the order.
Idu you have filed on under what act?
My lord,
I'm interested in also. Inferior Village Office, okay.
yes, my lord. If my lord may peruse in page number 202. The operative portion of the order passed by the Tahsildar.
Yes.
ಮಚ್ಚೆ ಗ್ರಾಮದ ರೀಸಾ ನಂಬರ್ 643 ಒಟ್ಟು 3 ಎಕರೆ 7 ಗುಂಟೆ ಮತ್ತು ರೀಸಾ ನಂಬರ್ 644 ಒಟ್ಟು 3 ಎಕರೆ 15 ಗುಂಟೆ ಜಮೀನುಗಳು ಕರ್ನಾಟಕ ಗ್ರಾಮಾಧಿಕಾರಿಗಳ ರದ್ದತಿ ಕಾಯ್ದೆ 1961ರ ಅಡಿ ಮರು ಮಂಜೂರು ಕೋರಿ ಒಂದು ಕಲ್ಲಪ್ಪ ಚಂದ್ರಪ್ಪ ಕೋಲ್ಕಾರ್, ಬಾಳಪ್ಪ ಪರಪ್ಪ ಕೋಲ್ಕಾರ್, ಪಾರಿಸ್ ರುಕ್ಮಿಣಿ ಕೋಲ್ಕಾರ್, ತಿಪ್ಪಣ್ಣ ಸೋಯನ್ಸೋ ಮತ್ತು ಫಕೀರ ಕೋಲ್ಕಾರ್ ಇವರುಗಳು ಸಲ್ಲಿಸಿದ ಅರ್ಜಿ ಮತ್ತು ಎನ್ ಅಬ್ದುಲ್ ಸಾಹೇಬ್ ಬಿನ್ ಅಬ್ದುಲ್ ಸಾಹೇಬ್ ಇವರು ಸಲ್ಲಿಸಿದ ಅರ್ಜಿ ಸದರಿ ಜಮೀನುಗಳು ಇನಾಮ್ ಜಮೀನುಗಳ ಸ್ವರೂಪ ಹೊಂದಿರುವುದಿಲ್ಲ ಅಂತ ಕಾರಣ ವಜಾ ಮಾಡಲಾಗಿದೆ. ಇಫ್ ಮೈ ಲಾರ್ಡ್ ಮೇ ಪೆರ್ಯೂಸ್ annexure A.
Nowadays ಇನಾಮ್ ಜಮೀನುಗಳು ಸ್ವರೂಪವನ್ನು ಹೊಂದಿರುವುದಿಲ್ಲ ಅಂತ.
But if my lord may peruse the Inam register at annexure A. These lands are the Inam lands, my lord.
Sale number, page number?
My lord, 28 is the Inam register, my lord.
Relevant portion.
And typed copy I have produced at ink page number 69.
ಇದೆಲ್ಲ ಮರಾಠಿಯಲ್ಲಿದೆ.
ಇಲ್ಲ, translated typed copy. Ink page number 69. 69. It is on 70, page number 70, survey number 643. Last allide. And ink page number 71, there is a survey number 644.
Illide the manuscript portion illide, which page number?
My
Register ಅಲ್ಲಿ
ಇದೆ ಸರ್.
Sale number 21. Page 56. 643. Sale number 22. 22 ಅಲ್ಲಿ ಯಾವುದು? ಇನ್ಯಾವ ಸರ್ವೆ ನಂಬರ್ 643 and?
My lord, survey number 644.
Page number 58.
644 ಎಲ್ಲಿದೆ? 644. So 643 and 644 have been entered into the Inam register.
Yes, ma'am.
ಆಮೇಲೆ ಏನಾಯ್ತು?
That the assistant commissioner, the Tahsildar says it is not the Inam lands. This is contrary to this annexure, my lord. They agreed by that. We prepared the miscellaneous appeal before the district court. District court rejects, holding that confirming the order passed by the Tahsildar and also regarding regrant made on 11/10/1979 in favor of one Abdul Qadar. And proceedings which are pending in review petition, those have been considered by the district court.
This register was of which year?
My lord, it is of the year 19.
Year ಕಾಣಿಸ್ತಾ ಇಲ್ಲ ರೌತ್.
My lord, last ಕೊಂದಿದೆ. I think page number 61. Don't date ಇದೆ, but Inam register is prepared prior to
When was it prepared?
1348, my lord.
The date ಎಲ್ಲಿದೆ?
Date to ಅದು ಇದ್ರಲ್ಲಿ ಸಿಗ್ತಾ ಇಲ್ಲ.
'53, '54 ಅಂತ ಒಂದಿದೆ 66 ಅಲ್ಲಿ, ಅದೇನ್ ಡೇಟ್ ಅಂತ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ.
My lord, one date we may find that ink page number 50.
Examined in 53, 54.
My lord may find ink page number 50, wherein it is stated that 31/7/26.
15.
50. At 11, serial number 11, there is a date 31/7/26 anta.
ನಿಮ್ದೆಲ್ಲಿದೆ? Serial number 21. Chogle Berich, Agna so and so. So date ಇಲ್ಲ. Yes. ಏನಾಯ್ತು ಇದರಲ್ಲಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
Session court ಅಲ್ಲಿ Session court confirmed the order of the Tahsildar saying that the land is not the Inam land and there is a proceedings which have been concluded in RSA. With that confirmation, the Sessions Court, without considering the claim as well as the submissions made by the petitioners, has rejected the appeal.
What are the proceedings in the before the?
Para 25, my lord, page 274, finding of the my lord appellate court. Regarding the litigations, my lord, which have went and attained finality.
ಇದು ಸೇಲ್ ಆಗಿದೆ.
ಇದು ಆಕ್ಷನ್ ಸೇಲ್ ಆಗಿದೆ ಪ್ರಾಪರ್ಟಿ.
ಮಾರಕಿ ಅಂದ್ರೆ ಏನು? ವಾಟ್ ಕೈಂಡ್ ಆಫ್ ಇನಾಮ್ ಇಸ್ ಮಾರಕಿ?
Kolkarki and Marki, my lord. Kolkarki and Marki. Those are
ಮಾಡೋದು ಮಾರ್ಕಿ ಇನಾಮ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ?
Service inam.
service inam.
What is the service?
The services are to maintain
by the Mahar community.
ಏನ್ ಸರ್ವಿಸ್ ರೆಂಡರ್ ಮಾಡ್ತಾರೆ?
ಊರಾಗ ಉತ್ತಾರದ ಸತ್ತವ್ರದ್ದು ಹೋಗಿ ಮನೆಗೆ ಡೀಟೇಲ್ಸ್ ತಗೊಂಡ್ಬರೋದು ಇಂಥದೆಲ್ಲ ಮಾಡೋದು. ಕೋಲ್ಕಾರ್ಕಿ
ರೆಕಾರ್ಡ್ಸ್ ಎಂಟ್ರಿ.
Maharki, Kolkarki and Walikarki. 3 years.
Malki,
Kolkarki, Walikarki. Warki.
Auction sale agidella idu, as
Blood,
per the finding.
may I,
1931,
may I make submissions?
CS number 253 of 1931 on 1/6/1939, which has not been challenged by you.
Blood, may I make submissions? As on the date of auction, the land was marquee land. And another thing, the one Basha and company was the having leasehold rights. Those have been sold, my lord, not the land.
Where are those documents?
Those
Where is the auction notification?
Well, even otherwise also, if my lord may peruse the order of the Tahsildar, I think page number 78, Annexure C.
And RSL settlement ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದಾರೆ.
Lord, the father
ನಿಮ್ಮ
of the
ತಂದೆಗೆ.
petitioner himself.
ನಿಮ್ಮ ತಂದೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತಾರೆ.
My lord, review is pending, my lord. Review is pending.
Review is pending.
Because
In a compromise, how can review?
what has happened, my lord? Without any grant, re-grant, the compromise was entered.
By
And
your father.
Moreover, as on today, the land, owner of the land is government, my lord. My lord, may peruse Annexure C in page number 78.
In light of all these things, probably your petition will have to be dismissed, but notice will have to go to others.
Lord, in this, earlier there was a suit filed by father of the petitioner in 97 itself. That came to be dismissed. Against that appeal is filed. In appeal it is confirmed. Thereafter, my lord, arraigning the father of the petitioner and some others, some of the family members, very same family members, filed another suit in OS number 364. Now, my lord, in RSA, they have received money. They have received money.
You file your objections. We are not granting interim order. It's only for interim order. Interim order we are refusing. Notice I place body will dispose them.
All the records, my lord, I have kept ready. Because yenagide, now, my lord, the land, my lord, is already developed, being developed. Now, day today, my lord, every day they are coming and opposing before the authorities. The writ petition is number is furnished. Convert ಮಾಡಿದೀವಿ, investment ಮಾಡಿದೀವಿ.
Today we'll require to spend some time on this and then pass orders. At least an hour ಆಗತ್ತೆ ಇದಕ್ಕೆ. Time ಇಲ್ಲ ಇವತ್ತು. Issue notice. ನೀವೇ ಬೇರೆ ಯಾರಿಗಾರು notice ತಗೊಂಡ್ರಾ?
Lord, 13 and 14, my lord, I'll.
ಅದು ಬಿಟ್ಟು?
Only 2 persons. ಈಗ ಇರೋದು ಮಿಕ್ಕಿದವರೆಲ್ಲ ಕಾಂಪ್ರಮೈಸ್ ಪೆಟಿಷನ್ ಇದ್ದವರು ಸೈನ್ ಮಾಡಿದವರು. They are also supporting us.
But you appear for them.
My lord, I have to get instruction. Only 13, 14, only 13, 14, my lord, I have instructions.
Issue notice to respond number 1 to 12. Then AGA accepts notice for respond number 15. Counsel for the petitioner, respondent 13 and 14 is granted a week's time to file his objections.
Yes.
By placing on record all the proceedings before the Honorable High Court of Madras as also before this court. Relist on 14th March.
Please.
Notice returnable by 28th March.
July.
Emergent.
Well, case party.
In this case, my lords, I have filed my affidavit, my lords, as ordered by this honorable court, my lords.
My lords, may kindly peruse the interim order dated 10/1/2024 months. Pursuant to the interim order, my friend has filed the report. Inspection report. Though the report, my lord, the inspection is not in terms of condition number, serial number 5 mentioned in my lord's order, order dated 10/1/2024.
The report.
Yeah, report. Adondu adjoining property on the measure ಮಾಡಬೇಕಿತ್ತು. Report is filed on 31/1/2025 notes.
Affidavit ಅದು.
Affidavit ಹಾಕಿದ್ದಾರೆ. Along with the mod sketch one. And page 4 mod is the spot inspection report. dated 24/1/2025.
There's violation.
Please, there is violations. In fact, in the petition itself, I admitted that without obtaining the permission, my client has constructed the first and second floor building. In fact, in the entire layout, the municipal council has not issued the any permission in favor of anybody else. I'm not on that point, but still, let them examine whether there is any last case. My lords also please to orally instruct to get the instructions. Whether there is any possibility.
What is J&L that you have challenged?
But the final order issued by way of amendment, my lords may kindly see the amendment application which came to be allowed, and I have filed the amended petition also.
Yes.
Annexure Q page 10 is the official memorandum dated 4/1/2025. Initially, my lord, in the original writ petition, I had questioned the further demolition which was sought to be made on behalf of the municipal council. But during pendency of the writ petition, this official memorandum dated 4/1/2025 came to be passed by the authorities, asking me to remove the first and second floor of the constructions made by the petitioner without obtaining the permission. My lords were pleased to grant the interim order. Meanwhile, my lords,
To verify. Verify ಆಯ್ತು.
ಆಗಿದೆ.
ಇನ್ನೇನು ಉಳಿತು?
Only advantage statement made by the municipal council is that there is no encroachment as such made by my client. In fact, on the ground that I have encroached certain portion of the road, earlier demolition was also made, which is also made part of the record.
So if they apply for a, Mr. Kulkarni,
Yes,
if they apply for a plan, second floor sanction ಮಾಡಬಹುದಾ?
Lords, as he has constructed the ground floor, if it falls within the purview of the this municipal councils act, we will grant, my lords.
Will permit him to file a modified plan.
Please.
If the modified plan can be sanctioned as per what is constructed, you sanction it. If in terms of bylaws.
Please.
If it is not capable of being sanctioned as per what they have built, sanction it as per the bylaws, and whatever is extra, you demolish it.
187A provides for regularization of the construction.
Regularization like
That's my lords.
not regularization. This is you apply for a plan sanction.
Please.
New ground floor plan sanction.
Ground floor I have obtained the plan
ಅಲ್ಲೂ ಸ್ವಲ್ಪ ಎಕ್ಸಸ್ ಕಟ್ಟಿದೀರಾ?
10 square meter ಅಂತ ಹೇಳಿದೆ.
My submission, my lords, it is my petition on my petition, my lords, that endorsement has issued earlier petition. Totally, my lords, I am not, if I am not wrong, totally, my lords, corporation issued endorsement. Only to, my lords, the accommodate, my lords, the petition. I am not disputing, my lords.
But in fact, I can understand my friend's anxiety for the reason that, but I'm not supposed to make it
from their own document saying that, my lords.
Nim problem ಏನು ಹೇಳಿ?
My Millers, I'm not the Millers a person to say that Millers construction is Millers within the purview of their measurement or not. Only my Millers the anxiety which Millers have approached this Honorable Court. This Honorable Court has passed an order saying that Miller, there is a road, 9-meter road, from the southern side of the Miller's plot number 20, the petitioner plot, that has to be Miller rectified. The representation was made, that more than Miller 6 representation made. By the Millers, they have not taken any.
Encroachment ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ ನಿಮ್ಮ
ಇಲ್ಲ.
Para 8 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. Para 8 of the
before that, Millers, before that, the endorsement which is issued may kindly be let's peruse that by way of amendment they sought on Millers 8/1
Para 8 of the affidavit.
Sketch of the property.
Para 8 of the affidavit.
Where the sketch of the property?
ಅಲ್ಲ ಓನ್ಲಿ ಮಿಲಾಟ್ಸ್ ಬಿಲ್ಡಿಂಗ್ ಫಂಕ್ಷನ್
ಮಾಡಿ ಮೆಜರ್ಮೆಂಟ್ ಮಾಡಿ ಎಲ್ಲ ಸ್ಕೆಚ್ ಅಲ್ಲಿ
ಇಲ್ಲ ಮಾಡಲಿಲ್ಲ.
As I have been furnished this each document, my lords, in paragraph number 8, my lords,
how do we accept para 8 without a sketch being shown?
Sorry.
How do we accept para 8 without you enclosing a sketch?
By way of sketch. I agree, my lords, but as per the spot inspection, my lords, whatever the extra he has constructed, unauthorized construction, he has constructed in his.
That we'll deal with.
Please.
But what about the encroachment?
My lord.
Or they are not bothered about, they are bothered
No,
about.
I am
the
not totally, my
encroachment.
lords, disputing.
He is not coming in the way of the construction, but of course, now that it's come up before this court, we'll have to deal with it.
For
Encroachment
2
ಒಂದು
minutes, my lords,
problem
if
ಇರೋದು.
my lords may
ಅದೇ
permit.
ಮಾಡಿಲ್ಲ ನೀವು.
2 minutes, if lords may permit, I will demonstrate from their own document saying that, my lords, there is no road ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. There is a road ಅಂತ ಹೇಳ್ತೀನಿ. ಒಂದು 2 ನಿಮಿಷ, my lords may kindly peruse the, my lords, para number 2 of their memorandum of writ petition. They have admitted there is a road. On the contrary, they say that, my lords, the owner land, the layout owner has deviated the entire plan to the extent of 5 meters.
Road ಎಲ್ಲಿದೆ? Southern side, ah?
ಹೌದು, southern side, please. May I, my lords, pass on, my lords, some documents, my lords, his own documents, saying that, my lords, there is a road.
Even as per the plan sanction, southern side.
I am not disputing the existence of the road. I am only saying that I have not encroached it. That's
Let
what
them,
the
let them,
commissioner
I'm
report
not,
says.
I'm, day one, my lords, I have told, whatever that, my lords, is grievance, that, my lords, without, let's, giving the opportunity, this endorsement and issue. Then let them give an endorsement. I'm not disputing, but only to the secure the, my lords, ends of justice. Earlier, there was a writ petition, which I have filed. There is an order. The total, my lords, the entire 6 representations kept pending for consideration. Only to the 9-meter road has to be, my lords, shown.
Encroachment on the road, we'll get it removed.
And there is a clear, my lords, judgment of the, my lords, Honorable Supreme Court, also, my lords, the division bench of the Madras High Court. Wherever, I'm not, my lords, wherever there is a encroachment on the, my lords, private property, they have to be given opportunity to, my lords, regularize. Otherwise, my lords, if in case, my lords, public property has been encroached, there is no, my lords, mercy. They have to, my lords, remove. In that case, my lords, the spot inspection report may kindly be seen. ಅಲ್ಲದೆ ಸದರಿ ಪ್ರಕರಣದ ಅರ್ಜಿದಾರರು that is, my lords, no, no. ಯಾವುದೇ ಜಾಗವನ್ನು ಅತಿಕ್ರಮಣ ಮಾಡಿದ್ದು ಕಂಡು ಬಂದಿದೆ.
Sketch ಅಲ್ಲಿ.
Sketch I have not produced.
Produce it tomorrow.
But in fact, page 35.
One thing, my lords, I had to, my lords, demonstrate. That's on the day of, my lords, inspection, the commissioner, my lords, intimated me also, my lords, my parties are present. We have, my lords, produced that documents are produced. Plan which is, my lords, for the construction permission taken, even a petitioner has taken on the basis of that plan. Plan I have produced. That plan shows that, my lords, 9-meter road is there. He has not accepted.
9-meter road, Mr. Patil is accepting this.
Please.
In fact, my lords, my kindly page 35 for
whether
a
there is
moment.
encroachment of the 9-meter road
Yes.
or not. ಇವಾಗ ಅವ್ರು ಕಟ್ಟಿರೋದೂನು ಸರಿಯಾಗಿ
ಅಲ್ಲ ಮತ್ತೊಂದು ಏನ್ ಹೇಳ್ತಾರೆ ಅಲ್ಲಲ್ಲ ಹಂಗೆಲ್ಲ ದೇ ಹ್ಯಾವ್ ಕಮಿಷನರ್ ಥ್ರೆಟನ್ ಪಿಟಿಷನರ್ ಸೇಯಿಂಗ್ ದಟ್ ಇಲ್ಲ ಈ ಪ್ಲಾನ್ ಅಲ್ಲ ದೇರ್ ಇಸ್ ಅನದರ್ ಪ್ಲಾನ್ ಯು ಆರ್ ಆಲ್ಸೋ ಆನ್ ಪಾರ್ಕ್ ಗಾರ್ಡನ್ ಲ್ಯಾಂಡ್ ಅಂಡ್ ಆಲ್ಸೋ ರೋಡ್ ನಿಮ್ದು ಮನೆನು ಡೆಮಾಲಿಷ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ he has threatened the petitioners also. ಅದಕ್ಕೆ ನಾನು I can understand that he has.
It is fine. But ಇದೆಲ್ಲ ನೇಬರ್ ಜಗಳ.
Neighbor, they have also constructed.
ಫ್ಯಾಮಿಲಿ ಜಗಳದಲ್ಲೇ ಇಲ್ಲಿಗೆ ಬರೋದು ವೈಲೇಷನ್ ಎಸ್ಪೆಷಲಿ ನೇಬರ್ಸ್.
Yes.
ಆ ನೇಬರ್ ಜಗಳದಲ್ಲಿ they forget that their own, they also are in.
In fact, they have also constructed mud by violating the building bylaws and the other.
Both of
No, that is wrong. That's not. If at all so, Millers, I will produce, Millers, my form number 3 has been issued by the CMC only. No, I can understand. I will undertake. I can understand. I will undertake. Tomorrow, Millers, if at all they produce the plan, except Millers, I have produced it. But other than this plan, I will understand. There is no plan at all. They are admitted.
Seeks for and is granted a day's time to place on record the sketch prepared during the inspection. Released tomorrow, 28.
May I request, I'm told that there are 2 plans. One is by the Dharwad Town Planning Authority and other by the Municipal Council. Let them produce both the plans so that it will be easy for the
layout plan section.
Layout plan, there is some conflict between 2 plans. Let them produce both the plans.
Plan sanction granted in respect of the subject property.
Please.
13.
But interim order is.
Interim order earlier granted is extended.
In a preliminary, let's say, in preliminary. I can be group with the preliminary urgency and takidre. Please.
Petitioner challenging the order passed by the Assistant Commissioner and Deputy Commissioner. My lord. The fourth respondent claiming to be a daughter of my lord, one Damova. Kindly, my lord, I will draw your lordship attention towards.
There is no interim prayer.
ಇಲ್ಲ ಕೇಳಿಲ್ಲ ನಾನು ಕೇಳೋದಿಲ್ಲ.
AG accepts notice for respond number 1, 2, 3, issue notice to respond number 4, reasonable by 22nd April.
Please.
14, dear Lord Khan,
Yes, my lords.
My lord,
I have sought
on the
instructions.
last date of hearing, your lordship had directed
The names.
to ascertain whether there is an application given by the ward's mother had given application wherein it has been written as Aris, my lord. First sentence ಅಲ್ಲಿ ಬರುತ್ತೆ ಸುಮ್ನೆ. In fact, the application subsequent ಕೊಟ್ಟಿದ್ದು ಮೊಹಮ್ಮದ್ ಶಾಯಿಜ್ ಅಂತ ಹೇಳಿ ಕೇಳಿದ್ದಾರೆ.
The application has been given, my lords, but we have given endorsement stating that to get the court decree, my lords.
ಇಲ್ಲಿ ಎಲ್ಲಿ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಾ ಇದೆ ಅಂತ ತಿಳ್ಕೊಳಕ್ಕೆ.
Please.
ಅಲ್ಲ annexure F, my lord, page number 18 ಅಲ್ಲಿ both the names are appearing. October 2024 dated.
ಇದು ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಏನಂತ ಕೊಟ್ಟಿದ್ದಾರೆ?
ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಏನಂತ ಕೊಟ್ಟಿದ್ದಾರೆ?
ಆರಿಸ್ ಅಂತೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆರಿಸ್ ಅಂತೆ ಕೊಟ್ಟಿದ್ದಾರೆ. There after it was brought to the notice of the concerned authority with a request to rectify it as Shaiz. ಅದು annexure D page number 16 ಅಲ್ಲಿ ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ. ಫಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ ಮೊಹಮ್ಮದ್ ಆರಿಸ್ ಮುಲ್ಲಾ, ನೇಮ್ ಆಫ್ ದ ಚೈಲ್ಡ್.
Your para 7 is not correct. You had given as Aris only.
ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅದು. I have to admit it, my lord. I have to admit it.
ನಿಮ್ಮ allegations ಎಲ್ಲ wrong ಆಗಿದೆ.
ಅಲ್ಲ ಅದು ತಪ್ಪಾಗುತ್ತೆ ಸ್ವಾಮಿ.
Why are you alleging against them?
ಅಲ್ಲ only request to the request before this court is that as far as seeking a court decree is concerned, let them consider my representation and pass.
That will do.
That
ಯಾಕೆ allegation ಯಾಕೆ ಮಾಡಬೇಕು? ಎಲ್ಲರೂ ಅವ್ರ ಮೇಲೆ ತಪ್ಪಿದ್ದಾಗ ಮಾಡಿ ಅವ್ರು ಕೇಳಿ ಸಾಕಾಗೋಗಿದೆ. ಕರೆಕ್ಟ್ ಆಗಿ ಇದ್ದಾಗ್ಲೂ ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ ಬೇಜಾರಾಗತ್ತೆ. ಅಲ್ಲ ಮಿಸ್ಟರ್ ಕುಲಕರ್ಣಿ?
Please. As my lords.
The petitioner is before this court seeking for the following reliefs. ಇದು ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್ ಹಾಕಿರೋದು.
ಈಗ ರಿಪ್ರೆಸೆಂಟೆಡ್ ಬೈ ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್, ಫಾದರ್ ಥ್ರೂ ಇಸ್ GP ಹೋಲ್ಡರ್ ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್.
ಅಮ್ಮ ಅಪ್ಪ ಹೆಸರಿಟ್ಟಿದ್ದು ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್.
ಅಲ್ಲ ಅದೇನಾಗಿದೆ ಅಂದ್ರೆ ಟು ಟೆಲ್ ದ ಬ್ಯಾಕ್ ಗ್ರೌಂಡ್, ಮದರ್ ಕೊಟ್ಟದ ಅಪ್ಲಿಕೇಶನ್ ಫಾದರ್ ವಾಸ್ ನಾಟ್ ಹ್ಯಾಪಿ ವಿತ್ ಇಟ್.
ಅದೇ
ಸ್ವಲ್ಪ ಅದಾಗಿ ದೇರ್ ಆಫ್ಟರ್
ಡಿಸ್ಪ್ಯೂಟ್ as to what to name the child.
ಅದಕ್ಕೆ ಮತ್ತೆ ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್ ವಾಸ್ ಕಂಪೆಲ್ಡ್ ಟು ಗಿವ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್.
The petitioner is a minor represented by his maternal grandfather. ಬಟ್ ಇವಾಗ ಬಾಕಿ ಅವ್ರದೆಲ್ಲ ಅಫಿಡವಿಟ್ ಕೊಡಿ, ಅವ್ರಿಗೆ ಬೇಕಾಗತ್ತೆ. ಮತ್ತೆ ಇನ್ನೊಬ್ಬರು ಬಂದ್ಬಿಟ್ಟಿಲ್ಲ ಹೆಸರು ಚೇಂಜ್ ಮಾಡಿ
ಅದು ಕಂಡೀಷನ್ ಹಾಕಿ ಮಾಡ್ತಾರೆ. ಯಾಕಂದ್ರೆ ರೂಲ್ 11 ರಲ್ಲಿ ಇನ್ ದ ಇವೆಂಟ್ ಆಫ್ ದ ರಿಜಿಸ್ಟರ್ ಫೈಂಡ್ಸ್ ದಟ್ ದೇರ್ ಇಸ್ ಎನಿ ಫಾಲ್ಸ್ಹುಡ್ ಇದ್ರೆ ಇದಾಗತ್ತೆ.
ಮತ್ತೆ ಅಲ್ಲ, ಮದರ್ಸ್ ಅಫಿಡವಿಟ್, ಫಾದರ್ಸ್ ಅಫಿಡವಿಟ್, ಪೆಟರ್ನಲ್ ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್ಸ್,
ಅದು ಆಲ್ ದ 3 will be given.
Mother and maternal grandmother.
My lords, one small submission, my lords. In such cases, my lords, in my daughter's case only, my lords, I had to file a declaration suit and get her name rectified, and thereafter I submitted application, my lords.
ಬೇಡ ಅಂತ ಅದು. We can avoid all that. Why should there be a suit to be filed for that?
That ground may be.
As long as you are protected with affidavits and everything is on record.
That ground may be observed.
ಅಲ್ಲ ಸೆಕ್ಷನ್ 15 ಅಲ್ಲಿ ಕರೆಕ್ಷನ್ ಸ್ಕೋಪ್ ಇದೆ ಅಂತ ಹೇಳಿ. ಪ್ಲೀಸ್
held it, but ನಾಳೆ
ಅಲ್ಲ ಅಲ್ಲ all preventive steps will be taken, my lord, so that there shall be no second round of.
Then there will be second, third, fourth. Represented by the maternal grandfather seeking for correction of the name of the petitioner as entered in the birth certificate issued by the respondent. The submission of Shri Ladkan Learned Counsel for the petitioner is that when the details of the child were furnished through the hospital, mistakenly the name of the child had been shown as Mohammed Ariz, correct spelling note for you, Mohammed Ariz, when in fact the name agreed upon between all the family members was Mohammed Shahiz Mullah. In view of the said mistake, the certificate, birth certificate has now been issued as Mohammed Ariz Mullah. And it is in that background that the petitioners had sought for correction of the name. In that background that the parents and the grandparents had sought for correction of the name of the minor child, which came to be rejected by respondents on the ground that once a name has been entered into in the records and a certificate issued, no such rectification can be carried out without a decree being obtained from a competent court. It is challenging same. The petitioner is before this court. This court has dealt with a similar situation, vide judgment in dated 1st September 2023 in WP number 18413 of 2023, wherein the name of the child was given wrongly by the parents.
No name was there, my lord, in that case. My lord.
No name. ಮತ್ತೆ ಇನ್ನೊಂದು ತಗೊಳ್ಬೇಕಾಯ್ತು ನೀವು.
ಇಲ್ಲ, no name, thereafter it was directed to incorporated. Parents approached this court.
Where the name of the baby was not mentioned. And subsequently, when the birth certificate was sought for with the name of the child being mentioned, the authorities had refused to grant such a certificate. ಮೊನ್ನೆ ಇನ್ನೊಂದು ಜಡ್ಜ್ಮೆಂಟ್, ಸಂಜಯ್ ಗೌಡ್ರದ್ದು ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಬಂದಿದೆ. This court, while it's order dated, a coordinate bench of this court, while order dated 6th February 2025, in WP number 6370 of 2024, has dealt with the manner and methodology of change of the name or correction as regards a certificate, birth certificate issued. The coordinate bench has held that it's a common practice for the name of the person to be changed due to various factors. And a change in name ought to result in a birth certificate being issued with such changed name. In that view of the matter, the submission made by Shri D.L. Latkan, counsel for the petitioner, today dears the contentions taken up in the petition, is that the name of the child was wrongly mentioned as Mohammed Ariz when it had to be shown as Mohammed Shaiz, and as such an application had been filed by the grandfather. He submits that affidavits of the immediate family, that is the mother, father, maternal grandfather, maternal grandmother, paternal grandfather and paternal grandmother would also be submitted to support that, to place on record that the entire family is agreeable.
If they are alive, but ಯಾರಾದ್ರೂ
Please, that they are agreeable for the said change of name. In that view of the matter, in view of the judgment of the coordinate bench of this court in Master Adrit Bhatt's case Supra, it would be required for the respondent corporation and the register of births and deaths to give effect to such change in the name as deemed fit by all the family members. Of course, once a new certificate is issued, the old certificate would have to be cancelled and necessary endorsement made on the old certificate. And if even the QR code is scanned and the certificate is accessed, on such access, it should be clearly indicated that the old certificate has been cancelled and a new certificate with the number of the certificate be mentioned. So there are no other future issues which are caused in this in relation thereto. As such, I pass the following order. Writ petition is allowed. A mandamus is issued to the respondent, directing the respondent to consider the application filed by the maternal grandfather of the petitioner, as also the affidavits to be filed by the other near relatives as indicated supra, and thereafter issue a rectified birth certificate by cancelling the birth certificate already issued as per the observation here and above made within a period of 30 days from the date of receipt of a copy of this order.
Please. 15, Prithvi case.
Regarding granting of E-class land.
I'll lean on the line, Admin. The contention of the corporation, register of births and deaths, that a declaratory relief had to be obtained from a court of law, to my considered opinion, would not be a viable alternative, inasmuch as for the mere change of name, parties would have to be relegated to a court of law when there is in fact no dispute.
Please.
Thus, apart from the parties being forced to approach a court of law, such kind of matters would also result in unnecessary litigation, which could be well avoided by the corporation by taking into consideration the genuine and bona fide request made by all concerned for change of name as afore indicated.
Please.
Yes.
15.
Yes, my lords.
The petitioner here, my lords, the petitioner here, my lords, is regarding E-class land, my lords, the matter. Petitioner, my
Impleading
lords,
application.
please, I have filed objections, my lords. I will narrate the facts, my lords, so
So
that.
are you impleading application?
Yes, my lords. We are the allottees, my lords, allottees of the land who have been allotted land by the order of the Assistant Commissioner passed in the year 2007, my lords. My lords, there are totally 48 allottees who have been allotted land. So the Assistant Commissioner had allotted this land to the deserving scheduled caste and scheduled tribe people and the landless poor people, my lords.
On what basis
Since
were
then,
you?
they are in possession of the land, my lords, and their names have been mutated on records, my lords.
You claim that the property belongs to you.
Please, I will submit, my lords, on that. My lords, may I request Annexure H, my lords, may I request. Annexure H, my lords, page 110 on the impleading application file. This is the order passed by the Assistant Commissioner. My lords, in that, my lords, reference number first, my lords, is the order, my lords, 25/7/77, which we have challenged before this honorable court and succeeded and pursuant to remand, my lords. In that, my lords, reference number 5, my lords, may I request, my lords, Hiriya Upavadhikarala Belagavi Ravara Patra 4/11/2006. That is recommendation sent by the, my lords, Assistant Commissioner to the Deputy Commissioner, my lords. I have produced that document, my lords, along with my objection. My lords, I have filed objection, my lords, to the impleading, my lords. A document, my lords, page 8, my lords, may I request.
There are 48 people to whom it's been allotted.
That I will show the recommendation, my lords, so that my lordship will
Have to
get
consider
clarity.
it, and the government will have to file its objections.
No, my lords, the
No,
EAC has given an opinion that the land is not fit for agriculture and subject to outcome of this petition pending before this honorable court. It is up to the Deputy Commissioner to grant the order.
This order was 8/6/2007. This petition you have filed in 2025. It can't be subject to that.
As on date of passing of this order, a writ petition was pending before this order.
That writ petition.
That writ petition was pending, my lords. And
Your writ petition.
my lords,
Writ petition number?
writ petition number, my lords, Annexure F, page 96.
Annexure F.
Please, my lords.
Page 96.
Page
96. 2015.
That
Have been renumbered.
renumber.
Initially it was CP ಅಂತ ಇತ್ತು ಅದು ಕನ್ವರ್ಟ್ ಆಗಿ ಆಮೇಲೆ ರಿಟ್ ಪಿಟಿಷನ್ ಅಂತ ಆಗಿದೆ.
So that was pending as
was
on
pending.
2007.
And my lords, I read only one line, lords, along with my objection, that a recommendation sent by the AC to the deputy commissioner for approval, my lords, along with my objection, my lords.
Order challenge 77 order. Yes.
ಸ್ವಲ್ಪ objection ನೋಡ್ಬಿಟ್ಟೆ along with my objection, my lords.
ಏನಾಯ್ತು ಈ ಆರ್ಡರ್ ಅಲ್ಲಿ?
ಅದನ್ನ ಹೇಳ್ತೀನಿ.
Writ petition allowed, impugned order, so and so stands
Direction.
quashed. Remanded to the land tribunal to pass appropriate order in accordance with law after providing an opportunity within a period of 4 months.
Please.
So this order of 2007
Please.
would also automatically.
That is behind the back of the petitioner.
Yes.
My lords, in that, my lords, the AC states that, my lords, may I request I permitted to read, my lords, along with my objection, my lords, to IA, I have filed, my lords. Annexure M, page 8, my lords.
Yes.
My lords, below 10 line, my lords, ಈಗ ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಭೂನ್ಯಾಯ ಮಂಡಳಿಯಿಂದ ಪ್ರಕರಣ ಪುನಃ ವಿಚಾರ ಮಾಡಲು ಅವಕಾಶ ಇರುವುದಿಲ್ಲ. ಯಾಕೆಂದರೆ ಆದೇಶವನ್ನು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ರದ್ದುಪಡಿಸಿರುವುದಿಲ್ಲ. ಅಲ್ಲದೆ ಸದರಿ RALR ಪ್ರಕರಣ ಈ ಕಾರ್ಯಾಲಯದಲ್ಲಿ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿ ಬೆಳಗಾವಿ ಅವರ ಕಾರ್ಯಾಲಯ ಸ್ವೀಕೃತವಾಗಿರುವುದಿಲ್ಲ. ಪ್ರಕರಣಗಳು ಸ್ವಯಂ ಇರುತ್ತವೆ. ಸದರಿ ಪ್ರಕರಣಗಳನ್ನು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಿ ಜಿಲ್ಲಾ ಅಪೀಲ್ ಪ್ರಾಧಿಕಾರ ಬೆಳಗಾವಿರವರ ನ್ಯಾಯಾಲಯಕ್ಕೆ ರಿಮಾಂಡ್ ಆದ ಆದೇಶ ರದ್ದುಪಡಿಸಿ ಪ್ರಕರಣಗಳನ್ನು ಭೂನ್ಯಾಯ ಮಂಡಳಿ ರಿಮಾಂಡ್ ಮಾಡಬೇಕಾಗುತ್ತದೆ. ಈ ಬಗ್ಗೆ ಈ ಹಂತದಲ್ಲಿ ಮಂಜೂರಾತಿ ಕುರಿತು ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸುವುದು ಸೂಕ್ತವೆನಿಸುವುದಿಲ್ಲ. ಕಾರಣ ಈ ಬಗ್ಗೆ ಆದೇಶಕ್ಕಾಗಿ ಕೋರಿದೆ. He himself says that, my lords, there is a matter pending before this honorable court. So, my lords, granting of land, my lords, to the, my lords, does not arise.
Date of this?
Date 4/11, 5/11, my lords.
5/11 which year?
2006, my lords. In the next page, my lords, another document I have produced. Other next page ಅಲ್ಲಿ
2006 ಅಂತ ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತೆ?
ಅದು next page ಅಲ್ಲಿ ಬರ್ದಿದೆ ನೋಡಿ. Page 9 ಅಲ್ಲಿ.
This is
Page
the
9.
recommendation.
Recommendation.
First passed on 8/6/2007.
But in that, my lords, ಉಲ್ಲೇಖ 5 ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಅನುಮೋದನೆ ಪತ್ರ 5/11 ಅಂತಿದೆ. There is no document to show that, my lords, the AC, my lords, has approved to the deputy commissioner.
That is why we'll have to hear the government as to what their stand is ಅಂತ ಹೇಳ್ತಾ ಇರೋದು. Until they file their stand, right?
Because
what is your stand?
My stand is, my lord, we have to ascertain insofar as this, as they said that, whether deputy commissioner has authorized the assistant commissioner for granting of. My lord, as per section 26.
The assistant commissioner says don't do it.
Alla
There is a
ಬಗ್ಗೆ
writ
order
petition
ಮಾಡಿರೋದು
pending, Annexure H is issued.
This order
You
is
have
also-
created 48 people, you are misleading.
This order is also passed by the assistant commissioner, referring all this. He has passed this order, impugned order.
7 na.
Annexure H.
Annexure H assistant commissioner.
Assistant commissioner order. He himself, my lords, recommends. And there, my lords,
That is referring all this, he himself.
Now, what have you created this 48 people, what will they do? If you hold it in his favor, this 48 people will
be on.
ಅವ್ರಿಗೇನ್ ಮಾಡ್ತೀರಾ ಆಮೇಲೆ? The assistant commissioner says don't grant, he only grants. ಅವನು ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಇಲ್ಲಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಇದೆ. Place your stand clearly.
Yes.
And AGA, impleading application had been filed by Roman number ಎಲ್ಲ
48 people, and my lords.
Roman number ಹಾಕಿದ್ದೀರಾ by 48 persons claiming that they have been granted portion of the property subject matter of the above petition. Learned counsel for the petitioner submits that the grant was during the pendency of writ petition in WP number
103302 of 2015.
103302 of 2015, which was earlier numbered as CP.
Lord CP 505 of 2012, my lords.
505 of 2012. But the order is
LNR ಅಂತ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದು.
LNDR.
LNTR. ಆಮೇಲೆ CP ಆಯ್ತು.
LNDR number ಏನು?
LNTR number, my lords.
Earlier LNDR.
LNTR number, my lords, is 161 of 86.
LNDR ಏನ ಏನಾದ್ರು ಇದೆ?
Please, LA LR number. LA LR number. 161 of 86
161 of 86.
and 277 of 86.
And 277 of 86, when the order dated 25/7/2077 had been challenged. This court, wide its order dated 3rd January 2024 in WP in the said matter, allowed the writ petition quashing the impugned order dated 25/7/1977. Thus, his submission is that when the said order has been quashed, the question, any proceedings or action taken in relation thereto stand negated insofar as the claim of the grant by the impeding applicants. He submits that the Assistant Commissioner had on 5/11/2006 opined that no such grant could be made in view of the pendency of the writ petition before this court, despite which, wide order dated 8/6/2007 at Annexure H, a grant has been made to the impeding applicants. The manner in which the respondents have acted has resulted in a peculiar situation, inasmuch as when the matter was pending for consideration before this court, the respondents ought not to have taken any steps, as rightly opined by the Assistant Commissioner on the first instance. However, shockingly, the very same Assistant Commissioner, wide order dated 8/6/2007, has granted portion of the land to 48 people in furtherance of the aforesaid order dated 25/7/1977, which has now been quashed by this court, which subsequently has been quashed by this court. Thus, it would be for the state to make it stand clear as regards what is to be done with regard to the grant made to the 48 persons, more so if any alternate land would be made available to them in view of the earlier order dated 25/7/1977 having been quashed. No allotment or grant could have been made in their favor subsequently.
My lords.
Subsequently, would have been made in their favor.
My lords.
Relist on yavat ಆಗ್ತೀರಾ?
After 10 days.
The AGS seeks fund is granted 2 weeks for doing the needful. The statement of objection along with the necessary documents to be filed on or before 21st, relist on 27th March.
My lords, I request for further hearing because already my lord stay to if
Bangalore ಹೋಗಿ ಮತ್ತೆ problem.
if they say as opinion, then my lords, it will be humbly request my lords. I'll take a chance, my lords. Otherwise, if they don't file, my lords.
ಬೆಂಗಳೂರಿಗೆ ಬರ್ಬೇಕು ನೀವು.
ಬರ್ತೀನಿ.
BCL ತಗೊಳಲ್ಲ.
ಅಲ್ಲ ಬರ್ತೀನಿ. ಅಲ್ಲ, if they produce that.
For further hearing.
Please.
16, Irangouda Kapoor.
My lords, on the previous date of hearing, my lords has directed to produce a document to show whether the service of notice is in compliance of order 28. That is, whether the notice is served to
Commanding
the
officer.
commanding officer. I may be permitted to serve the order sheet. Order sheet at page number, at the last page, it is been mentioned that countersigned commanding SK Jha, but this is not the notice in the suit. It is a notice in the EP proceedings, my lords.
ಈ ಸೂಟಲ್ಲಿ
Suit nalli it was
ಹೇಳ್ತಾ ಸೂಟಲ್ಲಿ ನಂಗೆ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
suit nalli it is on order sheet is mentioned, my lords, at page number 2 dated 23/1/23.
ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಅದೇ ನಂಗೆ EPL ಗೊತ್ತಾಯ್ತು ಅದಕ್ಕೆ ಮುಂಚೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
My lords,
ಸರ್ವಿಸ್ ಆಯ್ತಾ?
21/1/23.
21/1/23.
23/1/23. Defendant called out.
Duly served ಆಗಲ್ಲಪ್ಪ.
Defendant is
Unless
placed
it has been
expert.
served. Because there's a particular way of service on a army person.
Army person as per order 28 rule 3.
Other than that, it cannot be accepted.
My lords, now the question is before the court is in the EP proceedings, they have the matter is stayed as per in compliance of order 21 rule 8. They tell that there is a simultaneous 2 proceedings. That can't be termed as a 2 proceedings. Suit filed, suit decreed, EP filed, EP pending in the during the pendency of the EP proceedings. They have filed the application under order
21 rule 29.
21 rule 29. So miscellaneous can't be termed as the parallel proceedings or the
It's not a miscellaneous. When you have not effected the service properly, where's the question of miscellaneous? In EPL, stay madi, because then you will file the miscellaneous later. You can't go ahead with the execution and say miscellaneous akiyanta.
EPLE, they have taken the contention that there is a 2 proceedings pending. I may be permitted to go to the order, impinge order. Ali paranam.
And they said ex parte by civil miscellaneous 1 of 24.
There should be a simultaneous proceedings anta heli. Order 20 and rule 29, they have taken the shelter of order 21 rule 29.
Correct. Because if the service is not effected properly, civil miscellaneous will succeed.
Civil miscellaneous, okay, that is the proceedings is pending. In the EP proceedings, they file the application as per order 21 rule 29.
Your decree will go. So that is why rightly it's been stayed.
But in order 21 rule 29, there should be 2 proceedings.
In 2 proceedings.
Order 21 rule 29.
Which 2 proceedings are you speaking of?
Simultaneous 2 proceedings anta ಹೇಳ್ತಾರೆ. Stay of execution, order 21 rule 29.
Yes.
Stay of execution pending suit between decree holder and judgment debtor, where a suit is pending in a court against the holder of the decree of such court, or a decree which is being executed by such court, or part of on the part of the person against whom the decree was passed. The court may, on such terms of the security or otherwise, even though if they want to decree, also the security should have been ordered. Security for further, provided that if the decree is one for the payment of money, the court shall, if it grants stay.
Understand this 21 rule 28 ಎಲ್ಲ ಮನೆ CPC amendment ಮಾಡಿದಾಗ ನಮಗೂ ಸರಿಯಾಗಿ ಗೊತ್ತಾಗಿದೆ, because not a regular matter. How to serve it on a overseas sailor, how to serve it on this, how to serve it on a diplomat, ಅವೆಲ್ಲ ನಾವು ನೋಡದೇ ಇಲ್ಲ.
That question, my lords, my submission, respect submission, that question can be taken into consideration in civil proceedings. Now,
yes, now that the CMS is pending and this kind of a issue has been raised.
Whether civil miscellaneous is considered to be a proceedings.
It is now if it
as
is
per
allowed.
order 21 rule 9.
That is why we asked you, if you show us that he has been served, then we would not intervene. But if it is not been served, EPL correct ಆಗಿ ಮಾಡಿದೀರಾ ಸರ್ವಿಸ್ ಕಮಾಂಡಿಂಗ್ ಆಫೀಸರ್ ಇಂದ, ಸೂಟ್ ಅಲ್ಲಿ ಮಾಡಿಲ್ಲ. EPL ನಿಮ್ಗೆ ದುಡ್ಡು ಬರಬೇಕು ಅಂತ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿದೀರಾ, ಹಂಗೆ ಹೇಳ್ಬೇಕು.
Notice may be
ಸೂಟ್ ಅಲ್ಲಿ ಯಾಕೆ ಮಾಡಲಿಲ್ಲ?
Notice may be issued.
Notice ಅಲ್ಲ, will dismiss this. There's nothing. There is proper order. Petitioner is before this court seeking for the following.
I will be have some matter.
Petitioner is before this court seeking for the following relief. The petitioner was the plaintiff in OS number 570 of 2022 filed for recovery of certain amount of money. Notice having been served on the notice claimed to have been served on the respondent, who was the defendant therein. Taking note of the absence of the defendant, he was placed ex parte, matter proceeded with, and the ex parte decree came to be passed. Subsequent thereto, the petitioner filed execution proceedings in EP number 17 of 2023, where an attachment order was sought for of the salary of the respondent in the name of the salary, to be issued in the name of the salary drawing officer. It is claiming that only then the judgment debtor came to know about the decree. The judgment debtor filed an application order 21 rule 29 for staying of the proceedings by contending that the judgment debtor had filed a proceeding in miscellaneous number 1 of 2024 for recall of the judgment, ex parte judgment and decree. The execution court allowed the said application while its order dated, by the impugned order dated 9 January 2025, it's challenging the same, the petitioner is before this court. When the matter was taken up earlier, on an earlier occasion, the counsel for the petitioner was called upon to inquire and make a submission as to whether service of notice has been effected in terms of Rule 28 of Order 5 of the CPC. Today, a memo with the order sheet has been filed as regards the service of notice in the execution proceedings through the commanding officer However, insofar as the service of notice in the suit, the order sheet having been produced, a perusal of the order sheet would indicate that that summons have been issued on 17/12/2022 by RPAD. On 11/1/2023, awaiting the RPAD, the matter was adjourned to 23/1/23. On 23/1/2023, the trial court held that the defendant is deemed to be duly served. He was called out. Since the defendant was absent, he was placed ex parte. The defendant admittedly is serving in the army in the Tamil Nadu battalion at Kanchipuram. Rule 28 of Order 5 reads as under. A reading of the aforesaid Rule 28 would indicate that service on soldiers, sailors, or airmen would have to be effected by sending summons for service to the commanding officer, together with a copy to be retained by the defendant. A perusal of the plaint indicates that that while describing the defendant has been categorically shown to be in the occupation of working with the ಭೂಸೇನೆ ಅಂದ್ರೆ land army. ಇವಾಗ ಇಲ್ಲಿ army ಅಂತ ಹಾಕಿದೆ. Land army. It is not clear from the said description whether he is working in the army or the land army, since land army could relate to any other entity under the state government also. Notice was directed to be issued through RPAD. The perusal of the order sheet does not indicate that the notice has been issued to the commanding officer in terms of Rule 28 of Order 5. The RPAD having been served, it is also not clear from the, sorry, it's not clear. In the order sheet, there's an endorsement made that the RPAD has been refused. And it is in that background that the court held the defendant to be deemed to have been served and placed ex parte. Now, when the defendant is working in the army, in terms of Rule 28, notice was required to be served to the commanding officer. The question of refusal, who has refused, would have to be considered in the civil miscellaneous petition now filed by the defendant respondent. In that view of the matter, it not being clear as to whether the service has been effected properly or not, the application filed under 21 Rule 29 for staying of the execution proceedings, since the civil miscellaneous number 1 of
24 minutes.
1 of
24 minutes.
24 had been filed to set aside the ex parte order, cannot be found fault with. The submission of the learned counsel for the petitioner that in terms of Rule 29 of Order 21, there have to be two different proceedings in as much as two different suits, cannot be accepted in as much as if the execution proceedings were to continue when CMS is pending, and if the CMS was allowed, the decree would naturally be set aside, which would result in the defendant being placed in a position which cannot be reversed. As such, I do not find any infirmity in the order passed by the trial court. The petition stands dismissed at the stage of admission itself.
It is actually
memo.
NCC commanding officer. Commanding officer NCC, TN Tamil Nadu battalion.
I don't know.
Please.
He's a JCO, so it has to be.
Please.
17 SS Chalwadi.
I appear for petitioner. The petitioner may not have purchased the land
But, to the extent of my lords, 8 acres and 15 guntas, my lord. My lords, I'll take my lords to the annexure G, which is passed by your lordship.
There is no interim relief.
My lord, annexure G, page number 74, for a moment.
Mari, you government, hai na? 74.
74 is the order which is passed by your lordship. My lords, these are the petitioner have also, my lords, given, my lords, consent for the sale which was taken to the, my lords, petitioner. These, my lords, all the, my lords, 4 petitioners are the, my lords, consented, have given consent for my sale deed, which is at, my lord, page number.
Petitioners in 101650.
Yes, my lord.
Yes.
My lords, the consent deed also, my lords, I have produced at annexure E, page number 62, where all the, my lords, the parties in the, my lords, proceedings, where, my lords, have also given the consent in the year 2014, my lords. My lords, by virtue of that, my lord, I became the, my lords, absolute owner of the property. My lords, I have given, my lords, my request to the authority to enter my names, my lords, as per annexure H, page number 83. I'll take, my lords, to the order which was passed by your lordship is, my lords, page number, relevant portion is at, my lords, page number 81.
Roman 5.
Roman 5. Roman 5, during course of the survey, if ADLR is of the opinion that any other persons has any interest in the said land, the ADLR shall issue notice to such persons and conduct a joint survey, even if already concluded and so and so. My lords, before to that, my lords, I have given, my lords, my request, which is at, my lords, annexure.
You not been issued a notice.
Please, my lords, before to that only, my lords, I have requested the authority to mutate my name as per the, my lords, registered sale deed.
Survey adag notice kotro ilvo?
Illa kottilla. My lords, annexure F, page number 71 for a moment.
Their representation that your lordship, to the inquiry, to the authorities, your lordship, have to issue notice before joint inquiry. It is the representation made by them, your lordship.
Survey ಮಾಡಾಗ ಇವ್ರಿಗೆ notice ಕೊಟ್ರಾ?
ಇಲ್ಲ, ಅದು ಗೊತ್ತಿಲ್ಲ.
ಕೊಡ್ಬೇಕಲ್ಲ.
Petitioner ಕೊಟ್ಲೇ ಇಲ್ಲ.
It is their representation, your lordship, that is annexure H, your lordship.
Is a clear this one of the government property being enforced and taken. That is why we are directed all this.
But your lordship, in the writ petition, he is not the party. In the writ
He may
petition.
not be a party. That is why we are specific.
I am not a party.
Only that your lordship,
During
annexure
the
H.
course, if ADLR is, any other person has any interest.
As per the annexure G, your lordship, passed by this honorable court, and they have made the representation, your lordship, to issue notice, your lordship, before joint inquiry.
ಎಲ್ಲರಿಗೂ notice
Yes.
ಕೊಡಿ,
ಅಷ್ಟೇ,
ಎಲ್ಲಾರ್ನು ಎಲ್ಲಾರ್ನು
Yes.
ಓಡಿಸಿ.
ಅಷ್ಟೇ.
But notice ಕೊಡ್ಬೇಕು.
ಅಷ್ಟೇ.
It is a government land.
Yes.
You should do that.
Yes.
If you have any claim against your
Yes,
vendor,
my lords,
take
that's what.
your
My
action.
lords,
against
before to, my lords, passing an order up by this court, my lords, I have given a, my lords, request at, my lords, annexure F for a moment, my lords, which is dated, my lords, 9/12/2024 itself.
But we cannot grant you this order.
That is true, my lord. That is true. Only my request is, since my lords, registered sale deed is, my lords, in my favor, let them consider my request and, my lords, pass an order. Since, my lords, I'm not saying that, my lords, they should, my lords,
It is
enter my
government
name.
property.
Yes, my lords, that is true, my lords. That's what,
And
my
how
lords,
can
I'm
it come in
annexure.
your name?
Annexure G is, my lords, I am relying upon, wherein your lordship has, my lords, specifically directed the authority to consider the claim of the, my lords, any of the persons, which is not done.
And AG accepts notice for respond number 1 to 3.
That's the only, my
The
lords, my
petitioner
request.
is before this court seeking for the following reliefs. The claim of the petitioner is that
On 11/3/2010, my lords, I have purchased the property to the extent of 8 acres and 15.
the petitioners in WP number 10650 of 2024 they had sold,
My lords, the vendors of the, my lords, my lords, predecessor, my lords, they are the, my lords, legal heads of, my lords, one Kirby family. They have also given the consent.
had consented to the sale in favor of the petitioner of the subject property which had been sold by the father of the petitioner in WP 101650 of 2024.
ಅಲ್ಲ,
And as
in fact,
such
ಅದು
an-
father ಅಲ್ಲ, because it was, my lords, I have got it through court, my lords, commissioner was appointed, and, my lords, specific performance
had
suit was
given a
filed.
consent as regard the sale
Yes, ma'am.
executed in favor of the petitioners. His submission is that the sale having been so executed and application having been filed for making necessary entries in the revenue records
On 9/12, ಅದೊಂದು ಹೇಳಿದ್ರೆ.
on
It is part-
9/12
Yes, my lord, and 24.
24
With all the
annexure
annexures.
9/12,
Annexure F,
2024.
page number 71.
The said application has not been considered.
After the passing of your lordship order, I have, my lords, informed the, my lords, authority to, my lords, conduct
This
survey.
court,
Yes.
while it's ordered at 24 January 25 in WP number 101650 of 2024, had directed the ADLR to carry out necessary survey in respect of the various properties described therein And in the event of the ADLR being of the opinion that any other person has interest in the said land, to issue notice to such person and carry out a joint survey. The petitioner having made an application for change for entry of his name in the revenue records before the survey, it was but required for the ADLR to have issued notice to the petitioner also, requiring his presence during the joint survey. The same not having been done, I pass the following order. Writ petition is partly allowed. The ADLR is directed to issue notice to the petitioner and carry out a joint survey of the land claimed by the petitioner and such other land as may be required to be carried out, if not already carried out by the ADLR, in terms of the order dated 24 January 2025 in WP number 101650 of 2024. Since the order is passed in the presence of the counsel for the petitioner, the survey is directed to be carried out commencing from 10:30 a.m. on 14th March 2025. It is left to the petitioner to participate in the said survey. If the petitioner were not to participate in the said survey, the petitioner would not be entitled for any equities.
Great. 18, VM Shield 1.
This case,
yes.
The other day I have been asked to appear for R4, telling my wakalat for R4. R4.
4.
Ravindra Gudi.
HDMC.
That's my request, Your Lordship.
Shri Gurudev Gachanmat accepts notice for respond number 1 and 2. Shri Javalkar accepts notice for respond number
4.
4. What about 3 and 5?
They are not my clients.
Yes.
Yes, may I request, no, sir, both 33 is also connected to this. Your Lordship can take both matters.
33 reach
Is Javalkar is.
33.
ಅದರಲ್ಲಿ interim order ತಗೊಂಡಿದ್ದಾರೆ ಅದು ಇದು ಕನೆಕ್ಟೆಡ್ ಎರಡು ಮ್ಯಾಟರ್.
Properties are same.
Properties are same. They have obtained stay of demolition. ಅದಕ್ಕೆ ಅಂತ ತಗೊಂಡ್ರೆ ಎಲ್ಲ ಮುಗಿದು. Your Lordship can
33 ಕೊಡಿ.
Your Lordship can take 33 minutes.
Awaiting
As regarding the first petition which my friend has filed, my wakalat.
ಯಾರು ಕೌನ್ಸಿಲ್ ಹಂಗ್ 33 ಔಟ್ ಆಫ್ ಟರ್ನ್ ತಗೊಂಡ್ರೆ ಅವ್ರಿಗೆ ಯಾರು ಗೊತ್ತಾಗುತ್ತೆ?
ಅಲ್ಲ ಎರಡು ಕನೆಕ್ಟೆಡ್ ಇದೆ ಅದಕ್ಕೆ.
ಇದೆ ಬಟ್ ನೀವು ಮಾತ್ರ
I'm appearing. I'm ready to wait for that. I'm ready to wait for my turn on that particular aspect.
ನಂಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ.
Wait for my turn on that.
Pass over along with 33 if it reaches.
Please.
Connect with 33 and that video.
19, Siddhappa Sajjan.
Yes.
For the petitioner in this case, petitioner challenging the annexure B, C, H and K, my lord.
4161 and award.
4161 and award, my lord. Now they have issued the endorsement that now we deposit the amount, we vacate the possession, my lord. We are in the possession of the land since from. Now, as per the section.
That is why it's been acquired from you.
Acquired, but they have not taken possession, my lord. And amount has been not deposited.
61 ಯಾವಾಗಪ್ಪ ಆಯ್ತು?
Lord, 61,
my lord.
16/6/2015. Award is passed on 27/1/2017.
17.
In 2 years.
Yes, everything is within time. Now in
And not deposit the award amount, my lord. And they have now taken the possession also. And section 24(2), my lord, if more than 5 years you have not taken the possession, they have not deposited the amount.
Award has not been passed on the state. 2013 Act, Sriram.
Section 24, my lord. And land is taken by rehabilitation, my lord. We are constructed the house as well as a commercial complex. Now petitioner has dispossession that their houses, my lord.
Provided when award has been made and compensation in respect to majority of land holding has not been deposited. Was there any court proceedings relating to this land?
Please. And there is judgment of this court, my lord.
Court proceedings.
This court, my lord.
If there is no court proceeding, 2017 award aito, 5 years.
Yes, my lord.
My lord, even though taking into consideration section 24(2) in the indoor development authority judgment, it has been clarified in the subsequent development, even though if it is award is not and the beneficiary is not deposited the compensation, the proceedings does not lapse.
ನೀವು ಎರಡು it has to be both.
ಅಲ್ಲ ಯಾಕಂದ್ರೆ ಇದರಲ್ಲಿ the beneficiary is the that is the respond number 3. Whether they have deposited an amount, my lord, it is the authority who has to say.
They are not, they issued the endorsement annexure K, my lord.
ಬೇರೆಯವರ ನೀವಲ್ವಾ?
ಇಲ್ಲ.
Annexure K, my lord.
But you are appearing for SLO.
1 and 2 ಅಲ್ಲ SLO BTDA ಬಾಗಲಕೋಟೆ ಅರ್ಬನ್ ಡೆವಲಪ್ಮೆಂಟ್ 1 and 2 we appear. So my lord,
SLO has to say whether the deposit has been made or not.
yes my lord, by tomorrow itself I will say whether amount is deposited or not by the beneficiary.
Annexure K, my lord.
All three you will appear.
No, Bagalkot. My lord, it is
SLO is
Bagalkot
state.
Town Development Committee. Committee.
SLO Bagalkot Town Development Committee. SLO.
ಅಲ್ಲ ಯಾಕಂದ್ರೆ
Committee party ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ SLO and rehabilitation ಬಾಗಲಕೋಟ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ.
SLO ನೀವೇ appear ಆಗೋದು. ಬೇರೆ ಇನ್ಯಾರು ಅಪಿಯರ್ ಆಗಕ್ಕಾಗಲ್ಲ.
ಅಲ್ಲ ಇಲ್ಲೇ ಗಿರೀಶ್ ಹಿರೇಗೌಡರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ ಇದಕ್ಕೆ ಬಾಗಲಕೋಟ್ ಟೌನ್ ಡೆವಲಪ್ಮೆಂಟ್.
ಅದಕ್ಕೆ ಅಪಿಯರ್ ಆಗ್ತಾರೆ. SLO ನೀವು.
SLO I accept correct.
1 to 3 you will appear.
Committee ಅಂತ. ಅಲ್ಲ SLO it is true.
SLO BTDC
committee.
ಮತ್ತೆ ಅದೇ
please I accept notice ಮಾಡಿ.
ಅದೇ SLO ಅಂತ ನೀವು BTD ಅಂತೀರಾ. And AG accepts notice for respond number 1 to 3. He seeks for and is granted a day's time to obtain instruction, make a submission as to whether the award amount has been deposited and or the possession of the land of the petitioner has been taken by the SLO.
Please.
Relist on 28th.
Please.
Sought for stay, my lord. They have sought for stay not to dispose.
ನಾಳೆಗಿದೆ ರೀ.
20 Lakshmanti Mantigani petitioner.
Yes.
The land of the petitioners has been acquired for BRTC bust. Wherein the negotiation committee has been constituted for fixing the market value. It was fixed the market value 6,750 per square feet.
And AG accepts notice for respond number 1 and 2. He seeks for and is granted
two ಅಷ್ಟೇ CV ಅಂಗಡಿ KRDC ಅಲ್ಲಿ ಇದೆ.
Again ಮತ್ತೆ SLO.
SLO
ಅಲ್ಲ ಅವರು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್
SLO ನೀವೇ. ಇದೇ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಾ ಇದೆ ಎಲ್ಲದರಲ್ಲೂ.
ಕರ್ನಾಟಕ ಡೆವಲಪ್.
SLO is the state.
Correct. True my lord, but
it cannot be the, if they were made a party, yes. You are the state. SLO is the state. Is delegated authority.
Please.
Seeks for and is granted 2 weeks time to obtain instruction, make a submission. Relist on 21st March.
21 K. Anand Kumar.
Petitioner. I'm challenging the annexure J, my lord. Imposition of the interest, my lord. Already the 16,900,000 rupees paid by the
representation. 493.
Annexure J, my lord. Kindly see page number 39.
ಇಲ್ಲ ಯಾವ petition ನೀವು ನೋಡ್ತಾ ಇದ್ದೀರಾ? ಇದು 1493 ತಾನೆ?
ಹೌದು.
Your prayer is for a mandamus to consider representation.
ಎರಡನೇ prayer ಇದೆ. ಎರಡನೇ
prayer.
Please, man.
First searcher ಬದಲು ಆಮೇಲೆ.
Please, man. Please.
Passed by annexure J relating demand of.
Already 16,900,000 rupees deposited, my lord. Interest ಕೇಳಿದ್ದಾರೆ. The land was granted land grant rules, my lord. ಸದರಿ ಸರ್ಕಾರ 138A ಚದರ ಅಡಿ ನಿವೇಶನವನ್ನು ಸರ್ಕಾರದ ಪತ್ರ ಸೋಣಿಸು ಅನ್ವಯ 1 ಚದರ ಅಡಿಗೆ 350ರಂತೆ ವಿಧಿಸಿ ಮಂಜೂರು ಮಾಡಲು ಅನುಮತಿ ಇರುವುದರಿಂದ ಅದರಿಂದಲೂ ಸದರಿ ಶ್ರೀಮತಿ ದ್ರಾಕ್ಷಾಯಣಿ ಕೋ ಚಂದ್ರಶೇಖರ್ ಶೆಟ್ಟರ್ ಅವರ ಸ್ವಾಧೀನದಲ್ಲಿರುವುದರಿಂದ ಈಗಾಗಲೇ ವಿಧಿಸಿದ ಮೊತ್ತದೊಂದಿಗೆ ಸದರಿ ಮೊತ್ತಕ್ಕೆ ಜಾಮೀನು ಮಂಜೂರಾದ ದಿನಾಂಕದಿಂದ ಇಲ್ಲಿಯವರೆಗೆ ನಿಯಮಾನುಸಾರ ಬಡ್ಡಿಯನ್ನು ವಿಧಿಸಿ ಸಂಪೂರ್ಣ ಮೊತ್ತವನ್ನು ಬರೆಸಿಕೊಂಡು ಮಂಜೂರು ಮಾಡುವಂತೆ ನಿರ್ಧರಿಸಿದ್ದೇನೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ರೆಗ್ಯುಲರೈಸೇಷನ್
ಪ್ಲೀಸ್ ಮೇಲ್
ರೆಗ್ಯುಲರೈಸೇಷನ್
ಹೌದಾ ರೆಗ್ಯುಲರೈಸೇಷನ್.
ಸೊ ಅದಕ್ಕೂ ದುಡ್ಡು ಕೊಡಲ್ಲ ಅಂದ್ರೆ
ಅಲ್ಲ ಕೊಟ್ಟಿದೀವಿ annexure L1 L2 ಮೇಲೆ 16,900,000 rupees already paid ಮೇಲೆ
1,60,000.
L1 L2 ಮೇಲೆ total 16,09,900. 9,09,000 ಒಂದಿದೆ, 1,05,00,000 ಒಂದಿದೆ, 1,60,000.
ಏನು
ಅದು ನಮ್ಮ ಹೆಸರಲ್ಲಿ ಗೌರ್ಮೆಂಟ್ ತೆಗೆದು ನಮ್ಮ ಹೆಸರಲ್ಲಿ
ಏನಕ್ಕೆ ಕೇಳ್ತಾ ಇದೀರಾ annexure J ಗೆ?
ಇಂಟ್ರೆಸ್ಟ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದ ಓನ್ಲಿ ಇಂಟ್ರೆಸ್ಟ್ ಕಟ್ ಅಂತ ಹೇಳಿದಾರೆ ಆ ಅಮೌಂಟ್.
Interest from which date? From the date of
Date
regulation.
of the allotment till ಅಂತಂದ as per the Karnataka land rule grants ಮೇಲೆ there is no option to grant the interest ಮೇಲೆ.
Yes.
They have utilized your lordship that land, but your lordship they are entitled to pay interest.
Residential purpose.
ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ, ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ. Interest ಇಲ್ಲ, they did not pay it on time.
For that only.
First of all, you are unauthorized possession. You are getting the land.
Since my lord 1963 my lord he in
From date of allotment ಸ್ವಲ್ಪ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡಕ್ಕೆ ಏನಂತೆ?
ಅಲ್ಲ ಅದು ಕಮರ್ಷಿಯಲ್ ಆ ಕಾಸ್ಟ್ ಹಾಕಿದ್ದಾರೆ. ಕೈಂಡ್ಲಿ ಸಿ ಮೈ ಲಾರ್ಡ್ annexure ಇದು ರೆಸಿಡೆನ್ಷಿಯಲ್ ಸರ್ ಪರ್ಪಸ್ ಆಗಿದೆ.
Accepts notice for respond number 1 to 6.
ಕೈಂಡ್ಲಿ annexure G ಮೈ
Weeks fund is granted 3 weeks time to make a submission as regards the basis of levy of interest. Released on 28th March.
Please.
22, Sunita P.
Your Lordship, this is a petition.
Levy
wherein
of
the
interest.
respondent-
Interest.
Your
Yes.
Lordship, the defendant has filed a suit for specific performance on the agreement of the year 1996, Your Lordships. Page 13 is the plaint averment, where I would like to take Your Lordships to para number 4, Your Lordships. Page 13, para number 4.
Yes.
The plaintiff accordingly agreed to purchase one shop, and after negotiation, the total consideration value of a shop of so and so. This is my specific contention, Your Lordships, and this is the plaint averment. Now the application at page 36, Your Lordship may take. Application for amendment of pleadings is being taken, Your Lordships. May I take on page 36. Affidavit part, Your Lordships.
What is the amendment?
The amendment sought, that's what I was bringing for Lord's consideration.
35 is the affidavit.
Please, in the affidavit, in the affidavit, it is said that in this case, the suit house number was not mentioned in the legal notice as the agreement was so and so of the shop. After completion, so it was not mentioned in the agreement. Thereafter, the defendants demolished the shop, altered so and so. Now they want to bring it to the, now they want to change the entire case of the suit, Your Lordships. They say that I have demolished the suit, but the plaint is of the year 2020-21, Your Lordships. There they specifically pleaded for the shop, agreement for grant of shop, Your Lordships. Now, in the amendment pleadings, they seek the same as the house.
But the schedule says that survey number 217/F, Bard 1 village, Karwar Taluk, 10 into 20, total 200 square feet, having Karwar CMC number so and so, situated adjacent to so and so.
Your Lordships, now there is a new house constructed, Your Lordships. They want to, the old number remains the same. It will not get changed. But now they are trying to bring a new number saying that this is going to change the nature of the suit. That's my specific contention.
217/F, Bard 1 village, Karwar.
And
Ashte, they want to add that in para 4.
para 11,
because
para 11, Your
para
Lordships.
11,
Please.
para 11.
Please, Your Lordships.
Para 11 ಅಲ್ಲಿ ಏನಿದೆ, after demolition so the plaintiff issued a legal to their advocate so and so. Ashte, the schedule is the same. How does it change?
This is now after the entire cross-examination is over, Your Lordships, after the commencement of the trial, after the PW1, PW2, both are being examined, Your Lordships. Now this application has been filed, Your Lordships.
It won't change anything, madam. It is nothing that you will read any additional evidence.
Your Lordships, now there's a new house constructed over there.
So what? You have entered an agreement to sell. After that, whatever you do with it,
Agreement to sell is of
new
the year.
house or new multi-story building, it doesn't matter. You took the risk of constructing the house,
Your Lordship,
having an enter into an agreement.
the pleading is specifically for the shop. There is a shop and the upper floors are there. Now, if they enter this new number, the entire property comes into the picture. That's
There's
my,
no new number, madam. Suit schedule property is 217/F. Please see page 15.
please, Your Lordships. But
Is there already number?
schedule is, it is mentioned, Your Lordships. They want to bring it in the purview of the pleadings. Now, this will take the entire
The
chunk
schedule
of
is
the
also
property,
part
chunk
of
of
the
the
pleading.
property, Your Lordships.
The schedule is also part of it. We are not going to stay the matter. Issue notice to the respondents, returnable by 29th April.
Obliged.
It is made clear that the suit shall go on.
23, we have Lopan.
Yes.
Petitioners, my lord, the plaintiffs, number 1 to 4, 5 and 6, my lord.
Inna certiorari ಆಗ್ತಾನೆ ಇರ್ರಿ.
Please, my lord.
ಎಲ್ಲರಿಗೂ ಹೇಳಿದೆ, how can certiorari be there on 227 CPC? Set aside ಅಂತ ಕೇಳಬೇಕು. ಹೇಳಿ.
Please. Lord, we had filed a memo seeking withdrawal of the suit, my lord.
You are the plaintiffs.
Yes, my lord.
Suit for?
Suit for partition and separate possession.
Huh.
Lord, the present petitioners are plaintiff number 1 to 4, 5 and 6, my lord.
One to 3, 5 to 7.
1 to 3, 5 to 7, my lord.
Huh.
Lord, the trial court has rejected our memo on the ground that the other plaintiffs have not consented for. In fact, they have tendered their no objection on the memo itself. Page number 96, my lord, is the memo. The memo is supported by an affidavit saying that we are not concerned with the defendant's family.
You cannot say written statement, once you want to withdraw, you admit the content of the written statement.
Please, my lord.
You are saying you admit the contents of the written statement of defendant 1 to 4.
Yes, my lord.
Adi irakagalla. You want to withdraw your claim, you withdraw that.
Yes, my lord. Yes, my lord. Without there being, because, my lord, in fact, the other co-plaintiffs have tendered their no objection on the memo. Page number 96, my lord.
Issue notice to the respondents returnable by 25th April. The further proceedings in OS number 124 or 23 pending on the file of senior civil judge Bailongal is stayed till the next date of hearing. Process fee and copies by end of date 28th, filling with the interim order will stand automatically vacated.
24, Sriharsh.
Lord, in this suit for declaration and permanent injunction, my lord. Lord, your lordship may kindly, earlier occasion, your lordships had directed page 86 annexure K. Lord, for setting up of petrol pump, I had given a representation to the authorities. Your lordship directed this authority to, my lord, consider this. Based on this, annexure L has been passed, page 90, my lord.
Yes.
Saying that I have to obtain permission of the trial court under section 52 of
Respondents.
yes, my lord. I filed an application seeking pleading, my lord. My lord, already the list has attained finality in contempt proceedings before this honorable court, my lord. Because
how lists open?
My lord, there was a boundary dispute between plaintiffs and defendants.
Suit enaitadu 53
Other suit, earlier suit they have withdrawn in view of their compromise before this honorable court. They had agreed to withdraw the suit. They withdrawn the suit and files a fresh suit, my lord. And in that suit, I filed an application under section 52 seeking to enter into a lease agreement, my lord, with the fifth respondent corporation, my lord. So that has been dismissed.
Issue notice to the respondents. Number 1 to 5. Returnable by 25th April. Shri C.V. Angdi is directed to accept notice for respond number 6.
Please.
$25, Girish Adward.
Kindly pass over, my lords.
Pass over.
26, Arvind D. Kulkarni.
In pendence of the matter, respond number 3 has expired, hence IA 1 of 25 has been filed. Issue notice on IA 1 of 25, returnable by 29th April.
Petitioner is
During the
also.
pendence of the above matter, petition number 1 expired on
5/5/2020.
5/5/2024, hence IA 2 of 25 has been filed. Accepting the reasons stated therein, delay of 141 days is condoned. The abatement in respect of petition number 1 is set aside. The person named therein are brought on record as petition number 1A to 1C. Counsel for the petitioner carry out necessary amendment, file amended cost title.
Much obliged.
27, Srinand Tachapure.
Milords, in this matter, Milords,
My lord,
yes,
senior is held up in Kotal number 2. Kindly pass over, my lord.
Pass over.
please.
Please. 28, Muralidhar Puliyal.
ನೀವು ಹೆಂಗೆಲ್ಲ ಫುಲ್ ಹೆಸರು ಹೇಳ್ಬಿಟ್ರೆ ನಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ ಇಲ್ಲಿ. ಎಮ್ಮೆ ಉಳಿಯಾಲ್ ಮುರಳೀಧರ್ ಆತ್ಮಾರಾಮ್ ಉಳಿಯಾಲ್ ಅಂದ್ರೆ.
I'm sorry, Lord, sorry to,
ಹಾ
serial number 23.
ಹಾ
The lordship has granted stay, Lord.
yes
Ali, some of the defendants had filed a temporary injunction in view of notice.
collusion clearly.
Collusion.
You accept the contents of the written statement of D1 to 4 and now you want the injunction application to be also considered.
Andre, they have filed an application for injunction.
And then 23 issue notice. Interim order.
Lord, the land acquisition matter, Lord.
Withdrawal of amount. Who wants to withdraw?
Lord, I have filed application for Lord seeking permission to withdraw the amount.
What amount is deposited for what?
Lord, 25% of the Lord, the total amount, Lord, disputed amount 1 crore, 5 lakh and odd. 1 crore 5 lakh 72,624 was ordered to be released, Lord, by the executing court. So that was questioned, Lord, by the judgment.
But it is disputed. The contention is that no amount is due on third.
That is it. But that was not accepted, Lord, by the executing court. And Lord, there was an order to Lord, still, Lord, they have to pay, Lord, 1 crore 5 lakh 72,000.
You are private parties.
We are the land losers section.
The land.
Buddha has acquired the land.
Buddha yaru standing counsel.
Mr. Ullal appears for the Buddha. Ullal appears. Petitioner.
He is filed against himself. ಅದಕ್ಕೆ ಹೇಳೋದು ನೋಡಿ, ಸ್ಪೆಷಲ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಫೀಸರ್ ಇಸ್ ಓನ್ಲಿ ದ ಸ್ಟೇಟ್ ಹೂ ಕ್ಯಾನ್ ಬಿ ಫಾರ್ ದಿ SLO. The beneficiary and SLO can never be together. They are different role. SLO ಗೆ ಅವರು ಹಾಕಿದ್ದಾರೆ against themselves. It has been filed like that, dismiss. Mr. Ulial.
Mehuliyar.
We'll observe it in this, that this kind of things can be avoided. ಆಮೇಲೆ SLO ಮೇಲೆ allegation. You are same representing, same lawyer, SLO ಮೇಲೆ allegation. Government bandre at least something will be there.
One of the cases where the lordship passes such orders, it will be convenient for.
ಅದ್ರಲ್ಲಿ ಬರುತ್ತೆ ಅದು, ಇದ್ರಲ್ಲೂ ಹೇಳ್ತೀವಿ, ಅದ್ರಲ್ಲಂತೂ ಡೀಟೇಲ್ ಆಗಿ ಬರುತ್ತೆ. The above none appears for the petitioner. None appears for the petitioner ಬೇಡ, ಸುಮ್ಮನೆ ಯಾಕೆ ಅವ್ರಿಗೆ. The above petition has been filed by the SLO, Belgavi Urban Development Authority. One of the respondents, that is respondent number 2, is the chairman, Belgavi Urban Development Authority. The counsel who has filed the above petition is a standing counsel for the Belgavi Urban Development Authority. In that view of the matter, the Principal Secretary, Revenue Department, as also the chairman, Belgavi Urban Development Authority, are directed to file their respective affidavit as to how the above petition has been filed and how the standing counsel for the Buddha is appearing for the Special Land Acquisition Officer, who is a delegate of the state for whom only the government advocate can appear. Released on 20th March.
Yes.
29, Venkatesh Karvi.
Protected by the reserve land dated 1955 by annexure B, my lords, that is a Kabristan. But by filing the impleading application by the, my lords, petitioner respondents herein, they are now a concern to the survey number because it is a reserve land, my lord, is not a panchayat land. So 19 annexure B, my lord, it was granted on 1955. Since from 1962, my lord, they have not record maintained by the Tahsildar or the Revenue Department. As per annexure J, my lords.
Consider their objections also and pass an order. It's only
Because-
mandamus.
Because he has considered, he also questioned the order of lordship in this.
ಇಲ್ಲ ಬರೀ mandamus ಇದೆ.
ಅದು ಮ್ಯಾಂಡಮಸ್ ಇದೆ ನಾನು ಕೇಳ್ತಾ ಇದ್ದೆ ಅಷ್ಟೇ ನಾಟ್ ಚಾಲೆಂಜ್
representation of 28.
ಮ್ಯಾಂಡಮಸ್ ದಟ್ ಈಸ್ ವಾಟ್ ಮೈ ಲಾಸ್
NSRK, they are saying that you will
Objections
further
ಏನಿದೆ,
present
Allah,
Qatar.
they'll consider. Annexure L, H and L.
But in the interim prayer lordship, they are seeking NSRK.
ಅಲ್ಲ ಅಲ್ಲಿ ತನಕ ಏನ್ ಮಾಡಬಾರ್ದು ಮ್ಯಾಂಡಮಸ್ ಕನ್ಸಿಡರ್ ಮಾಡಬಿಡ್ತು ದಟ್ ಈಸ್ ವಾಟ್
ಇಷ್ಟೇನೆ ಬೇಡ.
ಅಷ್ಟೇನೆ ಬೇಡ ಮ್ಯಾಂಡಮಸ್ ಕನ್ಸಿಡರ್
ನೋಟಿಸ್ ಆಗಿದೆ.
ನೋಟಿಸ್ ಆಗಿದೆ ಇಂಪ್ಲೀಡಿಂಗ್ ಕಲೀಗಿದ್ದಾರೆ.
And your lordship in the Impay 32 lordship may kindly see. Impay 32 lordship third para.
Order
Unless-
ಮಾಡಿದೀರಾ ಅವರು?
Unless you question that order of lordship annexure K. Page number 32 lordship may kindly see. Third para lordship. Survey number 167 ವಿಸ್ತೀರ್ಣ 2 ಎಕರೆ 28 ಎಕರೆ ಜಮೀನಿನ ಮೂಲ ಆಕಾರ ಒಂದು ಪ್ರಕಾರ
ನಂಬರ್ ಏನ್ ಹೇಳಿದ್ರು?
32 annexure K lordship. Third para lordship.
ಸರ್ವೆ ನಂಬರ್.
ಸರ್ವೆ ನಂಬರ್ 110 ವಿಸ್ತೀರ್ಣ 2 ಎಕರೆ 28 ಎಕರೆ ಜಮೀನಿನ ಮೂಲ ಆಕಾರ ಬಂದ ಪ್ರಕಾರ ಒಟ್ಟು ಕ್ಷೇತ್ರ ಬ ಕಾಲಂನಲ್ಲಿ ನಮೂದಿಸಿದ್ದು ಚಾಲ್ತಿ ಪಾಣಿ ಪತ್ರಿಕೆಯಲ್ಲಿ ಫಾರಂ ಪೋಕಾ ಫೋಡಾ ಎಂದು ನಮೂದಿಸಿದ್ದು ಮೂಲ ದಾಖಲೆಯಾದ ಕಾಸ್ರ ಮತ್ತು ಕೈಬದ ಪಡೆ ಸರ್ಕಾರಿ ಫಾರಂ ಪೋಕ್ ಇರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಸರ್ವೆ ವರದಿ ಪ್ರಕಾರ ಮನೆಗಳು ಮಾಳಿಗೆಗಳು ಖಾಲಿ ಜಾಗ ಇರುವುದಕ್ಕೆ ತಿಳಿದುಬರುತ್ತದೆ. ಅರ್ಜಿಯ ಕೋರಿಕೆ ಪ್ರಕಾರ ಕಬ್ಜಾ ಪ್ರಕರಣ ಪ್ರಕಾರ ಪಣಿ ಇಂದ್ರೀಕರಿಸುವ ನಿಯಮ ಇಟ್ ಇಸ್ ದಿ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ issued by considering these objections.
But it is contrary to the
Unless you
J,
question that annexure K.
It is contrary to
Again, you will
annexure
also
J.
consider that.
ಕೊಟ್ಟಿಲ್ವಲ್ಲ.
Annexure J,
This is
Assistant Commissioner order lordship.
it's they are not parties here.
ಅವ್ರದ್ದೇ objection consider ಮಾಡಿದ್ದಾರೆ sir.
ಅವ್ರದ್ದು objection.
167
ಹಾ.
survey number is.
annexure annexure J.
ಮುಖ್ಯಸ್ಥರು ಸಲಾರ್ಜಂಗ್ಸ್
ಮುಖ್ಯಸ್ಥರು your lordship ಉಲ್ಲೇಖ reference in ink page 31.
In page number 30, my lord.
Reference number 1 lordship.
Page number 30 ಅಲ್ಲಿ annexure J. Annexure J ದಲ್ಲಿ ಅವರು ನಮ್ಗೆ ಡಾಕ್ಯುಮೆಂಟ್ ಏನು ಕೊಡ್ತಾ ಇಲ್ಲ. From survey number 167 is concerned from 61 to my lord 83. ಅದು ಹೆಂಗ್ ಪರಂಪೋಕ್ ಆಯ್ತು ಅಂತ ಹೇಳ್ತಾನೆ ಇಲ್ಲ ಅವರು.
Page number 31, reference number 1 lordship.
ಶಿಥಿಲಗೊಂಡಿದೆ.
ಶಿಥಿಲಗೊಂಡಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಸೊ ಆನ್ ಆಸ್ ಪರ್ ಡಾಕ್ಯುಮೆಂಟ್ ಮೇಲೆ ವಿ ಆರ್ ಆನ್ ರೆಕಾರ್ಡ್ ಆನ್ 1955. ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ 60 ತನಕ ಇದ್ವಿ. 60 ನಮ್ದು ರೆಕಾರ್ಡೇ ಇಲ್ಲ. ಹೌ ದಿ ಗವರ್ಮೆಂಟ್ ಮುಟೇಟ್ ದಟ್ ಪರಂಪೋಕ್
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀರಾ?
ಯಾರು? ನಾವು ಒಂದು annexure B, my lords.
What is annexure?
Annexure B, my lord, that is it is reserved for Kabristan in Pakka Bukka, page number 13, my lord. A typed copy I have produced.
ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಕಾಪಿ ಇದೆಯಾ?
ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಅಲ್ಲ, ಕಬ್ರಸ್ತಾನ ಅಹಲೆ ನಮೂದ ನಿರ್ಜೀವಿತರ ಪ್ರದೇಶ ಅಂತ ಬರೆದಿದ್ದಾರೆ. ಪೇಜ್ ನಂಬರ್ 15, ಮೈ ಲಾರ್ಡ್ಸ್. ಕಬ್ರಸ್ತಾನ ಕಾಲ್ ನಂಬರ್ ಅಲ್ಲಿ ಖಾತೆದಾರ ಅಥವಾ ಇನಾಮದಾರ ಹೆಸರು ಕಬ್ರಸ್ತಾನ ಅಹಲೆ ನಮೂದು ನಿರ್ಜೀವಿತರ ಪ್ರದೇಶ. ಸೊ ಸಪೋರ್ಟೆಡ್ ಬೈ ದಿಸ್ ಐ ಹ್ಯಾವ್ ಪುಟ್ ದ ಫೋಟೋಗ್ರಾಫ್, ಮೈ ಲಾರ್ಡ್ಸ್, that shows annexure E, my lords. 1919 ಇದೆ, page number 19, support of that photos, my lords. Photos ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ, it is a Kabristan reserved for. It is not residential purpose.
Annexure C, annexure C, record of rights lordship.
ಅದೇ ಫೋರಂ ಪೋಕ್ ಹಾಕಿದ್ದು ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಆಗಿದ್ದು.
ಪರಂಬೋಕ್ ಆಗಿದೆ, ಬಟ್ ಅರ್ಲಿಯರ್ ಎಂಟ್ರಿ ಇದ್ದಿದ್ದು how did it get changed?
ಅದು ಇಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್, that is not on record.
ಈವನ್
Page number 15 ಅಲ್ಲಿ
ನಿಮ್ ಪರಂಬೋಕ್ ಇದ್ರೇನು ಖಾತೆದಾರ ಅಥವಾ ಇನಾಮದಾರ ಹೆಸರು
15 ದಲ್ಲಿ ಪರಂಪೋಕನ ಅಂತ ಇದೆ.
ಖಾತೆದಾರ ಹೆಸರು ಯಾರ್ದಿದೆ?
ಖಾತೆದಾರ ಹೆಸರು ಇಲ್ಲ.
ಪೇಜ್ 15 ಅಲ್ಲಿ ಖಾತೆದಾರ ಹೆಸರು ತೋರಿಸಿದಾರಲ್ಲ.
ಅಲ್ಲ, your lordship, in that your lordship it is the ಹೊಲದ ಹೆಸರು ಪರಂಪೋಕ್.
ಹೊಲದ ಹೆಸರು ಪರಂಬೋಕು.
Yes.
ಖಾತೆದಾರ ಅಥವಾ ಇನಾಮದಾರ ಹೆಸರು ಕಬ್ರಸ್ತಾನ್ ಅಲ್ಲೇ
ನಿರ್ಜೀವಿತರ ಪ್ರದೇಶ ಅಂತ ಇದೆ.
ನಬೂದ್
If it is the
ನಿರ್ಜೀವಿತರ
question, Your Lordship, it is not necessary for him to make a representation if it is the case, according to him, Your Lordship.
But you are reserved like this.
No, because Your Lordship,
allotting.
because Your Lordship, we have rejected Your Lordship, wide answer K, it is a government land, Your Lordship.
On the ground that it's Perambok land.
Yes.
ಆ ಪೆರಂಬೋಕ್ಕೂ ಹೋಗ್ಬೇಕಲ್ಲ, ಪೆರಂಬೋಕ್ ಇಸ್
Your
ಖರಾಬ್
Lordship,
ಲ್ಯಾಂಡ್.
So I made a submission
Kharab
that,
land,
Your Lordship, he has
Kharab land.
questioned this annexer K, Your Lordship.
ಇಲ್ಲಿ ಹಿಂಗೆ ಪೆರಂಬೋಕ್ ಯೂಸ್ ಮಾಡ್ತೀರಾ? ಇದೆಲ್ಲ ಮೆಡ್ರಾಸ್ ಪ್ರೆಸಿಡೆನ್ಸಿ, ಇದು ಪೆರಂಬೋಕ್ ವರ್ಡ್. ನಿಮ್ ಬಾಂಬೆ ಪ್ರೆಸಿಡೆನ್ಸಿ ಇದಲ್ವಲ್ಲ ಪೆರಂಬೋಕ್. ಹೆಂಗೆ ಬಂದ ಪೆರಂಬೋಕ್ ಇಲ್ಲಿ?
ಅದೇ ನಮಗೆ ಗೊತ್ತದೆ, ಇಟ್ಸ್ ವರ್ಡ್ ಪರಂಪೋಕ್. How it
Perambok is Karab land.
Karab land, please.
In Madras presidency.
And as per the B Karab land, as per the government notification, I have one copy, my lords. It is the reserve for only, my lords, that Smashana Rudrabhumige reserve ಮಾಡ್ತಾ ಇರೋದು. That is, I have that one copy, my lords.
What is your representation now?
Representation that consider, my lord, once again consider.
Once again ಹೆಂಗಾಗತ್ತೆ?
ಅಲ್ಲ 21/8/24, my lords.
Annexure K is already been considered and rejected.
Rejected.
You have to challenge it.
Yes.
But my lords,
Don't to challenge instead of challenging.
but ಏನದ
Unless he
challenge ಮಾಡ್ಬೇಕಾದ್ರೆ
questioned, the
ಏನಾಗ
same remains, Your
what
Lordship.
why, my lords, as per annexure J, they have not given any documents for.
Right or wrong, they have passed an order. You have to challenge that
ಅಲ್ಲ
order.
ಬಟ್ ಮೇಲೆ ಇಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಸರ್ವೆ ನಂಬರ್ annexure J ಪ್ರಕಾರ ನಂಗೆ ಡಾಕ್ಯುಮೆಂಟೇ ಇಲ್ಲ. Otherwise secure the document by government, so I am ready for that. Government directed to secure the documents.
Petitioner told. Petitioner is before this court seeking for the following reliefs. Learned AGA submits that the representation has been already considered and an order passed on 1/7/2024, which is already which also been which has been produced by the petitioner himself at annexure K. If that be so, the main relief only for mandamus is not maintainable. Learned counsel for the petitioner submits that in order to challenge annexure K, the petitioner has sought for certain documents from the respondents, which has been rejected on the ground that the said documents are not available.
Yes.
If they are not available, the question of directing the respondent to furnish any document would not arise. It is for the petitioner to challenge annexure K in a manner known to law. Reserving such liberty, the petition stands. ಅಲ್ಲಿ ಶಿಥಿಲಪಟ್ಟಿದೆ ಅಂದ್ರೆ
ಅಲ್ಲ ಈಗ ನಾವು ಮತ್ತೆ ಈ ಗವರ್ಮೆಂಟ್ ದೇ ಹ್ಯಾವ್ ಟು ಮೇಂಟೈನ್ ದಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲ, ಅದರ್ವೈಸ್
ಮೇಂಟೈನ್ಡ್ ಅದೆಲ್ಲ ಶಿಥಿಲಪಟ್ಟಿದೆ, ಏನೇನೋ ಆಗಿದೆ, ಬಹಳ ಚೆನ್ನಾಗಿ ಮೇಂಟೈನ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ ಅವ್ರು ಬಹಳ ಚೆನ್ನಾಗಿ ಮೇಂಟೈನ್ ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲ ಡಿಜಿಟೈಸ್ ಮಾಡಿಸ್ತಾ
ಅಲ್ಲ
ಇದ್ದಾರೆ ಒಂದೊಂದೇ.
ಪರಂಪೋಕ ಹಾಕಿ ಅವ್ರು ಮೇಂಟೈನ್ ಮಾಡಿದ್ದಾರೆ.
Please, pending applications do not survive.
Please. 30. Irangauda Kapoor.
Filed I for recalling the order dated
ಏನಕ್ಕಪ್ಪ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು?
12. For non-prosecution.
Why was it dismissed? Taken steps in respect of 1 to 5. Steps payment ಮಾಡಿದ್ದೀರಾ?
Please.
Have you paid the process fee?
Yet not after.
Pending consideration of IA 1/25, the petitioner is permitted to comply with the objections
In the course
which
of the day,
resulted in the petition being dismissed. Released on 11th March.
31. Prithviraj Hittalmani.
Lord, the petitioner is seeking for quashing of the impugned endorsement passed by the third respondent, my lords, rejecting the admission of the petitioner to the first year LLB course.
That's one submission, my lords.
Matter, my lords, the respondent number 2 is university, my lords, but the notice was served on government.
ಆಯ್ತು ಸರ್ವ್ಡ್ ಅಂತ ನೀವ್ ಯಾರಿಗೆ?
For respondent number 3, my lords.
ಕಾಲೇಜ್
Please, my lords.
ಏನ್ ವಾಟ್ ಇಸ್ ದ ಪ್ರಾಬ್ಲಮ್?
ಏನದಂತ ಗೊತ್ತಿಲ್ಲ.
ಇವ್ರು ಕೇಳೋಣ ಇರ್ರಿ, ನೀವೇನ್?
My lords, he had taken admission, my lords. My lords, may kindly see page 19, annexure E, application.
ಏನ್ ನಿಮ್ ಇದೇನು? What is it that you have passed?
Lord, interim order is already granted.
Interim order is there, my lords.
You have 3-year course.
They have issued identity card also, my lords. Page 23.
Job oriented pre-university diploma course.
JOC.
JOC. JOC has been held to be equivalent.
ಏನ್ ಅನ್ನೋದು
ಗೊತ್ತಿಲ್ಲ. ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ನಾನು ಯಾರ ಹೆಸರು?
ಸೀನಿಯರ್
Shri K.L. Patil accepts notice for respondent number 2. Registry direct print his name as such. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that though the petitioner has completed vocational education by taking up a job-oriented
Course.
pre-university diploma course in the Government Pre-University College Shumaga, which is a 2-year course, the same has not been taken to be equivalent to PUC for the purpose of admission into a 5-year LLB course. It is in that background that the petitioner is before this court. This court, as in various matters,
At page 24, my lord, my lordship's judgment.
this court, by its order dated 9th December 2024 in WP number 313737 of 2024, has held that the JOC court can be considered to be equivalent to the PUC course. In that view of the matter, the rejection by the respondent number 3 of the petitioner's candidature for first year LLB of 3-year course, 5-year andre
3 years, my lord. 3 years course.
years ಹೆಂಗ್ ಆಗುತ್ತಪ್ಪ SLC plus ಇದು ಬರಲ್ಲ.
But he has completed BBM.
ಎಲ್ಲಿ ಡಿಗ್ರಿ ಎಲ್ಲಿದೆ? 3 year ಗೆ
Annexure
ಡಿಗ್ರಿ
D, my lords. Annexure D, page 15.
N plus 2 plus 3.
ಮಾಡಿದ್ರು.
ಈ ಕಡೆ ಬರ್ತೇವೆ.
ಏನ್ ಬಂತಲ್ಲಿ? Candidature for admission to first year of the 3-year eligibility course is not sustainable. His further submission is that the JOC certificate has been considered to be valid for the petitioner to be admitted to the Bachelor of Business Management course, being a 3-year degree with the Coimbatore University. The petitioner having cleared the 3-year undergraduate course had applied for the first year of the 3-year LLB course. The aspect of the equivalency has been considered by this court in detail in the aforesaid judgment in Rakesh Shetty's case. And this court has come to a categorical conclusion that once a first degree certificate is obtained and the GOC course or any other course is treated to be sufficient qualification for taking up the first degree, the university cannot now turn the clock back, and the college or the university cannot now turn the clock back and contend that the JOC course is not equivalent to the PUC course and deny the admission when the petitioner has completed his degree and applied for the LLB course. In that view of the matter, I pass the following order. Writ petition is allowed. Certiorari is issued, so and so endorsement at annexure A is quashed. A mandamus is issued directing respondent number 3 to forward the candidature of the petitioner for consideration for admission to the first year of the 3-year course, which shall be considered by respondent number 2 in terms of the decision dated 9 December 2024 in WP number 31737 of 2024, and necessary orders passed within a period of 30 days from the date of receipt of a copy of this order. The university is directed to forward a copy of the order dated 9 December 2024 in WP number 31737 of 2024 to all colleges coming under his jurisdiction by email and register post acknowledgement due, so that these kind of litigations are avoided in the future.
Grateful.
Pending I stand disposed.
32, J. Chinmat.
Petitioner is owner of land bearing survey number 76, Lords, which totally measures 31 acres, 36 kuntas, Lords.
No interim relief.
No, interim relief. Interim relief also. Lords, only bifurcation of the property,
Alright,
Lords,
you
because
very
4 acres, 32 guntas, Lords, has been acquired by National Highway. Lords should kindly see.
That your lordship, annexure F your lordship may kindly see.
Instruction idea.
Correct.
ಹೇಳಿ.
Notice.
The annexure B may kindly be seen for a moment.
Hmm.
Annexure B, my lords, page 34.
Hmm.
My lords, my name appears, my lords, for 17 acres in column number 10, my lords. My name appears, my lords, for 17 acres, 4 guntas of land. Then, my lords, the name of the national highway, my lords, jointly appears for 4 acres, 32 guntas of land.
Hmm.
I said, my lords, since the two record of rights, my lords, are supposed to be given. Annexure C, my lords, is a sketch. It bifurcates my land in between two, my lords. 76. I am the owner of survey number 76. So 76, my lords, in between the national highway runs. So my land has been divided into two parts. So they are supposed to issue 3 record of rights, my lords, 2 in my name, 1 in the name of record of in the name of national highway. They don't do it, my lords. I file a representation. Then I file a writ petition before this honorable court. This honorable court, my lords, by its order dated 26 June 2024, was pleased to issue the directions. Paragraph 5, page 39, my lords. It is needless to mention that when the citizen like petitioner or petitioner's property acquired or utilized by the government for formation of road, same shall be in accordance with law, and the petitioner is entitled to enjoy his property by virtue of constitutional right. And in the present case, petitioner having secured the property by virtue of registered sale deed, the remaining extent of land is sought to be mutated in his name. That was a positive direction given. Now, my lords, what they do is annexure E, my lords, page 41. My lords, kindly see. 4th column, my lords, Durasti Madabekada Kshetra column 3. My lords, got it, my lords. They make it 0, my lords. 21 acres, 36 guntas, my lords, is total extent. And my lords, my name should have been appeared for 17 acres, 4 guntas, they make it 0. And national highway also, my lords, they make it 0. Then they issue an endorsement at annexure F, may kindly be seen. Page 42, last paragraph. ತಿದ್ದುಪಡಿ ಪಹಣಿ ಪತ್ರಿಕೆಯಲ್ಲಿ ದಾಖಲೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಪಹಣಿ ಪತ್ರಿಕೆ ಕಲಂ ನಂಬರ್ 9ರಲ್ಲಿ ಸ್ವಾಧೀನದಾರರ ಹೆಸರುಗಳಿದ್ದು ವಿಸ್ತೀರ್ಣ 000 ಅಂತ ಇರುತ್ತದೆ. ಆದ್ದರಿಂದ ಪಹಣಿ ಕಲಂ 9ರಲ್ಲಿ ವಿಸ್ತೀರ್ಣ ನಮೂದಾಗದೇ ಇರುವ ಕಾರಣ ಪೋಡಿ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಸಾಧ್ಯವಿರುವುದಿಲ್ಲ. Then, my lords, may kindly see page 44. Page 44, record of rights. The measurements, my lords, at column number 10, column number 9, my lords, is made 0. So my lords, the direction is for them to affect and give different record of rights. They make it 0 and issue an endorsement that it is not possible.
I will get instructions. I will get instructions.
Last occasion also they took time.
Because your lordship, it is entered, your lordship, as per MR number. Unless you question that, your lordship, before the competent court.
MR number
Yes.
2425 has been entered by you.
Yes. Annexure
Your own accord.
annexure
No
for a
moto,
moment, your lordship.
without any application.
Annexure your lordship for a moment.
Earlier, it used to be 17 acres, so and so.
Yes.
Lords, page number 34, 2 MRs are already there. They are only formally supposed to issue separate record of rights.
For a moment, annexure your mechanism.
Yes.
That your lordship, column number 10.
Yes.
It was MR number is mentioned, your lordship. In that, your lordship, in person of that, 0 mentioned.
They make it.
So, your lordship, he has to challenge that MR number.
Why?
Because your lordship, it is effective right to by virtue of that, your lordship, it is mentioned.
This MR number has been done in pursuit of mandamus which has been issued by the
Yes.
court. To give him 3 act on his representation.
Only to consider his representation, your lordship.
0 ಮಾಡ್ಬಿಟ್ರೆ.
Only to consider his representation, your lordship, you have issued this endorsement. So, your lordship, so I made a submission, I will get instructions.
ಏನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಅಂತ ನಾವು
What? Because in that, your lordship, podi madak ಬರಲ್ಲ ಅಂತ ಬರೆದಿದ್ದಾರೆ.
There was a positive direction.
The name of the petitioner had been entered into in the RTC for 17.04 acres in survey number 76 of Dharwad. ಇದೆಲ್ಲಿದೆ?
Lots of
76.
ಗ್ರಾಮ ನುಗ್ಗೆಕೆರಿನ ಏನಿದು?
ನುಗ್ಗಿಕೇರಿ.
Hobbli Dharwad, Taluka Dharwad, District Dharwad. In pursuit MR H 26 of 2017-18 dated 1/6/2018, the name of the NHI was entered into in respect of 4 acre 32 guntas in pursuit of MR T 18 of 23-24 dated 19/1/24. The property of the petitioner having been bifurcated by the national highway into 2 portions, both the portion being situated on either side of the national highway. In order to better use the said property, the petitioner had made a representation to the respondent which was not considered, And as such, the petitioner approached this court by filing WP number 103538 of 24, which came to be disposed on 26 June 2024, directing the response to consider the application and representation submitted by the petitioner in that regard. In persons thereto, vide the proceedings before the Kandaya Adalat conducted on 28/8/2024, the extent of land has been reduced both for the petitioner as also for NHA to 0, and a mutation has been effected in the RTC as per MRT 11 of 2024-25, dated 29/8/2024, reducing the extent of land to 0. However, in column number 9, along with the name of the petitioner, an extent of 17.04 acres has been mentioned.
In column number 11, Your Lordship, ಭೂಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆ ಚಾಲ್ತಿಯಲ್ಲಿರುತ್ತದೆ. It is mentioned.
ಎಲ್ಲದಕ್ಕೂ ಭೂಸ್ವಾಧೀನ ಇದೆಯಾ?
ಗೊತ್ತಿಲ್ಲ.
And for that, I need separate RTC.
That is ಭೂಸ್ವಾಧೀನ ಚಾಲನೆಯಲ್ಲಿದೆ, but notification ಕೊಟ್ಟಿಲ್ಲ, extent ಕೊಟ್ಟಿಲ್ಲ. Our direction was for both. A column number 11 indicates that it is only only indicates that land acquisition proceedings are in progress. However, there are no details given as regards the acquisition notification, including the date and extent of the acquisition proposed. The Principal Secretary of Revenue Department is directed to look into this aspect and cause necessary entries in this aspect in all revenue records if there is an acquisition proposed. Insofar as the petitioner's case is concerned, though the extent of 17.04 acres is mentioned in column number 9, in the relevant column as regards the extent, it has been shown as 0. It was required for the respondents to have acted in terms of the representation and the directions issued by this court. In WP 103538 of 2024, caused a survey of the property conducted for the and Durasti proceedings, bifurcating the land of the petitioner and the land of the NHAI, and issue and carry out necessary mutation in the RTCs. The same not having been done, the respondent authorities have reduced the extent of the property of the petitioner to 0. This, being a serious issue, would have to be explained by the concerned authorities. Hence, an affidavit is directed to be filed by respondent number 3 and 4, indicating as to how this has occurred. It is on the basis of the explanation that further action would have to be taken. Released on 20th March.
For further hearing.
ಅಲ್ಲೂ ಅದೇ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಂತ ತಗೊಂಡ್ ಬಂದು ಇಲ್ಲಿ ನಿಮಗೆ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದ್ದು, ಇಲ್ಲಿಂದ ತಗೊಂಡು ಹೋದ್ರೆ ಅಲ್ಲಿಗೆ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ.
Only small issue, Lords.
Only small issue, ಎಲ್ಲ ಸ್ಮಾಲ್ ಇಶ್ಯೂ ಅಂತಾನೆ ಹೇಳೋದು.
ತಾವಿದ್ರೆ ಕರೆಕ್ಟ್ ಆಗ್ಬಿಡುತ್ತೆ. My lord is there, my lords, things will be settled correctly.
Okay, for further hearing.
Great.
My lord, kind permission. Serial number 30, it was dismissed and I have filed for recalling application. My lord has directed to pay the PF for respondent number 5. My lord's only technical difficulty is unless the matter is restored, I can't.
ಅದಕ್ಕೆ we have permitted you to file.
Permitted to. I'll pay the PF.
You pay it and 12th ಏನೋ ಇದೆ ಅವತ್ತು ಹೇಳಿ.
One matter, my lords, I had moved at 2:30, my lords, in the morning. But I'm told that, my lords, one matter I had moved at 2:30, my lords, tender matter. But my lords, that memo is not come is what I'm told.
ಎಲ್ಲ ಮೆಮೊ ಹೋಗಿದೆ.
One more memo I'm submitting
memo,
as an abundant precaution because they are unable to find the memos.
Yes, madam.
My lords, if I may make a mention.
Serial number?
Number 4, 43, my lords.
ಏನು ಇಬ್ರು 43 ಅಂತ ಇದೆ.
It's under orders. My lords.
ಎಕೋ ಬರ್ತಾ ಇದೆ ಅನ್ಕೋ. Yes, 43 ಏನು?
My lords, it's for orders. My lords, may minor objections have been removed. My lords, if my lords may be accommodated at 2:30, my lords, to hear it or notice.
We don't know. For 2:30, there are 50 memos which have been moved. If it reaches, yes. Otherwise, no.
Serial number 71, my lord. Another connected matter is there. It may be taken up.
71 connect with so and so, released on 28th March.
With lordship's kind permission, my lords.
Connected matter date was given on 25th, my lord.
25th March,
Please, my lord.
25th March.
Please. Interim
Second
order.
list,
With
serial
Lordship's
number.
kind permission, my lords.
Second list.
Yes,
serial
just a
number.
moment, please.
Second list, serial number 18, my lords. Can it be next week? Can you?
Second list, ella jana. Yes.
My lords, serial number 38, my lords, needful has been done, my lords. Notice may kindly be issued to R7, my lords.
38, counsel for the petitioner submits that process fee has been paid, registry is direct verify and issue notice to unserved respondent written by 24th April.
Obliged, my lords.
On submission. List to serial number 5. The notice was deferred insofar as private respondents are concerned. And the lordship has directed me to secure the record since there is a delay of 19 years in challenging the land tribunal order. Based on the statement given by the petitioner, my lord, the land tribunal has rejected. It has been listed in B group. Allah, other 19 years delay.
68 one.
68.
That was my lord has pleased to heard the matter. That is pertaining to my lord, a backward class student from other state.
238.
And NEET, once some NEET agency.
230 list.
Please.
ಸೆಕೆಂಡ್ ಥರ್ಡ್ ಎರಡು ಲಿಸ್ಟ್ ಹೋಗಿದೆಲ್ಲ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಥರ್ಡ್ ಲಿಸ್ಟ್ ಎರಡು ಹೋಗಿದೆ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಎಲ್ಲ ಡೇಟ್ ಕೊಟ್ರ ಅಂತ ಹೇಳಿದ್ರೆ ಸರ್. ಸರ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್
ಇಲ್ಲ ಬರ್ತಾರೆ 230 ಕೆಲವೊಂದು ಪಾಠ ಹಿಡಿದೆ ಅದು ಮುಗಿಸಿ
ಅದೇ ಹೇಳಿದ್ರು
12 ಮ್ಯಾಟರ್ಸ್ ಇದೆ. ಯಾವ್ದು ನಿಮ್ದು ಇದೆ ನೆಕ್ಸ್ಟ್ ಇದೆ ತಗೊಂತೀನಿ.
ಸರ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಎಲ್ಲ ಹೋಯ್ತಲ್ಲ. ಹಾ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್
T7 ತಗೊಂತೀನಿ. ಇಲ್ಲ ಮುಗಿದಿನ ತಗೊಂತೀನಿ, ವೇಟ್ ಮಾಡಿ ಸ್ವಲ್ಪ.
The petitioner seeks for and is granted 10 days time to make payment of necessary process fee in respect of service of notice. Out of court language andre ಏನು? So you have to send it in RPID ತಾನೆ? RPID ಮರಾಠಿಯಲ್ಲಿ ಬಂದಿದೆಯಾ? But seeks for and is granted 10 days time to make payment of necessary process fee for service of notice in respect to unserved respondent. If needful is done by 14th March, issue notice to unserved respondent written by 29th April. Registry is also directed to put up the postal track record by that date.
ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ?
ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. ಮ್ಯೂಟ್ ಇದೆಯಾ ನೋಡಿ. ರೆಡ್ ಏನದು?
ರಿಫ್ರೆಶ್ ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ?
ಮಿಸ್ಟರ್ ಪಾಟೀಲ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
It's audible.
Audible. Purnima?
Sir. Sir, clarity ಇಲ್ಲ ಸರ್, ವಾಯ್ಸ್ ಅಲ್ಲಿ ಕಟ್ ಆಗ್ತಾ ಇದೆ.
ಕಟ್ ಆಗ್ತಾ ಇದೆಯಾ ಇವಾಗ? ಅಲ್ಲೇ ನೋಡಿ ಚೆಕ್ ಮಾಡಕ್ಕೆ ಹೇಳಿ ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ. ಚೆಕ್ ಮಾಡಿ ಮತ್ತೆ ಲಾಗಿನ್ ಆಗಿ.
230 matter 59 further hearing Mallikarjun B. Madanalli.
Lord, in this matter, my lord, the lordship has directed me to ascertain the vacancy. I have secured the list, my lord. There are about nearly 50 vacancies out in the entire Mudal Taluk. I will place before the court. Wherever they choose, they will make.
ಇವ್ರು ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
ಇವ್ರು 15 ಮಂದಿ ಇದ್ದಾರೆ. 50 ಇದಾವೆ. ಎಲ್ಲಿ ಬೇಕಾದ್ರೂ ಹೋಗಲ್ಲ. ನಮಗೆ we are not objecting in so far as they are concerned.
ಮತ್ತೆ ಇನ್ನೇನಂತ? Close.
Yes. I will, along with the memo, I will place the vacancy.
Record your submission.
Yes, madam. Yes, madam.
ಏನಪ್ಪ?
Submission, my lord. Since because of the vacancy, my lord, I am a.
You will now that they will be transferred, you will be allowed to recruit. ಅವ್ರು ಟ್ರಾನ್ಸ್ಫರ್ ಆದ್ಮೇಲೆ ನೀವು ರೆಕ್ರೂಟ್ ಮಾಡಿ.
Recruitment, my lord. Till the completion of recruitment, they may be continued.
Till completion of the recruitment, my lord, they may be permitted to continue.
They are supposed to continue because, my lord,
ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲ ಅಲ್ಲಿ ಸುಮ್ಮನೆ ಯಾಕೆ?
they are now working, my lord.
ಹೋಗ್ತಾ ಇದ್ದೀರಾ?
ಹೌದು, working, they are working.
ಮಾಡಿ. ನೀವು ಎಷ್ಟು ದಿನ ತಗೊಂತೀರಾ ರೆಕ್ರೂಟ್ಮೆಂಟ್ಗೆ?
At least the government permission under 3 to 4 months. 3 to 4 months it's required, my lord.
3 months. Petitioners are before this court seeking for the following reliefs in each of the above petitions. The dispute arose between the parties mainly on account of lack of confidence and miscommunication between the teachers and the management of the school. Though several allegations were made by each other when the matter was taken up for consideration, on inquiry as to whether the matter could be amicably resolved, both the councils submitted that they will endeavor to try and resolve the matter. Both the councils, upon instructions, thereafter submitted that both of them are willing to withdraw the allegations made against each other, as also by further submission was made by the teachers that there being lack of confidence, they would wish to be transferred to any other school admitted to grant in aid. Council for the school, for the management, also acceded to the said request. In that view of the matter, learned AGA was directed to secure instruction if there are any vacancies available within the said district, taluk, in other schools admitted to grant in aid, where the teachers could be transferred. Learned AGA upon instructions today submits that there are 50 vacancies in different schools.
Both primary and higher.
In the primary and high school level, in the very same, in Mudol Taluk. He submits that taking into consideration the convenience of the teachers and taking into account their preference, 15 of the teachers who are before this court in the above matters would be transferred to the respective schools of their choice.
Yes.
Learned Counsel for the Management submits that since the teachers are being transferred and the exams are now scheduled from the 10th of March, until the recruitment is completed, the teachers would have to continue to render their services in the school, and thereafter they could be transferred. And in this regard, he submits that recruitment of new teachers would take about 3 months' time to be completed. In that view of the matter, the above being an amicable resolution which has been arrived at between the parties, I have the considered opinion that that passing of necessary direction in that regard would resolve the matter. The transfer orders
in first case
transfer,
ಅಷ್ಟೇ transfer.
59 ಅಲ್ಲಿ prayer A, writ petition is allowed, certiorari is issued, so and so is quashed. Next one, Pudi.
They are seeking relief against the management. Mandamus.
ಏನಂತ? ಇದು withdraw.
ಹೌದು.
WP number 102824 of 2021 stands withdrawn. Memo ಹಾಕಿ. ಎರಡೇನಾ ಇನ್ನೊಂದಿದೆ?
ಅದು ಸೇಮ್ ಇನ್ನೊಂದಿದೆ.
ಅದು
3730 ಅದು
37370 is dismissed as withdrawn. The petitioners in WP number 104938 of 23 shall continue to work in the respondent institution, respondent number 5 institution, for a period of 3 months from today. That is until
3 months from today, till completion of the recruitment process.
ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಅದು ಬಿಡ್ತಾ ಇಲ್ಲ.
ನಾನು ಅದನ್ನ ಹಾಕಿ ಗವರ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಟು ಗಿವ್ ಪರ್ಮಿಷನ್.
ಅದು ಹೇಳ್ತೀವಿ. 3 months from today, that is until 31st of May 2025. Upon completion of their tenure on 31st May 2025, respondent number 3 effective till 31st. Learned AGA is directed to furnish a list of schools with the details of the vacancies to the petitioners within 1 week from today, that is on or before 7.
Today itself.
Learned AGA has today submitted a list of vacancies
will be submitted to
the petitioner.
Yes.
The petitioners to convey their respective preferences to the third respondent. Third or fourth?
Third respondent.
BO na DDPI?
BO.
The fourth respondent, BO, by 7th March 2025. Their permission are kodbek for recruitment.
Recruitment from proposal has to be sent by them. Thereafter, my lord, it will be.
Yaar kodbeku?
Deputy Director, that is the DDPI.
DDPI. The submission of the Council for the Management that a proposal for fresh recruitment would be submitted to the second respondent by 7th March 2025 is placed on record. If the said representation is received by the second respondent by that time, the second respondent is directed to process the same and afford necessary approval in relation thereto within 15 days from then, that is by 21st March 2025. The respondent number 5 is at liberty to cause the recruitment of fresh teachers in the time frame that it so chooses. The tenure of the petitioners would, however, come to an end by 31st May 2025.
Time bond, till today they have not issued the time bond. More than 10 years they have worked. Time bond ಕೊಟ್ಟಿಲ್ಲ. Time bond ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ implement ಆಗಿರೋದು.
It's not just government.
ನೀವು ಕಳಿಸ್ಬೇಕು, ನೀವು ನಾವೇನ್ ಕೊಡಬೇಕು?
ನಮ್ದು ರಿಕ್ವೆಸ್ಟ್ ಅದೇ ಇದೆ.
Since they are themselves as making SR corrections in the SRs and all these things, my lords. They are making corrections in the SRs. The SRs are with them only, my lords.
ನೀವೆಲ್ಲ ಕೊಟ್ಟು ಮುಗಿಸ್ಬೇಕಲ್ಲ.
ಅಲ್ಲ, SR ಅವ್ರ ಹತ್ರ ಇದೆ. SR ದಲ್ಲಿ ತಾವ ತಿದ್ದುಕೊಂಡು ಎಲ್ಲ ಇದನ್ನ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅದಕ್ಕೆ ಅದು ಪೆಂಡಿಂಗ್ ಉಳಿದದ್ದು.
ನಿಮ್ ಪ್ರಕಾರ ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿ ಅಪ್ಲೋಡ್ ಮಾಡಿ, ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತಲ್ಲ.
ನಾವು ಮಾಡಿ ಪ್ಲೀಸ್.
The respondent management is directed to upload the necessary SR with the correct details, with appropriate increments and the like, in respect of each of the above petitioners on or before 30th April 2025.
Please.
The affidavits, the affidavits of the teachers is taken on record.
Please.
Pending IAS do not survive for this consideration.
60, Omkar Desai.
Lord, in this, the lordships had directed me to secure instructions from the state government. Lord, as per the instructions given, Lord, since 2006, after incorporating of the Act and the rules, and in view of the NCISM having been, my Lord, since from the 2020, the entire process is controlled by the KES and the central government at the NCISM. Every year, my Lord, the state government role is only with regarding to issuing the notification insofar as seat matrix is concerned. Every year it is notified. Except that role, my Lord, state has no other role insofar as admission and other factors concerned. The entire thing has to be is controlled by the NCISM, and the norms which have been followed, that has to be considered.
Yes, affidavit.
I have received the scanned copy, my Lord.
Kodi scanned copy no aaytu. As long as some information comes, we are happy. Yes, what is the stand now? Why regulations have not been made?
So far as regulation, my Lord, we have already framed the new regulations, my Lord, in the year 2024. And my Lord, it is specifically said that, my Lord, the students shall have to be admitted only through online CET. That is, my Lord, through counseling. So, my Lord, that is a stand taken by the NCISM.
Where is the regulations?
So, regulations are.
You had issued guidelines.
No, my Lord, we have a guideline. So, my Lord.
Where is the regulation?
Regulations ida 2020.
Last time ತೋರಿಸಿದ್ದು guideline, regulation ಅಲ್ಲ.
2020 regulations ಇರಬೇಕಲ್ಲ.
ಇದ್ರೆ ಕೊಡಿ, ಯಾರಿಗೂ ಗೊತ್ತಿಲ್ಲ, ನಿಮ್ಗೆ ಒಬ್ಬರಿಗೆ ಗೊತ್ತಿರೋದು. ಎಲ್ಲರೂ ಇಲ್ಲ ಅಂತ ಇದ್ದಾರೆ.
2020 itself regulations ಎಲ್ಲ ಆಗಿದಾವು.
So if the regulations are there, why are you not disclosing it to everybody?
No, it is there, my Lord. It is on online also, in the website of NCISM also.
Sir, only UG.
Which is a relevant regulation? What is the issue in this matter?
Rule number 8.
Rule number 8.
What, my Lord, framed under new Act 2020 Act.
Lord, I will come to that point, my Lord. Rule number 8, my Lord.
And the exercise of powers under section 55 of the NCISM Act 2020.
Lord, section. This 8.
Page 5 nodi.
My Lord, before that, my Lord, there is an amendment
My lord, my submission is this, my lord. My lord, NCISM Act has come into existence in the year 2020. CCIM Act was in force.
Yes.
My lord, after repealment of this particular act, my lord, NCISM has come into existence, and my lord, section 59 of NCISM has specifically says that till new rules are framed, my lord, we are going to adopt the earlier rules. My lord, that
Yes, but how long will you have that?
no, my lord. That is why, my lord, in the year we are now, my lord, we have framed a new rules. That is in the year 2024. In the year 2024, my lord, the
1st October 24.
this is, my lord, insofar as 22, my lord. Aurdu 22, 23 matra, namdu, my lord, in the year 2018, my lord, we were adopting the earlier rules, my lord. That is, that I have produced before this court. My lord, rule number 8.
You are the premier organization dealing with education in health sciences across the country. And you take 4 years to make one regulation.
My lord, we had
Putting upon the lives of thousands of students and hundreds of colleges. Apart from professors and teachers, teaching, non-teaching staff.
My lord, even in new rules also, my lord, there is no change in the, my lord, rules. But my lord, we had adopted the rules, earlier rules, my lord.
Again, regulation 8 and
regulation 8, mode of admission, my lord. Mode of admission.
Minimum
Page number 3, my lord. Page number 3. 3.
3 is 2018.
Please, my lord. This was in force, my lord, earlier.
Yes.
My lord, rule number 8, mode of admission, my lord. Next, my lord, 8.2. There shall be uniform entrance examination to all medical institution at the post-graduation level, all India post-graduation, so and so, for admission to post-graduation course in each academic year, and shall be conducted by an authority designated by the central government, provided so and so, my lord. In order to be eligible admission to post-graduation course for academic year, it shall be necessary for a candidate to obtain a minimum marks of 50 percentile all India graduate entrance test held for the said academic year. My lord, before that, my lord, provided that all India Ayush post-graduation entrance test, AIA, PGCET, shall not be applicable for foreign so and so, my lord. My lord, if this specifically says further, my lord,
only through central counseling or the state authority. It is only by way of guidelines. They come up saying that all the seats across all the quotas will have to be.
My lord, even in guidelines also, my lord, there is no specific guideline, my lord, which says that these students have to be admitted, my lord, indirectly. That is by way of, my lord, direct admissions to the colleges.
Prohibited. Any other mode of admission is possible. That is the problem. That is why you have not been clear on things. You are the person administering this. If you are not clear, all these issues happen.
Lord, the subsequent rules, my lord, now they are very much clear that the students shall have to be admitted only through counseling, my lord. That is.
Yes, then again the issue, and your Murnalak idavalla. The issue is if vacancies iddavag yen madadu. The KEA should continue to be in operation till all the students who have enrolled onto the KEA are given the seats or the seats are filled up, either of these two. KEA is saying, okay, online, I'll do my 5 rounds, then I'll do one mop-up round. I'll mop up everything and give them whoever comes. Then there are students who are left, seats which are vacant, they'll go directly to the college, they get admission, which you say is not correct. And KEA says, I am finished. No, don't ask me. You're dealing with life of students, their next education life and further life you're dealing with. You can't be so, we can use a lot of words, but we are not using those words.
No, my lord, when the time is given for them for admission of students, my lord, whoever likes that college, my lord, they will take admission, my lord.
Yes, but they like.
That has to be done within time period, my lord. If
everybody wants to go to IIT, but everybody doesn't get IIT.
Yes, my lord.
IIT try ಮಾಡ್ತಾರೆ ಸಿಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ next option ಹೋಗ್ತಾರೆ.
But for that, every my lord, process, my lord, there is a time limit, my lord. That is why the KA is taking care of it.
Yes, but finally, what is the end result is you are leaving some students without admission and some colleges with vacant seats. We understand if all students had got admission, no problem.
Please.
We also understand if all seats were filled up in all colleges, then also no problem. Colleges fill up ಆಯ್ತಪ್ಪ ನೀವು ಇಲ್ಲ ಹೋಗು ಅಂತ ಹೇಳ್ಬೋದು. ನೀವು ಇವಾಗ ಮಾಡಿರೋದು students are also not admitted, seats are also vacant. Then those students go to the college charges double the fees and says management quota and admits them. Then they come for examination, you say no, and they come before this court.
But only for that purpose, my lord, this particular online or through CET, my lord, it is made mandatory, my lord. That, my lord, they will charge exorbitant, my lord, fees on the students.
Yes.
Keeping in that, my lord, mind,
You are the
my lord,
cause for it.
my lord.
You are the cause for it. You should issue direction to your recruiting agency, KEA, that until everything is completed, they should function. Since you are not done, we will do it.
My lord, this is a policy matter, my lord. The rules and regulations that have already been framed, my lord, I am making submission before this court. And even new rules also, my lord, this says same thing, my lord.
Yes, totally. Purnima, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
Yes, sir.
ಕೊಡಿ ನಿಮ್ದು ಏನು ನಿಮ್ದು
ಏನೂ ಇಲ್ಲ ಸರ್.
role of KEA comes to an end. That is the operative word. You are doing a good job. Only thing we are saying is you should continue to do that job until it is completed.
The counseling lots and allotment of seats depends upon the option entry given by the candidates and availability of the seats. If no candidate is opting for a particular seat in a college, that can't be allotted at all. And similarly, a person who wants to get that seat, but does not register with KEA for counseling, can't be allotted again.
Second one, we agree completely. If he is not registered, no. The first one, if he doesn't get it in that college, should be given an option to make a change.
There are chronological options given. If option 1 is not available, option 2 is available, then will be allotted that seat. That's the procedure for counseling. And even now, 7 to 8 rounds of counseling are being conducted, so that some students get at least whatever the remaining vacant seats are there. And even after that, there's still remaining vacant. Even this first round, when it has taken place, after 2 months of that first round, this 8th round is being concluded. Then the 2 months of classes have been already gotten over. By the time the student comes from 8th round of counseling, and if this is to be continued until all seats are to be filled up, it becomes an unending process. That is the practical difficulty that.
Then you have the counseling sessions closer, not with that gap.
That's the cutoff date, whatever is given by NCISM. Till then, whatever rounds of counseling can be completed. Till now, KEA is doing that.
How long does it take for each counseling session?
At least 2 weeks.
Why 2 weeks?
Start to end, because option entry is there. 2 to 3 days is given for option entry, then for allotment, and after that payment of fees is there, and after that to collect admission order and to report to the college. only after reporting to the college date is over, my lords, then the KA will come to know how many seats are vacant for second round. Because some students get the report to the college, some students do not. And those who do not, my lords, those seats again fall vacant and they'll have to be included in the second. That is how, my lords, the process works. So as per my instructions, this is, my lords, is happening. And then there's so much time gap between the first and the last round of counseling, my lords. Who join later, lords, miss out on the
So
classes.
what can you do so that this kind of situation is avoided? Think of, all of you are coming up with problems only. None of you are having solution-based approach. This is my problem, that is my problem, that is my problem. Who will look at the student's problem? You are all there to look at that, not your own problems. Without those students, you don't need to exist. It's not that because of you, the students exist. Because the students have to be given admission, you exist. Without the students, KEA has no substance at all. And NCIM will not exist. All the university will not exist. All three of you exist for the students and the colleges. Please remember that. You as lawyer and we as judge won't exist without litigants. Litigant ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಮ್ಮ ಇಬ್ಬರಿಗೂ ಕೆಲಸ ಇಲ್ಲ. ಸ್ಟೂಡೆಂಟ್ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ ಯಾರಿಗೂ ಕೆಲಸ ಇಲ್ಲ. ಅವ್ರನ್ನೇ ನೋಡ್ಕೊಳಲ್ಲ, ನನ್ನ ಪ್ರಾಬ್ಲಮ್ ಇದು ಅಂತ ಹೇಳ್ತಾ ಇದ್ರೆ ಎಲ್ರು. And you keep on putting the student into more trouble. You build up your administration better, you get more people. Why 2 weeks? Do it in 1 week. Something you have to work out with. ಕೌನ್ಸಿಲಿಂಗ್ ಫೀಸ್ ತೊಗೊಳಕ್ಕಾಗತ್ತೆ, ಅವ್ರ ಯೂನಿವರ್ಸಿಟಿ ಫೀಸ್ ತೊಗೊಳಕ್ಕಾಗತ್ತೆ. ನೀವೇನಾದ್ರು ತೊಗೊಳ್ತೀರಾ? ನೀವೇನಿಲ್ಲ ಅನ್ಸುತ್ತೆ. You have to do that. Now, what do we do with these students who have studied, who have done? Because all of you say it's not my problem. I have my own problem. Solution could affidavit andre no. My role comes to an end. I have fixed it is for KEA to do. Whatever both of them do, university will do. All three of you don't talk to each other. This is not the way it can be done. The education matters. And one student, if he doesn't get it, his whole life, what he has planned will go for a toss. If he gets what he gets in, then he will be a good doctor or whatever. Maybe. Can't say. ನಿಮಗೆ ಸೀಟ್ ಲಾಗೆ ಡಿನೈ ಮಾಡಿದ್ರೆ ಕೌನ್ಸಿಲಿಂಗ್ ಸೆಷನ್ ಓವರ್. Have some human approach. Look at it. ಇವಾಗ್ಲೂ ನೀವೇ ಮಾಡ್ತೀರಾ, ನಾವು ಮಾಡ್ಬೇಕಾ ಹೇಳಿ?
Lord, any guidelines may be issued by this honorable court, my lord, because now, my lord, as of now, they say that we have already framed our rules. So, my lord,
That is the problem. But then when we say we have to observe your conduct
no, my lord, we have
of NCSM, KEA and the university, who have the petitioners are before this court seeking for the following leaves. The first petitioner in WP 101187 of 2024 is a student. And next one could. And second petitioner is a college. The petitioner in WP 105635 is a college. And the petitioner in WP 102480, petition 1 to 3 in 102480 are students. Petition number 4 is the college. The facts in all the matters are more or less similar, in as much as the student had approached the college for admission, and the college granted admission to the said student. Thereafter, when the student sought to appear for the examination, the student was denied the right to take up the examination on the ground that the admission of the student is not through the Karnataka Education Examination Authority, which is the authority and designated by the National Commission for Indian System of Medicine to be the counseling authority as also the authority to approve the admission and allot the students to different colleges. The contention of the students is that the students had registered themselves with the KEA, that some of the students had registered with the KEA, despite having been so registered and having undergone counseling, they were not allotted any seat in any college. And after they having come to know that there was vacancy in a particular college, they had approached that college who had granted them admission. In respect of some of the other students who had not registered themselves with the KEA, they had approached the college directly and secured admission. It is in that background that the NCISM, KEA and the university were called upon to make their stand clear as to the manner of registration of the student, counseling, allocation and admission. The university, at the very first instance, the university washed off its hands by contending that the university is only to act as per the direction of NCISM and KEA. The university does not handle any admission except the technicalities and procedure thereof once the KEA recommends the admission. The KEA The executive director of the KEA has filed an affidavit stating that it is the authority designated by NCISM and carries out counseling for all students except foreign national in the state of Karnataka. The counseling is held from time to time, and once the counseling is over, the list of allotment is submitted by KEA. The role of the KEA comes to an end, and the KEA as such functions on the directions of the government at the central and state levels and the NCISM. The KEA has no independent decision-making power as regards the allotment of seats remaining vacant after completion of counseling by KEA and or allotment of seat to students who have remained ಯಾವಾಗ ಡಿಸ್ಕನೆಕ್ಟ್ ಆಯ್ತಪ್ಪ
ಮೇಡಮ್ ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗಿದೆಯಲ್ಲ ಯಾಕೆ ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗಿದೆ ನೋಡಿ
ಇಲ್ಲ ಸರ್ completion of counseling of KEA it's coming sir
on completion of counseling by KEA
has no independent power
no independent decision-making power regarding allotment of seats remaining vacant after the completion of the counseling by KEA, and the KEA cannot allot any remaining student to any college, any unadmitted student to any college after the counseling is completed. An affidavit of NCISM has also been filed, affidavit
Please, affidavit.
Stating that detailing out the powers of NCISM and the regulations which have been formulated by NCISM. And in furtherance thereof, it is stated, and in the affidavit it is stated that the regulation of 7/12/2018 issued under the Indian Medicine Central Council Act 1970. Enough, I think. Would be applicable, and in terms of regulation 8 thereof, there has to be a uniform entrance examination to all medical institutions at the postgraduate level, namely All India Ayush Postgraduate Entrance Test bracket AIA-PGET bracket close, and admission shall be conducted by an authority designated by the central government. And in this regard, it is the KEA who has been the designated authority in the state of Karnataka, who is required to carry out the counseling and allotment of the students to the respective colleges. These being the stands of these three institutions who have been vested with the obligation of taking care of the interest of the students and their career, the issues which are involved have not been answered by any of the three institutions. The questions which have come up before this court in several petitions, including this petition, are: one, if a student has been registered with the KEA and has not been allotted a seat in any particular college, even after the completion of the counseling rounds conducted by KEA, what would be the status of that student, even if there were vacancies in a college available after the completion of the counseling rounds? Two, what would be the status of the vacant seats in the various colleges if after completion of the counseling sessions, those seats remain unfilled? These two important questions which arise out of this petition were what were posed to the respective councils for the respondents. However, the answer by each of them is that the university has nothing to do with it. They will act as per the instruction of the KEA. KEA has submitted that they act as per the instruction of NCISM. And within the time period that the counseling is completed, they try to allot seats to the students as soon and as may be possible. The NCISM contending that it is for the KEA to handle the counseling and admission. The NCIM having designated the KEA, it is the KEA's responsibility. It is these aspects which would have to be required to be considered by this court, since interest of large number of students is at stake, and those matters have been coming up before this court. ಇನ್ನೇನಾದ್ರು ಇದೆಯಾ? ಆಮೇಲೆ ಮಾಡ್ತೀವಿ, ಇವತ್ತು ಬೇಡ.
Please.
Heard so and so, reserved.
Obliged, grateful.
That was one other submission made by some of the students is that though they are not registered with the KEA, their marks is much more than the marks of the students who have been allotted seats by the KEA. And despite which, they have not been allotted a seat. ಹೆಂಗ್ ನಿಮ್ಗೆ ಯಾಕೆ ಸೀಟ್ ಸಿಕ್ಕಿಲ್ಲ?
Students allotted are not having 110, 9, 98. These candidates are having 145, 137.
So ನಿಮ್ಗೆ ಯಾಕೆ ಸಿಕ್ಕಿಲ್ಲ? Yes, madam.
These two posts
Not registered, we agree, but registered and not getting a seat.
or number ಕೂಡ ಕೊಟ್ಟಿದ್ದೀವಿ KE registration number along with their marks and everything not.
Yes, reserved.
61 B ಶರಣ ಬಸವ.
ಪರ್ಮಿಟ್ ಮಾಡಿಲ್ವಾ?
ಮಾಡೈತಲ್ಲ.
Daily order ಅಲ್ಲಿ the
101187, my lord.
the students are common order.
Yes.
The students are, respective students are permitted to take up their examination.
On 3rd
The
March.
respective authorities are directed to facilitate the said examination by collecting the examination fee, if not already collected, issuing necessary all tickets, etc. As regard the examination set to commence from 3rd March 2025.
It is amendment as I carried out, my lord. This is.
61 B ಶರಣ ಬಸವ.
Lord, in this matter, the lordships has directed us to ascertain and go through the original document which has been produced with regarding to allotment of plot under the Ashray scheme.
Kupatra.
Yes. On going through that, my lord, it is disputed.
Disputed.
Yes.
Okay.
My lord,
Original ಇದ್ದಂಗಿದೆ ಅಲ್ಲಿ.
ಹೌದು.
ಅದು disputed.
ಅದು disputed. My lord, all that is seen, my lord, then it can be.
Disputed and file your objection.
Yes.
And my lord,
My lord, here,
in annexure C, wherein
Shanavasa, we can only give it to them, ask them what it is. If they are disputing it, let them say why they are disputing, which will be dealt with.
if they are disputing, my lords, I am not saying that. But insofar as annexure C, which is a resolution passed by the Ashray committee, they have observed that already the Kupatra was
Can we
issued.
give a finding on it without taking their say on record? We can't do that. We have to give them an opportunity. We'll give them that opportunity. Yeah, it's not an emergency that we have to hear.
No, no,
Emergency
I'm not-
light, not this.
please.
The AGA, upon taking inspection of the original Akupatras furnished by the counsel for the petitioner and obtaining instructions from the concerned, submit that the Akupatra submitted by the petitioner is disputed.
Disputed. Since my
Has
lord,
not been issued by the concerned
yes,
authority.
yes.
He seeks for and is granted 10 days time to file his detailed statement of objection in relation thereto. The said objections to be filed on or before 14th March, relist on 21st March. Then further hearing,
Interim order.
release from parted, interim order earlier granted is extended till next date.
Please.
Release from part.
52 ಮೃತ್ಯುಂಜಯ ಹಿಡಿಕೇರಿ.
My lords, almost settling. Almost settled.
Almost.
Really pass over. Really pass over. Yes.
ಇವತ್ತೇ ಸೆಟಲ್ ಆಗುತ್ತೆ. Okay. Pass over.
Please.
63 ರಾಜಶೇಖರ್ ಗುರ್ಜಿ.
But some more time, my lord.
Both the councils submit that they will require some more time to report settlement. They seek for 2 weeks' time.
Please, please,
Relist on 21st March.
please.
Please.
64 ರಾಹುಲ್ ಕುಟೋಜಿ.
Please, for petitioners, my lord, this matter belongs to.
You take a next week, your lordship.
There
You
is some
take a next week,
urgency.
your lordship.
From last Thursday, it has been listing, my lord. And there is some urgency, my lord. The petitioners are the agriculturists, my lord. Their pathway has been blocked by the private respondents, my lord. Lord's page number 32 village map is produced, my lord.
22 na?
32,
32.
please, my lord.
Yes.
There are total 7 lands, my lord. The present petitioners are the sublands of the serial number 868, my lord.
868.
Please, my lord.
Yes.
This present serial number, my lord, serial number 882 and 869. The private respondents who have the, my lord,
869.
No, my lord, 868, 860.
68 ಆಯ್ತು.
Please, my lord. 869 and 882, my lords.
882 ಎಲ್ಲಿದ್ಯಪ್ಪ?
There is
882
corner.
ಈ ಕಡೆ ಇದೆ.
Please, my lord. For a moment, my lord, page number 15, my lord. Tishank map I have produced, my lord. Now, my lord, the serial number 882, who is the respondent number 5, my lord. He has converted his land as the non-agriculture land, my lord. Now he has constructed the gutter, my lord, towards the front side, my lord. And
ಎಲ್ಲಿದೆ 882 ಕಾಣಿಸ್ತಾ ಇಲ್ವೇ?
Please, my lord.
ಪೇಜ್ 15 ಅಲ್ಲಿ.
Yes, sir. 883 ಬಾಸ್
883 ಇದೆ.
ಅಲ್ಲಿ ಕಾರ್ನರ್ ಇದೆ, ಅದು ಹೋಗಿದೆ ಸರ್.
882, 868, 869, 872.
ಪೇಜ್ ನಂಬರ್ 16 ಅಲ್ಲಿ ಇದೆ ಸರ್. ಪೇಜ್ ನಂಬರ್ 16.
16.
Please. Photo.
882.
Please. 882. He has converted his land as the non-agriculture land, my lord. And 869, he has fenced his land through the wire, my lord. I have produced the photographs also, my lord. Page number 17, there is the pathway, my lord. Photographs show. Now, my lord, kindly come to page number 18, my lords. There is the district main road, my lords, towards the eastern side of the petitioner's land, my lord. Only from the 4 to 5 feet from the distance of the district main road, my lord, he has now they have blocked their road, my lord.
District road has been blocked.
No, my lord, from the district road to private land is that, my lord, only 4 to 5 feet, my lord.
4 to 5 feet.
Please, my lord. Page number 19, my lords, kindly see the obstruction made by the private respondent, my lord. The gutter has been constructed by the respondent number 4 and land has been fenced by the respondent number 5, my lord. In the corner, my lord, there are totally 7 lands which are at a corner center, my lord. Please, my lord. As per annexure G, my lords, the government.
Mandamus.
But, my lord.
My file is not available, but on his submission, lordship, if he is the private persons you are blocking, he has to file a suit, your lordship.
Access to a public road.
No, according to him, your lordship, the private persons are blocking them, according to the submission, not the public road, your lordship.
Notification ಕೊಟ್ಟಿದಿರಲ್ಲ. Access to public road and
page number 34.
He made a submission that, your lordship.
And water facilities cannot be stopped by anyone.
But your lordship, he is making submission that, your lordship, the private person blocking his land ಅಂತ ಹೇಳ್ತಾರ, not the public road ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ ಅವರು. His land ಅಂತ ಹೇಳ್ತಾರ.
Public road. Public road.
Road ಇರೋದು public road.
Please, my lord. For a moment, my lord, page number.
Direct the response.
Page number 38, my lord.
ಆ ರೋಡ್ಗೂ ಇವ್ರ ಲ್ಯಾಂಡ್ ಮಧ್ಯದಲ್ಲಿ ಬೇರೆಯವ್ರ ಲ್ಯಾಂಡ್ ಇದೆ.
Please, my lord.
They are not allowing them to cross their land to get into the public road.
Please.
Of 5 feet. Irrespective, your notification is there that no restriction can be made as regards public road or waterways.
For a moment, my lord, page number 38, my lord.
The petitioners. The respond number 5 ಹೆಂಗಪ್ಪ AG ಹೆಂಗಾಗತ್ತೆ?
Respond to 1, 2, 3, my lord, 4 and
4 and 5 deferred.
Private parties.
Mandamus ಹೆಂಗ್ ಕೊಡಕ್ಕಾಗತ್ತೆ?
But, my lord, as per the annexure G, my lord, government notification has been issued.
Yes,
please,
that is what we are speaking of.
Please,
but without notice to 4 and 5, this order cannot be passed.
But, my lord, in the similar set of facts, my lord, earlier this coordinate bench has passed the order, my lord. I have passed this last page, my lord. Please, my lord. Similar set of facts, direct to remove the obstructions made by the private respondents, my lord.
In page 23, your lordship.
After getting the report.
Please, in this also, my lord, there is a report, my lord. Annexure 38, my lord, kindly see the page number 38.
38.
In page 23, your lordship, last para is made allegations against the respondent, private respondent.
Page number 38, my lords, from the bottom side, my lord. Second para, my lords. ಸದರಿ ಅರ್ಜಿಯನ್ನು ಕಂದಾಯ ನಿರೀಕ್ಷಕರು ಅಥಣಿ ಇವರ ಮೂಲಕ ಪರಿಶೀಲಿಸಲಾಗಿ ಸದರಿ ಜಮೀನುಗಳು ಅಥಣಿ ನಂದಗಾಂವ್ ಮುಖ್ಯ ರಸ್ತೆಗೆ ಹೊಂದಿಕೊಂಡು ಇರುತ್ತವೆ. ಸದರಿ ರೀಸ ನಂಬರ್ಗಳ ಉತ್ತರ ಮೂಲೆಯಲ್ಲಿ ಹಾದು ಹೋಗಲು ವಹಿವಾಟು ರಸ್ತೆ ಸುಮಾರು ವರ್ಷಗಳಿಂದ ಇರುವ ಕುರಿತು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಸದರಿ ರೀಸ ನಂಬರ್ 869 ಹಕ್ಕುದಾರರು ಸದರಿ ಅಥಣಿ ನಂದಗಾಂವ್ ಮುಖ್ಯ ರಸ್ತೆಯನ್ನು ಒತ್ತುವರಿ ಮಾಡಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಒತ್ತುವರಿದ ಕ್ಷೇತ್ರವು 0 ಎಕರೆ 1 ಗುಂಟೆ ಅಂತ ತಾಲೂಕು ಭೂಮಾಪಕರು ವರದಿಯನ್ನು ನೀಡಿರುತ್ತಾರೆ. ಸದರಿ ರೀಸ ನಂಬರ್ಗೆ ಹಾದು ಹೋಗಲು ರೀಸ ನಂಬರ್ 869 ಮೂಲೆಯಲ್ಲಿ ವಹಿವಾಟು ರಸ್ತೆ ಇರುವುದು ಕಂಡು ಬರುತ್ತದೆ ಅಂತ ಕಂದಾಯ ನಿರೀಕ್ಷಕರು ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. And, my lord, page number 30, there page number 30, my lords. The Taluka surveyor has submitted the report, my lord, from the bottom side, my lord. ಸದರಿ ರಸ್ತೆಯ ಗಡಿಗಳನ್ನು ಸ್ಥಳದಲ್ಲಿ ನಾವುಗಳು ನೋಡಿಕೊಂಡಿರುತ್ತೇವೆ. ಅಳತೆ ಕಾಲದಲ್ಲಿ ಸದರಿ ರೀಸ ನಂಬರ್ 860ರಲ್ಲಿ ರಸ್ತೆ ಒತ್ತುವರಿ ಕಂಡು ಬಂದಿರುತ್ತದೆ ಅಂತ ಹೇಳಿ ಬರೆಸಿದ ಒಪ್ಪಿಗೆ ಜವಾಬು ಆಗಿರುತ್ತೆ. Please, as per the annex
23.
last para, Your Lordship, in that. ತಾವು ಅರ್ಜಿದಾರ ನಮ್ಮ ಸದರಿ ಜಮೀನುಗಳಲ್ಲಿ ಬೆಳೆದ ಶೇತಕಿ ಬೆಳೆಗಳನ್ನು ಸಾಗಾಟ ಮಾಡಲು ನಾವು ಸುಮಾರು ವರ್ಷದಿಂದ ಉಪಯೋಗಿಸುವ 12 ಫೂಟ್ ಅಗಲ ರಸ್ತೆ ಶ್ರೀ ಆದಿತ್ಯ ಗುಂಡು ಮಾಶಾಳ್ ಇವರು ತಕರಾರು ಮಾಡದ ಹಾಗೆ when he has made the representation against the private persons. ಅವರ ವಿರುದ್ಧ ಕ್ರಮ ತೆಗೆದು ಅಂತ ಹೇಳ್ತಾರೆ. Without hearing them, Your Lordship.
Take out and summons, your own complaint is.
But my lord, since immemorial time we are
To
using.
notice to respond number, emergent notice to respond number 4 and 5. Returnable by 21st March.
My lords,
Yes,
but
by
there- but my lord,
14th March. Counsel for the petitioner is also permitted to take out and summons on respond number 4 and 5 and move the matter for consideration after service of notice.
there is some urgency, my lord.
In the meanwhile, objections to be filed by the learned AG.
There is some urgency.
Well, anta allegation madam, our parties is not behind their back.
But my lord, in the similar set of facts, this honorable court has entertained in the initial
We
stage
don't
and
know
directed
that
to.
pleadings, but in Nimma complaint, you are saying, you are making allegation that they are.
My lord, kindly page number
We
16.
can
my lord.
grant an order behind the back like that, in their property.
No, my lord, kindly see the village map.
ನೀವೇ ಅಡ್ಮಿಟ್ ಮಾಡಿದಿರಪ್ಪ, ಅವ್ರ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಬಿಡ್ತಾ ಇಲ್ಲ ಅಂತ ನೀವೇ ಹೇಳಿದ್ದೀರಾ.
But the my lord,
ಅವ್ರ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಮೇಲೆ ಹೋಗ್ಬಿಟ್ಟು ನಾನು ರೋಡ್ ರೀಚ್ ಆಗ್ಬೇಕು ಅಂತ ನೀವೇ ಹೇಳಿದ್ದೀರಾ.
Taluka surveyor has submitted the report. Government land has been.
That is one part. Your complaint is different.
65, Venkatesh Karvi.
Regarding the, direct the government melody DDPI to ensure regarding the show cause notice issued or not. As per the document on record matter, it was issued on 2019.
Lord, yesterday's matter, my lord, since copy was not available, so the lordship has granted me time to.
Yes, copy banta.
Band court.
ಏನಿದು?
And grievance is, my lord, sir.
Lord, they are seeking for quashing of annexure T.
T. What is T?
That is the endorsement which has been issued at page number.
ರದ್ದುಪಡಿಸಿದ್ದಾರೆ.
Next, J is made 32 Karana show cause notice, my lord.
Page 60.
Page?
60.
16.
60.
60.
Annexure T is the
annexure
impugned.
T, ಅದೇ
That is the endorsement. That is 3/2/2023.
Hmm.
This impugned endorsement they have challenged. My lord, my respectful submission is that at page number P, page 43, that is the original order which has been passed on 14/3/2020, withdrawing their recognition with regarding to the defects. At page 44 are the up to serial number 1 to 21 are the deficiency. On that basis, my lord, after holding inquiry, this has been passed, withdrawing.
Yes, page 46.
So, my lord, based on this, my lord, the endorsement as per annexure T, he has simply stated that to prefer an appeal under section 130. He has not preferred any appeal. Madilla.
It's not, my ground is, my lords.
Lala, none.
So that is a alternative remedy 130, section 130 alternative. My ground is, my lord, 2019 show cause notice issued to the primary school or 2019. Subsequently, without complying the 39 sub clause 2, my lord, that is 1 month notice as per the provision of section 39 sub clause 2 of the that education act.
So Mr. Karvi,
They
this
have,
order has
my
been
lords.
passed on 14/3/22.
Yes or
which
not?
Not challenged.
My lord, what happened, my lords, on 2022, we filed the civil suit before that was I produced, my lord, 447.
Can you do
So
all
that is not maintained, that's I that withdrawn, my lords. On January, subsequently, I have filed this petition, my lord, because
File an appeal.
only, no, my lord, only ground is, my lords. So they have closed the, that SATs, my lords, that is student achieve.
ಅದಕ್ಕೆ ಬಂದಿದ್ದೀರಾ ಇವಾಗ?
So that is, my lord, that
ಇಲ್ಲಾಂದ್ರೆ
is the
ಅದಕ್ಕೂ
reason.
ಬರ್ತಾ ಇರ್ಲಿಲ್ಲ ನೀವು.
So, no. They approached on January, I directed them
We'll
to.
direct them to
No.
carry out an inspection now.
Yes,
to
my lord,
ascertain
direct
if
inspection,
everything
please,
is
my lord,
free.
please, we are ready for that. But meantime, my lord, sir, that try to restore that dice number. and-
Restoration ಆಮೇಲೆ ಬರುತ್ತೆ.
My lord,
You
that
first
restore,
to-
because
have
my
you
lord,
complied with
it's academic, upcoming with my lord, March, it's the examination.
Next week ಅಲ್ಲಿ ಬರುತ್ತೆ.
Please.
Report.
The reason for passing this in the interest of the children's and the ಮಾಡಿದ್ದಾರೆ.
Please, my lord, then
ನೀವು
inspection.
ಇದೆಲ್ಲ ಇಷ್ಟೆಲ್ಲ ವೈಲೇಷನ್ ಇಟ್ಕೊಂಡ್ರು
ಅಲ್ಲ ಮಾಡ್ಲಿ sir, inspection, we are ready for inspection, because only one ground is.
ಅದೇ ಮಾಡಿಸ್ತಾ ಇರೋದು.
And ಅಲ್ಲ, second ground is, my lords, my lord, one more thing,
Order
my
dated.
lord, one.
ಏನ್ ಬೇಡ.
ಮೂರು ಶಾಲೆಗಳನ್ನ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಾರ ವಿತ್ ಸೇಮ್ ಪ್ರಿಮೈಸಸ್.
ಆಯ್ತು.
In the same premises, they allowed 3.
ಅದರದ್ದು ಚೆಕ್ ಮಾಡಿಸ್ತೀವಿ.
Yes, please, my lords, please. That is, I have
Order
named
dated
the
14/3/2022 had been passed taking into account the various deficiencies in the physical infrastructure of the school run by the petitioner. The submission of Shri Venkatesh Karvi, learned counsel for the petitioner, is that there are no such deficiencies and all these aspects have been provided for by the petitioner. The petitioner has been singled out. There being 2 other schools in the same building, they have been granted recognition. In that view of the matter, I am the considered opinion that who will inspect? Nimmele allige.
ಅಲ್ಲ for that reason, page 45 kindly.
Inspection?
ಅಲ್ಲ inspection ಆಯ್ತು, page 45. ಅದರಲ್ಲಿ after 21, clause number 21 ಆದ್ಮೇಲೆ ಮುಂದುವರೆದ ಕ್ಷೇತ್ರ ಶಿಕ್ಷಣ ಹುಬ್ಳಿ ಇವರು ಶಹರ ಇವರು ಸಂದರ್ಶನ ನೀಡಿ ಸದರಿ ಅನ್ವೇಷಾಲಯ SC/ST/IT 225 ಲಭ್ಯವಿದ್ದು ಸದರಿ ವಿದ್ಯಾರ್ಥಿಗಳು ಬೇರೆ ಬೇರೆ ಶಾಲೆಯಲ್ಲಿ ದಾಖಲಾಗಿರುವುದು ಎಂಬುದನ್ನು ಅಲ್ಲ, that has been already taken that.
Who will carry out the inspection?
And
ಅಲ್ಲ any other than lordships, I allude to ಅಲ್ಲಿ ಯಾಕಂದ್ರೆ ಇಲ್ಲಿ ಮತ್ತು ಇಲ್ಲಿ ಇವರೇ ಬರ್ತಾರೆ.
Who can do it apart from that?
Apart from that, my lord.
One more thing is, my lord, that showcase notice issued by BO. So, but this notification is issued by DDPI.
Respond number 2 commissioner ಮಾಡಿದ್ರ?
Respond number 2.
Competent authority and
is directed to carry out the inspection of the school of the petitioner and the neighboring schools and submit a report as regard the existing facilities and their compliances with the applicable law, being both the act and the circular stroke notification issued thereunder.
Please.
The inspection to be carried out commencing from 5th March, report to be submitted by 11th March, list on 14th March.
Please, please, my lords.
My lord, I accept notice for all the respondents.
ಅಲ್ಲ ಆಗಿದೆ, ಮೊನ್ನೆ ಆಗಿದೆ.
Please.
66, Avinash Bankar.
This is day before yesterday's matter. The shifting of mutton shops to the market ground. The second respondent was asked to seek instructions. Market ground, it was, the notice was issued to shift the shops to the market ground.
Yes.
It is surrounded by the temple.
I was told that there is separate market is located and the auction is also being conducted, and one more notice was earlier issued in the month of January itself and he did not respond to it. Again, we have issued one more notice and we have conducted the public auction, auctioning the shops. There are as many as 30 shops. He did not take part in the auction, and he is
ಯಾವ auction? ಈ shop, ಇರೋ shop ಗ ಇಲ್ಲ next shift?
no, the other shops where we want to locate the entire market, where the shops are there. Lords may kindly see the photographs.
ಇನ್ನ ಇದಾವ shops ಅಲ್ಲಿ ಮುಗಿತಾ?
Yes, there are other shops are there.
ಯಾವಾಗ next auction?
Please.
Next auction ಯಾವಾಗ ಮಾಡ್ತೀರಾ?
As and when if he comes, we'll give him no problem. And he is squatting on the property without paying a single pay, and he is collecting the rent.
The problem is that the shops which now proposed, they are surrounded by all the temples.
It is their obligation that you will be working there.
Publicly, future again it will not.
If you don't want to go, then we can't help you.
We are running the place now where we are running.
The reason is this.
Actually, it's a meant for
From time to time, there are changes which will happen.
True, but
ಬೆಂಗಳೂರು ಹೈಕೋರ್ಟ್ ಧಾರವಾಡಕ್ಕೆ ಬಂತು. ಇಲ್ಲಿ ಬೆಂಗಳೂರಲ್ಲೇ ಇದ್ದಿದ್ರೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ನೀವು ಬೆಂಗಳೂರು ಶಿಫ್ಟ್ ಆಗ್ಬೇಕಾಗಿತ್ತು. ಅಲ್ಲಿ ಟೈಮ್ ಆಯ್ತು, ಶಿಫ್ಟ್ ಮಾಡಿ.
There is a reason behind it. He is squatting on the property without paying any single pay, and he has given 12 shops, created himself and given it to third person. He is collecting 40 to 50,000 rupees per year from each shop holder. He is getting the amount. That is the reason why he don't want to vacate the premises.
Petitioner is before this court seeking for the following reliefs. The condition of the petitioner is that the petitioner has been forced to vacate the premises in CTS number 1694 Badgi town, where he's running a mutton shop, to a location now fixed and chosen and fixed by respondent number 2 on the ground that the said area has been identified for setting up shops of meat and poultry. The contention of learned counsel for the Shri Avinash Bankar, learned counsel for the petitioner, is that said location is not feasible inasmuch as there is a temple located close by and there is a possibility of objections being raised by the neighbors of the said market at that time. The Hanuman Reddy Savkar, learned counsel, appearing for respondent number 2 after obtaining instructions, submit that the market has already been constructed, and in that regard he has filed a memo enclosing the photographs thereof, which has been taken on record. His submission is that there being ಎಷ್ಟು shops, sir? 40?
Out of 30, my lord, 4 shops have been auctioned.
That there are 30 shops which have been set up exclusively for the purpose of meat and poultry
Yes.
business, out of which 4 shops have already been auctioned, and if the petitioner were wishing to take up any particular shop, he could also participate in the said auction. His further submission is that the respondent number 2 has taken into account all unnecessary applicable rules and obtained all permissions to set up the said market, and the petitioner need not have any fear as regards any objection being raised
Resolution is also passed, my lord.
in respect thereto. And as such, he submits that the action taken by the respondents being within their permissible administrative jurisdiction, this court ought not to intercede. Third, so-and-so perused papers. As can be seen from the photographs which have been produced, there are large number of shops which have been constructed and ready for occupation, and more or less ready for occupation. The municipal council, the municipality, has designated a place for carrying out the business of meat and poultry work, which it is entitled to do under the Municipalities Act, inasmuch as there are various aspects relating to meat and poultry business which is required to be taken into account for the purpose of establishment of such shops. The municipality having done so, I do not find any infirmity in the said order. Liberty is, however, reserved to the petitioner to take part in such auction as may be conducted by the municipality for such shop as may be of interest to the petitioner.
Yes. 67, Narayan Viyaji.
Please, my lord, a rule has been issued in the matter.
ಮತ್ತೆ ಆರಾಮಾಗಿ ಬರ್ಲಿ, ಏನಕ್ಕೆ ಇವತ್ತೇ ಯಾಕೆ ಬಂತೀವಿ? Relist. ಯಾರು ಮೂವ್ ಮಾಡಿದ್ರು? Relist on 8th April.
Please.
Please.
68, Omkar Desai.
Lords, as per my instructions, please, the students, lords, were below percentage in the PCB2. Hence, lords, their admissions were not approved. Lord, as lords, on the last occasion, lords, my learned friend has relied, lords, the order passed by the principal bench. Once if it is approved by the NEET, then the university.
How are you to say no?
ಅದೇ ಅದು ಬರಲ್ಲ.
ಅಲ್ಲಿ ಹೋದ್ರೆ ಅವ್ರು ಹೇಳಿದ್ದೆ ನಾನು ಕೇಳ್ತೀನಿ ಅಂತ, ಇಲ್ಲಿ ನೀವು ಉಲ್ಟಾ ಹೇಳಿ. ಯಾಕೆ ಇದು ಮಾಡ್ತೀರಾ ಅಂತ ನಿಮ್ ಮೂರ್ದು ನಮ್ಗೆ ಇನ್ನ ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲಪ್ಪ. NCISM, ಯೂನಿವರ್ಸಿಟಿ ಅಂಡ್ KEA. Please advise your people properly. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the petitioners have fulfilled all the requirements of the admission into respondent university. All the documents in the BAMS course, all the documents in relation thereto have been furnished. the admission of the petitioner is within the intake capacity sanctioned by the university and NCISM. NCISM ಯಾವ್ದಿದು?
Please, National Council of Lord.
NCISM.
Yes.
The petitioners, having registered themselves on NEET 2023, have also secured appropriate ranking entitling them appropriate ranking. NEET, appropriate NEET ranking. The KEA, Karnataka Examination Authority, had verified all the documents and allotted the petitioner to respond number 3 college. It is after the respond number 3 college had sent the admission details to the respond number to the university sought to contend that marks are below the percentage required and therefore sought to deny the petitioner's admission, which had been approved by KEA,
Please. Yes.
designated by the NCISM. The university is only vested with the obligation and duty to administer the university. The regulations, formulated by NCISM having designated KEA as the counseling authority in charge of the admission process. Once the KEA has allotted a particular student to a particular college, the further process of completing the formality of enrollment, registration of the student is to be carried out by the college and the universities. The university cannot, after the KEA has allotted a seat to a particular college, contend that the qualifications and or the marks of the students are lesser than what the university desires. In that view of the matter, the respond number 1 university, not having any say as regards the marks that have been secured by the petitioner after their allotment to respond number 3 college, I pass the following order. Writ petition is allowed, a mandamus is issued. Respond number 1 and 2 university is directed to approve the admission of the petition number 1 and 2 in respond number 3 college within a period of 15 days. From the exam
Monday.
Within a period of
At least
2 days from the date of receipt of a copy of this order. In the event of there being any delay therein, the respond number 3 college and the university shall facilitate the petitioners in taking up their examination commencing from 3rd March 2025 by collecting the necessary fees and or such other examination fees and or such other fees, and by issuing necessary hall ticket and such other documents as may be required for the petitioners to take up their examinations from 3rd March.
Operative portion. ಇಲ್ಲ ಮಂಡೆ ಅಂದ್ರೆ ನಾಳೆ ಹೋಗಿ ಹಾಲ್ ಟಿಕೆಟ್ ತರಬೇಕಾಗುತ್ತೆ.
Respondent university shall act on the since the order is passed in the presence of the counsel for the respondent university, the respondent university shall act on the communication made by the said counsel, which communication is requested to be made by end of day today.
Yes, please.
Either upload agutte, if not, no.
Please.
69, Ravi Hegde.
My lord. My lord, I filed a statement of objection. Kindly be on 2 weeks' time.
Huh?
I filed statement of objection.
ಏನು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ, ಎಲ್ಲ ಡಿಕ್ಟೇಟ್ ಆಗೋಗಿತ್ತು. ನಿಮ್ಗೆ ಏನಾದ್ರು ಇದ್ರೆ ಕೇಳೋಣ ಅಂತ. ಏನಿದು ಡಿಕ್ಟೇಷನ್ ಇಲ್ಲ. ಇನ್ ಡಿಲೇ ಇರೋದು ಅಷ್ಟೇ ಅಲ್ಲ ಇದು. ರವಿ, ದಿಸ್ ಓನ್ಲಿ ಅಬೌಟ್ ಡಿಲೇ.
ಡಿಲೇ ಇಲ್ಲ, ಇನ್ಫ್ಯಾಕ್ಟ್ ಅದೇನೋ ಸ್ವಲ್ಪ ಕಷ್ಟ ಅಂಡ್ ಪೇಸ್ಟ್ ಎರರ್ ಆಗಿರ್ಬೇಕು. Lord, the termination takes place in 2014. Immediately notice was issued and conciliation petition was filed. Then, my lord, in 2015 dispute was raised.
ಏನೋ ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬಿಡಿ.
2015 ನಲ್ಲೇ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅದರ ಡಿಲೇ ಇಲ್ಲ. 15ನೇ ಇಸ್ವಿ ಡಿಸ್ಮಿಸಲ್ 14/2014. Page 28, issues framed by the court. My lord,
It was filed in 2015 itself.
15 itself.
Yes, madam.
ಅದೇ ಸರ್
ಏನಿದೆ
ಟೈಮ್ ಬೇಕ್ರಿ ಸರ್ ಸ್ಟೇಟ್ಮೆಂಟ್
2014 ಪಾಪ 10 ವರ್ಷ ರೀಸ್ಟೇಟ್ ಆಗಿದೆ.
ರೀಇನ್ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಗಿ ರಿಟೈರ್ ಆದ್ರು.
ರೀಇನ್ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಗಿ ರಿಟೈರ್
ಆಗ ರಿಟೈರ್ ಆದ್ರು, ಟರ್ಮಿನಲ್ ಬೆನಿಫಿಟ್ಸ್ ಇನ್ನು ಸೆಟ್ಲ್ ಮಾಡಿಲ್ಲ.
is granted 2 weeks time to file a statement of objection. Objections if any by 21st, relist on 27th.
70, Ikalteli.
Matter arising out of my lords and suit, application came to be filed for my lords not to put up a construction. Application was allowed reversed in the appeal. My lords directed the respondent defendant to file affidavit in support of, in event of.
Not to claim equity, my lords.
No equity.
Yes,
Only my submission, my lords. GPA holder has filed affidavit here. Entire appeal is contested, that is.
PA holder ಹಾಕಿದಾರಲ್ರಿ.
Lord, PA, I am cavator in this matter, my lord. I was represented through PA holder only, my lord.
If that is
your clients this.
Lord,
ಅವರು ನಮ್ಮ PA holder I did not authorize to file ಅಂತ ಹೇಳಿದ್ರೆ.
Now
the allegation against you and the PA holder.
ಈಗ ಸೂಟ್ ಅನ್ನು PA holder ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಿದ್ದಾರೆ.
File of the party. The party will be.
My
affidavit has been filed on behalf of respondent number 1, a perusal thereof though an affidavit has been filed, a perusal thereof indicates the same is filed by the power of attorney holder of respondent number 1. In that view of the matter, the counsel for respondent number 1 is directed to file an affidavit of respondent number 1. He seeks bond is granted. ಎಷ್ಟು ದಿನ ಬೇಕು?
4 days, 5 days.
A week's time to file the same. Relist on 7th March.
Please.
71 Arjun, 72 Sonu Suhel.
I am for petitioner, my lord. Last time this honorable court directed to the respondent to file affidavit, my lord. Last time time ತಗೊಂಡಿದ್ದಾರೆ my lord to file affidavit.
ಈ ಸತಿ ಕೊಡಬೇಡಿ.
But draft of the affidavit is ready, your lordship, but Deputy Commissioner, your lordship, is held up in Withdrawal festival. But your lordship, as per instruction.
Festival?
That is a village festival in the answer. Withdrawal Mallama. But your lordship, as per the instructions, your lordship, the special level Hidkal Dam is the competent authority to grant the land. It was also AC, your lordship, has also written letter to the special level on 17 to 2025 to consider the case of the petition for grant of land. It was also forward to the petitions also, your lordship.
Yes.
This is the copy of.
Consider ಮಾಡಿ and 3 ಸತಿ ಆಯ್ತು ಅವ್ರು contempt ಹಾಕಿಲ್ಲ.
But regarding that, your lordship, survey number 99, your lordship, they are claiming. There is a land is available.
Yes.
And in view of that, your lordship, certain commissioner has written a letter to the special LAO to consider the case of the petitioner for grant of land. In that.
When will you do it?
Within 30 days, your lordship.
You will do it. So we'll record your statement. The petitioner is before this court seeking for the following reliefs. The grievance of the petitioner was that despite several directions issued by this court earlier and the recommendation made, the petitioners have not been granted land. Learned AGA upon instructions submits that the SLO ಯಾರು recommend
Hidkal Dam. Hidkal Dam, your lordship.
ಅಲ್ಲ ಇವಾಗ ಯಾರು recommend ಮಾಡಿರೋದು?
The assistant commissioner to special LAO Hidkal Dam, your lordship.
The assistant commissioner has written to the special LAO
Hidkal Dam.
land acquisition officer Hidkal Dam to identify and allot appropriate land, and that the special land acquisition officer is in the process of doing the needful. Given 60 days time,
yes,
the allotment, the grant would be made to the petitioner. Since a positive submission has been made by the learned AGA, placing the said submission on record, hoping that this time the grant would be made within 60 days time, the petition stands disposed. If needless to say, if needful is not done by said dates, appropriate action would have to be taken. Learned AGA is directed to transmit the above order to ensure the transmission of the above order to CCMS.
Both cases, your lordship.
Both.
Achudlan.
73, C.S. Nilopan.
It's a matter, my lord, your lordship, of the opinion that under
Second one, 73.1, 73.2.
in the first petition, we have filed a compromise petition.
73.1 ನಲ್ಲಿ who will accept notice?
That's
Respond number 1.
respond number 1, my lords.
R1, I take notice now.
And,
Here Nilopan accepts.
and another, my lords,
Just 73 dispose ಮಾಡ್ಬೇಡ.
Please.
73.
18, my lords, respond 18, Deepak, sir. Please.
The petitioner is before this court seeking for the following reliefs. A joint memo has been filed which reads as under. The submission of Shri C.S. Shettar, respond number 4 here, and who was the revision petitioner? Huh?
Yes, yes, me.
Revision petitioner in
Section A, my lord.
number in revision petition number 50 or 23 at 24 at annexure A. Is that you would be withdrawing the said revision petition.
Please.
A submission is taken on record, the revision petition number 50 so and so at annexure A at so and so is dismissed as withdrawn. Consequently, the order dated 29/8/2024 is set aside.
Joint memo is filed, my lord.
ಅಲ್ಲ,
ಅದು next ಅಲ್ಲಿ ಬರುತ್ತೆ.
Please.
73.1. ಯಾರ್ಯಾರಿಗಪ್ಪ ಇದು?
I appear for respond number
Respond number 1, my lords.
in both 73.
73.1, Shri Shreyas Nilopant accepts notice for respond number 1, 2.
Sir, dispense, my lords, I will, entire, my lords, others, my lords, I will file a dispense. Other, my lords, respondents will seek.
Dispensing claim ಮಾಡಕ್ಕಾಗತ್ತೆ.
They have already taken their share in the.
Before the trial court, my lords,
Dispensation. We have to set aside a decree by the Lok Adalat, of which they are party.
they have, my lords, taken the share by way of compromise.
Only these two persons had not
Left
taken a
out, my
share.
lords.
But that whole decree has to be set aside.
Then, my lords, again, my lords, it will be. Because, my lords,
ಹೇಳೋದೇ ಇಲ್ಲ, ನೀವು ಅರ್ಧಂಬರ್ಧ ಹೇಳಿದ್ರೆ ಹಿಂಗೆ ಆಗದೆ.
insofar as these
ಇದೀರ party
respondents
will file ಅಂತ ಹೇಳಿದ್ರೆ.
Lord, in view of setting aside of the order of Deputy Commissioner, my lord, the compromise that has been entered in RA, my lord, attains finality, my lord. In which, my lord, the rest of the respondents have taken their shares. By recording this compromise, this writ petition may be disposed of. Because only these two persons were left out in the RA, my lord, compromise.
Both were absent in the RA. Others.
Absent. ಅವ್ರು ಲೆಫ್ಟ್ ಔಟ್, ನೀವು absent.
So this was against us, and others, they have taken share.
Notice to respond number 2 to 20.
Please.
He is dispensed with at the sole risk, cost and peril of the petitioner. It is made clear that respond number 2 to 20 would not be bound by any orders passed by this court in the present matter. 73.2.
Respond number.
Nivena,
Please.
Shri Shreyas Nilopant accepts notice for respond number 1. Notice to respond number 2 to 20, dispense same order. Final order, third. WP1 common order 101453 and 101578. The petitioners are before this court seeking for the following reliefs. The submission of the petitioners is that they are aggrieved by the compromise decree dated 8/12/2018 passed in RA number 50 of 2015 before the Lok Adalat. The grievance in effect is not as regards the entire compromise, but only in regard to a portion of the property which has been allotted to respondent number 1 without taking into account the rights of the petitioners in both the above petitions. They submit notice having been served. Respondent number 1 submits that since the petitioner is not available at the time of recordal of the compromise, they are not included. The petitioner has no objection for the land which has been allotted in his favor to be apportioned amongst the respondent number one has no objection for the land allotted to the respondent number one to be apportioned amongst the petitioners. And as such, it is submitted that the land in RS number 9/11, situated at Kustagi district, Koppal, measures 2 acres 6 guntas, as regards which respondent number one would be entitled to 1 acre 3 guntas. You are petition number two.
He is the purchaser, my lord, from respondent number one.
Yeah, who is the party in the other matter?
He is not party in our petition matters. The first matter is.
The first matter, he is petitioner number two.
Respondent number 4, yaro.
Respondent number 4, my lord, is the
Neela Gangamma.
He is petitioner in 101513 of 25.
10?
1513.
1513 petition. That the petitioner in WP number 101513 would be entitled to 2 guntas. The petitioner in WP 101453 of 2025 would be entitled to 1 gunta 5 annas.
Please.
A compromise ಮಾಡಿದ್ದೀರಾ?
Joint memo, let's go filed.
ಅದು ಅದ್ರಲ್ಲಿ ಹಾಕಿದಿರಪ್ಪ, ಇದರಲ್ಲಿ
Will file. No.
a compromise petition has been filed, the same is taken on record. The daily order will release tomorrow. ನಾಳೆ ಹಾಕಿ. We'll pass this order tomorrow.
We will file it, naturally. We will file.
We'll file it ಅಂದ್ರೆ ನೋಡ್ಬಿಟ್ಟು ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕಲ್ಲ. ನಾಳೆ ಫೈಲ್ ಮಾಡಿ.
233 matter. 1, Prashant Usmani.
It's calling in question, my lord, the order passed by the Lok Adalat. I was not, petitioner was not a party to those proceedings. My brother plaintiff, my lords, files a suit with a very strange prayer wherein he relinquishes his right in favor of defendants 1 and 2, and for injunction not to interfere in the remaining portion of the land. That property is a joint family property. I have a share in that.
You are not a party.
I am not a party. The prayer itself in the suit is very strange wherein he gives up his right.
ಅವರ ಹೆಸರಿನಲ್ಲಿ ಇರುವ ಕುಸ್ತಿ ಕಬ್ಜಾ ಎಲ್ಲ ಅಲ್ಲ ಪೋರ್ಷನ್ ಆಫ್ ಇಟ್. ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ರಿಟರ್ನಬಲ್ ಬೈ April 28. The operation of the compromise decree dated 16/3/2024, passed in OS number 97 of 2014, pending on the file of the pending on the file of the principal civil judge at Kustagi at Annexure E is stayed till the next date of hearing. Counsel for the petitioner is directed to make payment of process fee and furnish copies by end of day 28 February, failing which the interim order will stand automatically vacated.
2, K.H. Bagi.
The petitioner is challenging or imposing of 12% FDT, my lords, forest development tax is concerned, lords.
12%?
Forest development tax.
Covered. And AG, kodi the order. And AG accepts notice for respond number 1 to 4. Same order. Pending items.
3, Dinesh Kulkarni.
Purchaser.
Lord, it is purchaser.
Grantee purchaser.
Grantee no purchaser, uncare.
Purchasers.
Purchaser.
Purchasers.
1999 my lord grant.
Anyway, ಇದು challenge ಮಾಡಿಲ್ಲ.
52 grant, 99 my lord it is sold.
And AGA accepts notice for respond number
1 to 7.
1 to 7. Issue notice to respond number 8 to 9 returnable by 29th April. The operation and execution of the order passed by respond number 2 dated 14/8/2024 bearing number so and so at annexure J is stayed till the next date of hearing. Both the petitioners and respond number 8 and 9 are restrained from putting up any construction on the subject property as also from any manner dealing with, alienating, encumbering or creating a charge on the subject property till the next date of hearing.
5 Anil Kale. Vote 4. Vote finished.
Yes.
My lord, the record of rights were changed based on a compromise decree. And that is challenged by my lord, some individual persons claiming right under.
Today, Lord, my learned friend, afternoon copy has been served. I am not a week's time.
ಅದೇ ನಿಮ್ಗೆ ಅಲೋ ಮಾಡಿ ಅಂತ ಹೇಳಕ್ಕೆ. I have no objection ಅಂತ ಹೇಳಿ. Weeks time. Weeks time ಏನಕ್ಕೆ ಕೇವೆಟ್ ಹಾಕಿದ್ಮೇಲೆ?
Monday, Lord.
Don't we deal with the property till the next day.
Please.
ಇದರಲ್ಲಿ Lord, the Tahsildar Lord has inspected the spot.
ಎಲ್ಲ ಗೊತ್ತಿದೆ ನೋಡಿ.
And
Entry ಮಾಡೋದು ಎಲ್ಲ ಬರುತ್ತೆ.
Operative portion I am only.
Authorities cannot go, my lord, contrary to the compromise decree. Entries are based on compromise. If they are agreed, if they are agreed, my lord, by the compromise, and if their right is affected, they have to challenge it. They straight away
They are
approach the
parties to the
authority.
they are parties to the
No,
compromise.
no, they are not parties to the compromise.
Then what is their right?
Father Lord sold the property. After Lord, they got entered their names in the revenue records. Though property was converted in the year 1997. Entries made in the Grama Panchayat. Without
You are the brother.
we are the purchasers.
They are claiming to be.
90s.
Purchaser from?
Father. After death, Lord, these
Those
children,
properties were left
including
out.
each other, filed the suit and obtained the compromise decree before Lok Adalat.
Those properties are left out.
Self-acquired property in joint family.
Self-acquired.
Whatever it may be, Lord, they.
Self-acquired property.
ಮತ್ತೆ ಮುಗೀತು.
My lord, one more thing. Those lands are, my lord, left out in the compromise. 10 sites were left out. We have not entered into compromise. There are only 3-4 persons. They are challenging the entire entries.
ಅವ್ರು ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ.
ಅಲ್ಲ ನಾವು ಅವ್ನು ಬಿಟ್ಟೆ ಮಾಡಿದೀವಿ. Compromise.
Lord, I will ascertain, Lord, as per the report of the Tahsildar, Lord, 100.
Lord, AGA accepts notice for respond number 1 to 3. Notice to the other respondents is deferred for now. Released on 3rd March.
Please, preliminary hearing.
In preliminary hearing.
Please.
5 Anil Kale. Page 42, my lord. Interim injunction was ordered against respondent 4 and 5. Petitioner, my lord, respondent 4 and 5 are brothers. Lord, in respect of use of common road, page 42 is the operative portion. Lord, along with the injunction order, my lord, I have approached the police, my lord. Now, my road is blocked. Lord, I have to transfer the, my lord, to transport the sugarcane crop. My lord, common road, my lord, is blocked. Therefore, my lord, the police, my lord, did not take any action.
Road ಯಾಕೆ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ? ನೀವು ಸರಿಯಾಗಿ ರೋಡ್ ಮೇಂಟೈನ್ ಮಾಡಲ್ವಾ?
ಅಲ್ಲ ಮೇಂಟೈನ್ ಮಾಡಿದಲ್ಲ. ಬಿಟ್ವೀನ್ ದಿ ಬ್ರದರ್ಸ್ ಡಿಸ್ಪ್ಯೂಟ್ ಬಿಟ್ವೀನ್ ದಿ ಬ್ರದರ್ಸ್.
This
ಅವರವರಲ್ಲೇ.
is a public road.
Public ಅಲ್ಲ.
Public ಅಲ್ಲ. Among, my lord,
among your
family members.
Lord, AGA accepts notice for respond number 1 to 3. Issue notice to respond number 4 and 5. Returnable by 28th April. The grievance of the petitioner for now is that the petitioner, having succeeded in obtaining an order of injunction restraining the defendants in OS number 217 of 2004, who are respond number 4 and 5 herein, from interfering with his possession, with his use of the road. The defendant 4 and 5 having interfered, a complaint having been filed with respond number 3 has not been acted upon. In that view of the matter, the respond number 3 is directed to implement the order passed by the Principal Civil Judge in JMSC Mudor, dated 28th January 2025 and OS number 217 of 2024.
Six, Sridhar Prabhu.
Wait, please, Your Lordship. Your Lordship's judgment, Lord, for online access to tribunals is not implemented after several years of the judgment. I produced
Online access to? Online access to?
KERC, Lord, Karnataka Electricity Regulatory Commission.
Adik mandamus
Our KERC, all regulatory commissions in India are, Lord, now online, except KERC. Sole exception being KERC.
Who is the standing counsel for KERC?
Euro Kamte sir. Yes,
And AG accepts notice for respond number 1. Shri BS Kamte accepts notice for respond number 2. Elli Kamte or Elli?
BS Kamte.
The grievance of the petitioner is that the respondent number 2 has not complied with the order of the Honorable Apex Court in WP Criminal 351 of 2023. Sarvesh Mathur was the Registrar General, High Court of Punjab and Haryana, dated 6th October 23. And the order dated 22nd May 2023 in WP number 10634 of 2021. Solvis Energy India Private Limited was the state of Karnataka, page 17. Inasmuch as the KERC has not provided for e-filing, e-appearance and other e-services.
E-filing is permitted, but e-appearance is not.
E-appearance and e-services, though e-filing has been permitted.
Yes.
Illi Kamte or
BS Kamte.
Konne illi. It was but required for the KERC to have complied with the directions which have been issued. Not having done so, the petitioner has submitted a representation which has also not been considered. In that view of the matter, I pass the following order. A mandamus is issued directing the respondents to comply with the aforesaid orders within a period of 30 days, 60 days from the date of receipt of a copy of this order.
7, Avinash Bankar.
The second respondent has issued a notice to demolish the school building.
School building.
School building. Now, the petitioner is the owner of the land bearing survey number 855, that is plot number 29. It was granted to the petitioners in the year 1992 by the Mandal Panchayat. Now, so challenging the entries in the name of the petitioner, the second respondent municipality has filed appeal before the assistant commissioner. That appeal came to be dismissed in the year 2012 itself. Now, based on some complaint before the Lokayukta, the Lokayukta directed the second respondent to demolish the building, containing that it is a park.
Lokayukta has already directed.
He directed the second respondent municipality.
But that's the challenge madilla.
Now we were not parties. Party notice.
If they are acting as per the Lokayukta's direction, you will have to challenge that. Lokayukta and party madbeku.
The reference, may I request page number 24 annexure H. It's a notice now which has issued. They have
item number 2.
Reference, they have given reference.
Item number 5.
Item number 5. Here sati ide.
We were notice even from Lokayukta also there is no notice.
But if there is a direction issued, should you not challenge it so that we make the.
May I request
the issue, my lord, says whether that building is constructed by taking permission from the municipality or not. That is why we have issued notice. My lords, at page 24, lords Ulleka Naku at bottom, my lords.
Only because plan sanction. Plan sanction tondidira.
Sanction agide. Plan sanction
tondidira. That is what we require. Ask them to provide all those documents.
When after from when
reply to this with that.
Now 15 days notice has been given to them.
Demolition. And if documents quoted, they will consider it. Avaru pressure alidare. Petitioner is before this court seeking for the following release. The petitioner is aggrieved by the notice dated 24/2/2025 issued by respondent number 2 at annexure H, directing the demolition of the property construction put up by the petitioner. The submission of the counsel for the petitioner is that no such order could have been passed the petitioner, being the owner of the property, having obtained necessary plan sanction from the concerned authorities, has put up the construction in legal and proper manner. Shri Prashant Osmani, learned counsel, for respond number, who has accepted notice for respond number 2, would submit that the notice has been issued calling upon the petitioner to furnish details as regards plan sanction otherwise, since there is a complaint which has been received that the construction is illegal in nature. His submission is that if the petitioner were to furnish all the details of plan sanction and if the construction is found to be in accordance with the plan sanction, no action for demolition would be taken. The learned counsel for the petitioner seeks for and is granted a week's time to place all the necessary documents for consideration before respond number 2. Respond number 2 is granted 15 days time thereafter to pass necessary orders. Until then, respond number 2, needless to say, would not, ought to restrain itself from carrying out any, seeking to carry out any demolition or otherwise of the subject property. Learned AGA accepts notice for respond number 1 mail.
8, Mrutyunjay Hellikeri.
Sorry for the petitioner's counsel, my lords. This we are. Lords, again we are back to the Gadag.
Same matter on Monday. It is Monday, same matter. They moved the division bench today, my lord, and the division bench has declined to interfere. This is the only fact I bring it to knowledge of this. Now they are challenging the election in this petition.
Direction nature, sir, should be watching the order issued with this. Now you are challenging the election officer.
Please.
If they permit me, my lords, I thought I have a right of, anyway, my lords, I would have brought it to my lord's notice. It is not that I will not bring it to your lordship's notice. My lords, there are 2 grounds under which this writ petition is. That, my lords, any election everywhere your lordship knows, it is the same thing, my lords. There are 2 grounds on which this is basically, my lords, premised.
We have added one more. Temples, mutts, etc. They are even worse than this.
My lords, one is, my lords, if your lordship kindly come to the, I'll just say, one is, my lords, the authority who has delegated the power and appointing the assistant commissioner as the election officer. He had no power under the rules of delegation. So the notice calling for a meeting.
What is the provision?
And, my lords, yes, please come to President and Vice President rules, my lords, under the Karnataka municipalities, President and Vice President rules 1965. The second ground being, my lords, 7 days clear notice.
The first one, no,
yes.
Who is the?
Please come to
authority.
Karnataka municipalities, President and Vice President rules. In that, please come to, lords, election officer is defined. Please see 2BI. Election officer.
CMC, na?
It's CMC.
The deputy
in the case of CMCs, the deputy commissioner or the person performing the duties of the deputy commissioner for the time being.
Yes.
Now, my lords, please turn now in the case of TMC, 2 and 3 also becomes valid, my lords. 2 is in the case of town municipal councils at district headquarters, any officer nominated by the deputy commissioner in this behalf, not below the rank of an assistant commissioner.
So there is no nomination in one, second nomination is there.
No, secondly there, first illa. First it can be DC, probably, my lords, what is known as in my lords, we do not know whether it's a rank, additional deputy commissioners and ADC, who will be performing the duties. They could probably. They could if they are performing the duties of a deputy commissioner or an in-charge deputy commissioner. Suppose that district does not have a deputy commissioner. Another district has, and he is given in charge of a particular.
Deputy commissioner, we agree.
Probably he could.
But ADC, special DC, that has been negated by Supreme Court in respect of the revision powers, etc.
Please.
So they cannot discharge antanu hoyitu.
So
at the most it could be in-charge DC of the other. Yes.
It could be only an in-charge. So the rule is very specific, my lords. And then, my lords, please come to 3, my lords, rule 3 there. Since your lordships are holding the rule book, my lords. Appointment of date of meeting. The election of president and vice president shall be held in the meeting fixed by the election officer, and he shall thereupon send to every councillor notice of date so fixed not less than 7 days prior to the date of meeting. Now, of course, 3 your lordships have interpreted, not necessarily, my lords, so far as another case, a recent judgment by my lords pertaining to Harappanhalli, my lords, your lordships have interpreted that to
Section
mean
49 of the Gram Panchayat.
almost.
No confidence.
No comment.
No confidence do alla idu. Municipalities Act alle. Rule
No
3.
confidence, adil 7 days, including,
Yeah.
excluding
No,
the
but
date of
here
issue.
this was regarding election rules madidira.
Excluding date
Election
of
rules
issue.
illidu. That's why copy ಕೊಡಿಯಪ್ಪ. That I will come later. This is as recent as
Yes, that is what, date.
almost your lordships have interpreted this rule. What I mean to say is, now, my lords, my lords, what has happened here, my lords, your lordship knows I'm not going into the issue of disqualification that your lordships have dealt. There is an order. Division bench has now said they have to follow parameters of 31, 32. I am not concerned with that. That's though they are also petitioners before my lords. That's if your lordship now comes to the impugned order, please come to Annexure C, page 24.
Yes.
No, my lords, to the best of my knowledge, C was issued on 6/8/24. The rules which I read to my lords that were in existence so far as our research goes, my lords. Now, my lords, please see ವಿಷಯ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗಳು ಅಧ್ಯಕ್ಷ ಮತ್ತು ಉಪಾಧ್ಯಕ್ಷ ಸ್ಥಾನಗಳಿಗೆ ಚುನಾವಣೆಗಳನ್ನು ನಡೆಸುವ ಕುರಿತು. In that, please, my lords, the ಮೇಲ್ಕಂಡ government orders are there. I'm not concerned, but second para, your lordship may kindly come, unnumbered. ಅದರಂತೆ ಈ ಕೆಳಗಿನಂತೆ, your lordship gets it, my lords?
Yes.
ಈ ಕೆಳಗಿನಂತೆ ನಗರ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗಳ ಅಧ್ಯಕ್ಷ ಮತ್ತು ಉಪಾಧ್ಯಕ್ಷ ಚುನಾವಣೆಗಳನ್ನು ನಡೆಸಲು ಸರ್ಕಾರದ ಉಲ್ಲೇಖ 5ರ ಅನ್ವಯ ಅಧಿಕಾರಿಗಳನ್ನು ಚುನಾವಣೆ ಜರುಗಿಸಲು ಗೊತ್ತುಪಡಿಸಿದ್ದ ಅಧಿಕಾರಿ ಎಂದು ನೇಮಿಸಲಾಗಿದೆ. ನಗರ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆ ಹೆಸರು ನಗರಸಭೆ ಗದಗ್ ಬೆಟಗೇರಿ. ಚುನಾವಣೆ ಜರುಗಿಸಲು ನೇಮಕ ಮಾಡಲಾದ ಗೊತ್ತುಪಡಿಸಿದ ಅಧಿಕಾರಿಗಳ ವಿವರ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಗದಗ್. The rules are very categorical. Unless the rules are amended, then, my lords, there are for other bodies. For each body, my lords, Tahsildar and other bodies, they have goes down to town municipal council, town panchayats, where they have given it to the Tahsildar. Those are the lower tiers in municipality, my lords.
It was issued by the Jilladhikari Gadag.
He has the deputy commissioner delegates this virtually. Now, please see 3 again, my lords. I'm sorry, 2. 2BI.
Yes.
In the case of CMC, deputy commissioner or the person performing the duties of deputy. Now, there is absolutely no power under which he is, my lords, empowered, or he is neither does he have the power of delegation, nor does the rule provide for such exercise of powers by the deputy commissioner. That's number 1. Now, my lords, there are 3 judgments on that aspect. Of course, the Supreme Court has considered not necessarily on this aspect, on general delegation. Now, my lord, suppose if it's a ministerial act, if it is that also is not provided here. I am going one step worst case scenario against me. Even if he does not have the power, suppose he can ask the clerk to post. It is not necessary that the deputy commissioner has to do every act. That's how the Supreme Court has interpreted this provision. Now, our case is this delegation by the deputy commissioner to the assistant commissioner is contrary to the rule as was existing at least on 6/8/24.
Is your contention that there's some amendment thereafter?
We, my lords, we have done at least from the internet we could not find, because we don't know, my lord, nowadays what happens, several rules and acts are amended which none of us will know also. Earlier, my lords, it used to come out. Today, nobody knows, my lords. We have done on the internet.
You wing qualify, madam, judgment to wing qualify. As furnished by the counsel for the petitioner and respondent.
No, what's happened, my lords? In fact, one judgment has come out. Later, the learned single judge, we had to point out in a review, book had printed the amendment. It had not been notified. The government also went ahead. Then in a review, my lords, we had to point out later, saying that that amendment is brought out in the books,
but not
notified at all.
Into effect.
So what happens is with the electronic gazette and other things, so this is the first ground.
Yes.
Now the second ground being, my lords, the notice issued by the assistant commissioner, your lordship should get at Annexure D, page 26.
36.
26, my lord.
26.
This is dated 20th of February 2025 and served on some personally, my lords, on 21st, fixing the date of meeting as 28. Your lordships would get that serial number, clause 3 therein, or clause 2 itself, where the date of meeting is fixed as 28/2.
Yes.
My lords, this would also not satisfy 7 clear days notice period. Firstly, AC does not have the power, assuming.
Keeping that aside.
Yes, my lord.
21st it's been served.
21st it is served. 28th is the election, my lords. If your lordship sees, if those days are excluded, it is not even 7 days clear notice. Because 28th, 10 o'clock election process itself starts.
28th has to be excluded.
21st serve madiyare. I would say, my lords, 21st also you exclude. 22, 23, 24, 25, 26, 27.
Yes.
6 days agutte. 21st include madidre 7 days clear agalla.
Yes.
These are the two principal grounds which we have challenged, my lords. Of course, I am also told, so far as 3 of them are concerned, or yaru disqualify agididdu idralli petitioners, petitioner 7, 8, 9. At that point of time when the notice was being served, they had suffered a disqualification order, so notice is not even served to them. Though now your lordships have set aside the disqualification, they have to, my lords, actually be allowed to vote, or, my lords, notice should have actually go to them.
Once the meeting has been fixed, they may not be entitled to. But let us see your deputy commissioner. Yes.
My lords.
Ashtana?
Those, my lords, I'll just show one judgment, my lords. Lords, this is for the proposition, my lords, 58, that if there is a statutory rule or an order, sorry, sorry.
Ashok Kumar.
Please come to straight away, my lords, to para 58, my lords, at page 172.
58.
Because this is a settled position, so I did not, my lords, they have called out. It starts with the constitution bench, your lordship gets it, my lords. A constitution bench of this court, while dealing with a similar issue in respect of executive instructions in Santram Sharma versus State of Rajasthan, held, it is true that government cannot amend or supersede statutory rules by administrative instructions, but if the rules are silent on any particular point, the government can fill up the gaps and supplement the rules and issue instructions not inconsistent with the rules already framed. The law laid down above has
the decision of our court on 2B1.
2B1, that's, my lords, on the delegation power. No, my lords, we could not trace.
So you are the first one raising that issue.
Lords,
you are the first one raising the issue, or first time that is issue is capable of being raised.
It might happen because certain things, my lords, this is one judgment. Then, my lords, there are 2 other judgments which I just want to point out.
Those are general propositions that if it is to be done in a particular manner,
that
manner or not at all. That is the basic premise.
And this goes to the root of the matter, Lord, because it is not even a illegality or a error. It's a void notice, my lords, because it's issued by an authority who has no power.
Yes.
So it goes to the root of the matter.
Election officer means.
Please, before that, I request Milord to kindly see Annexure C. It is not a delegation by the deputy commissioner. Deputy commissioner only indicated who are the officer is going to be exercise the power in terms of the rule or delegation by the government. This only say ಚುನಾವಣಾ ಅಧಿಕಾರಿಗಳು ಜರಿಸಿರುವ ಗೊತ್ತುಪಡಿಸಿದ ಅಧಿಕಾರಿ ಎಂದು ನೇಮಿಸಲಾಗಿದೆ. Designated officer.
Where is the delegation by the state, by the government?
Please, there is a delegation.
And does the government have the power to delegate under 2B1?
Exactly.
In exercise of the power under 321A. And also, there is a one circular.
It is a notification of 13/8/2004.
My lords, if your
From
lordship
that date
sees,
till
even
today,
that,
all the elections are worded by Assistant Commissioner only. Till
Lords.
today, all the elections in entire state are worded by the Assistant Commissioners only.
And you'll have to challenge this notification.
Not challenge that notification
my
by
lords,
anyone.
please come to 321 for a moment. Section 321.
We, even if our coming to 321 will not help you, Mr. Spanindra, unless you challenge it.
Lords, now we'll have to challenge, but whether they have the power, if the rules say so, my lords, that's why prima facie, if I can make out that the rules, once there is a statutory rule, the rule has to be amended. Such of its powers under the act, the government's powers it can delegate.
And also,
Please see 321(1), my lords. The government may by notification delegate to the Director of Municipal Administration, Deputy Commissioner, Assistant Commissioner or Tahsildar such of its powers under this act except the power to make rules. So, my lords,
See, we won't express our opinion on this unless it is challenged.
absolutely.
This is an
But
academic
if I know, I understand this notification is placed, but if I,
This notification, if it was contemporaneous with this, then probably you could have pleaded mala fide. But this is 13/8/2004.
it is, my lords, I understand this. It is. But my lords, if prima facie, if I can make out that this itself is what I, no doubt, my lords, for the,
Without a challenge. Without a challenge, you can't. We can't consider it. You can make out, but we can't.
lords, there, it's only a notification. It does not even amend the rules, nor does it, my lord. That's why I said, this is, my lords, a notification which cannot supersede the rules.
That is for you to make out
Lords,
by
that's
challenging.
Lords, that's exactly why I placed that judgment before my lords to say any notification cannot, the government by executive instructions or any so, cannot, my lords, bypass the rules.
Can we, on the basis of your certiorari or the notice, say that this is bad in law?
Lords, because the rules itself, what I will then leave it to my lords.
Don't be proud.
We'll have to
Challenge
challenge
it.
that. But if I am prima facie able to make out,
Learned AGA accepts notice for respond number.
my lords, then the second ground is available to us. My lord, that your lordships have
that
to-
also convince.
1, 2, 3. She Desai accepts notice for respond number 4. Second ground. Adi there.
Please, Lord, this notice is issued on 21. They received on 21. See, if the 21 is, that is on date on which they have their knowledge of the notice. If the 21, 22, 23, 24, 25, 26, 27, it's amount to 7 days. That is the case in which my lord passed in Arapanalli case. There is a shortage of 5 days notice.
So
21, my lord, it is they received it.
21 receive.
21, 22, 23, 24, 25, 26, 27, 7 ದಿನ ಆಗುತ್ತೆ. Even excluding the date of meeting.
That is by counting the date of receipt.
The date of service.
Please.
But if the date of service is not counted, date of service and date of meeting would have to be excluded both.
If that date has been considered, my lord, and kindly take the note of that, my lord.
General
My lord,
Process Act.
my lord, kindly, that has to be, kindly take the conduct of the petitioners, my lord. They have served this notice on 21st. Till today, they have not questioned this before this.
They wait for the last moment. They're entitled to do
See,
that.
My lords, 6 days.
No, only on the dismissal of the earlier writ, my lord, only on the dismissal of the earlier writ petition.
Though Gauri Shankar
No, no.
Swami said by trick or stratagem that same thing continues. Gauri Shankar Swami, ಇದು ಯಾಲಕ್ಕಿ ಗೌಡ.
Or kindly appreciate this fact. After the dismissal of the, after the disposal of the writ petition, they filed this writ petition by the respondent petition number 5, 6, and 7, my lord.
5, 6, and 7 will exclude. But excluding them is of no consequence.
Please, my lord.
What about 1 to 5, 1 to 4?
No prejudice will cast to my lord. That is another. Yes, my lord, I will demonstrate through the judgment of the Honorable
Sorry.
Supreme Court.
If there's a judgment which says that less
Sir,
than
one judgment, one
the
judgment.
date of service can be
There is
can
a
be
judgment, my lord,
included.
even shortage will not,
Show us.
shortage will not prejudice to the members. This is a way back in the. Sir, one quote. But in the last paragraph, my lord, we here also arising out of the municipalities, where court said the similar no confidence motion was moved, the shortage of 4 days, 5 days notice. After the proceedings have questioned before the Honorable Supreme Court says, we are therefore opinion that The fact that some of these councillors issued the less than 3 clear notice of the meeting did not itself make the proceedings of the meeting or the resolution passed by their invalid. These would be invalid only if the proceedings were prejudicially affected to such irregularities. As already stated, 19 of the 21 councillors attended the meeting. One of these 15 voters favored the resolution conduct appellant. There is absolutely no reason to thinking that proceedings of the were prejudicially affected by the irregularities in the service of the notice. We therefore conclusion that the failure to give a 3 clear days notice to some of the councillors did not affect the validity of the meeting or the resolution of the no confidence motion as against the appellant. So, my lord, the concept of prejudice to the members has been followed by this honorable court in division bench also. I will give one more judgment, my lord. My lord, one more in the after issuance of the calendar of events. So it is not open for them to rise that there is a less minimum notice and all those things. My lord, this another this honorable courts to single judges.
Or a copy ಕೊಟ್ಟಿದ್ದೀರಾ ಇದು?
ಕೊಟ್ಟಿದ್ದೀನಿ. Then another, my lord, last paragraph. However, according to the petitioner, notice sent to her with the registered post was served on 14/10 and therefore 7 days clear notice is not available to her. The said contention cannot be accepted at this stage. The calendar of events is already issued and the election is scheduled to be held on 20th October 11. Once the calendar of events are issued, the election process cannot be interfered by this honorable court. If the petitioner is aggrieved by the outcome of the election, it is open for them to petitioner to file a question before the tribunal. Please.
For election to the post of Adhyaksha and Upadhyaksha.
Please, please. Well, at division bench of this honorable courts, in respect of the 14 days, the prejudice to be shown not by hyper technicality. This is another judgment of the division bench of this honorable court. Malad, this is arising out of the Gram Panchayat, Malad, 15 days clear notice, paragraph 7. Admittedly, no confidence motion notice is issued by the assistant commissioner. Is so and so date conveyed by 17th. As such, prima facie 15 days clear notice is issued by the assistant commissioner. Even accepting the contention of learned counsel for the said notice was dispatched from the office of the assistant commissioner 2620. At the most, there may be shortage of 1 day. In this regard, observed by this honorable court in so and so judgment, we feel that appellant cannot be succeeded on hyper technical ground by invoking the jurisdiction under 226 of the Constitution, 226 of the Constitution of India. So they should paragraph 9, my lord. The jurisdiction of this honorable.
Munyappa was state of Karnataka.
So where, my lord, similar view says that I have not taken.
KLJ ಇದೆಯಾ? ಶ್ರೀರಾಮ್. KLJ ಇದೆಯಾ ಅಲ್ಲಿ? 99 4 KLJ 42. 4 KLJ 42.
And paragraph 9, Lord, jurisdiction of this honorable court under Article 226 is the discretionary. It is not every cases where illegality or irregularity is committed, the court will interfere invoking the jurisdiction under 226 of the Constitution of India. That is particularly so when the violation alleged is for the provisions which is the essence of procedure in nature, not in violations of the fundamental right. The conduct of the aggrieved party who make the such grievance against such irregularity is much important as alleged irregularity. It is to be remembered that in the case of democratic process, number of persons panchayat unanimously moved to no confidence motion, so did not take it. So like that, my lord, it is explained. So here also, my lord, the conduct of the petitioner kindly appreciate. They have after the disposal of the case of the disqualification, when they have not succeeded before this honorable court, when they have not succeeded parallelly, they moved the.
That and this are separate.
Only to show that, my lord. Only to show that, my lord. Only to show that, see the conduct. See what is if they have knowledge of the meeting on first day, my lord, that is sufficient. See, ultimately prejudice to be done because of the non-issuance 1 day shortage of the notice. The prejudice should be shown. What is the prejudice discussed? That is what the Honorable Division Bench of this Honorable Court interpreted and the Honorable Supreme Court has laid down in its judgment.
Everybody was served on 21st.
Yes, my lord. It is their admitted case. It is admitted case. Before, by 10 a.m. it was served. This Honorable Court, my lord, continuously followed the proposition of prejudicially causing damage in terms of the judgment of Honorable Supreme Court, my lord. Therefore, my lord, by most acceptable submission is that it is admitted case that on morning 21st they have served the notice. Therefore, my lord, there is no prejudice cast to the petitioner. Hence, my most acceptable submission is that, my lord, let the election is scheduled tomorrow, my lord, and calendar of events is already issued.
Yes,
And it is their case, my lord. It is their case. Kindly recollect, my lord. It is their case that the elections are not held in Gadag for 1.5 months. See, these are the statement they have made before this honorable court. Kindly take note of that, man.
May I mention?
There's a different matter. We are dealing with two different issues here.
So therefore, my lord,
mix madak hoಗ್ಬಿಟ್ರೆ ಎಲ್ಲ
the statement. See, therefore, my lord, my most on the question of law itself, my lord.
ಆಮೇಲೆ ನಮ್ ಕೇಳಬೇಕಾಗುತ್ತೆ ಗದಗ್ ಬೆಟ್ಕರಿದ್ ಏನೇನಿದೆ ಎಲ್ಲ ತೆಗೀರಪ್ಪ ಅಂತ ಹಂಗಾಗಲ್ಲ. Deal with each matter on its own.
My most acceptable submission is that, my lord, this no prejudice will cast to them, my lord.
That we
please, in terms of the law elected by
of these decisions.
Please.
Yes.
Number one, my lords, my learned friend, what he referred to. Lords, if your lordship sees, those deal with the issue of no confidence. The time period stipulated in the election law, my lords, I can go on giving judgments. In election law, my lords, time periods are stipulated for a particular purpose. If this attitude is taken, my lords, then tomorrow, 7 days nomination time is to be given under any rule, my lords. Even for assembly or local bodies election. Can the government come and say, why do you need 7 days?
There is a judgment of a coordinate bench of this court.
Lords, which
your lordships have relating to this particular aspect.
Lords, your lordships also have dealt with the same thing, my lords, on 28th January. Same issue.
This was not brought to our notice. Probably if this was brought, that would not have
Lords,
been.
even then, if a lordship sees, that's why, my lords.
But if there's a coordinate bench judgment which is prior to.
No, it is, my lords. I understand. But there also, if a lordship sees, they
have a judgment per inquiry.
Adbeda. But if the lordships have referred to the act and see, my lord, the time period. Now, please see section 9 of the Mysore General Clauses Act, my lords.
This coordinate bench judgment.
Absolutely.
In 39290 of 2011 on this very aspect.
Lords, I will just show that if your lordship sees there.
And the apex court judgment in.
That's pertaining to no confidence.
No confidence.
That's pertaining, my lords, let's at least, my lords, for a moment, no confidence cannot be mixed up with, my lords, the election issue. That is pertaining to no confidence.
This is also no confidence.
Those, my lords, Moni Ratnamma and, my lords, which my learned friend referred to the other judgment of the Honorable Supreme Court.
Moni Ratnamma and Narsimaya are no confidence.
Yes. Those pertain to, my lords, no confidence, which can't be mixed up with this issue.
But
they are dealing with
a very strongly worded.
So far as the election issue is concerned, now we have, my lords, Narsimaya is also, my lords, no confidence. So those are in different situations. Now then, my lords, we have a rule here which categorically says 7 days clear notice. Now please see, my lords, section 9, my lords, of the General Clauses Act.
Yes.
Commencement. In any Mysore or Karnataka Act made after the commencement of this Act, it shall be sufficient for the purpose of excluding the first in a series of days or any other period of time to use the word from and for the purpose of including the last in a series of dates or any other period of time to use the word to. So 7 clear days notice, you exclude the first and the last day. Otherwise, it does not become.
Excluding first two.
First, my lord, that's the date of service.
Including last.
Yes, the date of service and the date of election have to be excluded.
Including last.
My lords, please see.
Shall be sufficient for the
Yes,
purpose of excluding.
for the purpose
first in a
excluding the first in a series of days
Ah.
or any other period of time to use the word from, and for the purpose of including the last in a series of days. So that last day also gets excluded.
Include agide.
Illa. For the purpose of including, my lords, it starts
In any
comma here, my lords, if your lordship sees. For the purpose of excluding in the first in a series of days to use the word from, and for the purpose of including the last in a series of days or any other period of time to use the word to. From and to, my lords, that's how the first date and the last date gets excluded. Otherwise, the 7 clear days would not have, it would have simply said 7 days, the rule. The very fact that the rule uses the term 7 clear days.
AR 2001, Shriram.
The court of
AR 2001, SC 36. 36.
We send them. The word send to every concern. Send. It is not receiving. Last.
Karnataka General Plaza.
ಇದು ಓದಿದ್ದೀನಿ ಬಾ.
ಕೊಡಿ. Page 36. Yeah, 2001.
If you exclude the first, the 21st ಹೋದ್ರೂ ಹೊರಟೋಯ್ತು. Two, 23, 24, 25, 26, 27, 28 ಹೊರಟೋಗುತ್ತೆ.
ನಾಳೆ ಇದೆಯಾ ಎಲೆಕ್ಷನ್? So you have to decide this now. ನಾಳೆ ಇದು ನೋಡ್ಕೊಂಡು ಬನ್ನಿ ಅಂತ ಹೇಳುತ್ತೆ.
Send to every counselor not reached to date not less than 7 days. This emphasis is on the send. Send. Seven days you are
Supreme Court has said it's only the first day which can be excluded.
Then, my lords, even then it is not 7 days. If your 21st gets excluded.
Let us be on concept.
Yes, yes, my lord. I read it is from and to.
ನೀವು ಹೇಳ್ತಾ ಇರೋದು both the days.
It has to.
Now, section 9 you rely upon, Supreme Court says it is the first day which has to be excluded. So if it is the first day which has to be excluded, now let us look at the number of days. Now the date is
21st is service.
So first 21st is service, 21st will add. Ellargu 21st ena service.
They are not disputing. Their case is, petitioner case is on 21st.
We are not disputing it. Why are you getting excited?
No, sir.
We are not getting excited.
Alla, sir.
Don't worry, we are not. That's our case also.
ನಾವು ಹೇಳೋದು ಹೇಳ್ತಿದ್ದೀನಿ ಸರ್.
ಅಲ್ಲ,
Election ಅಲ್ಲಾಗ್ತದೆ.
ಯಾಕೆ ಅಷ್ಟೊಂದಿದು?
ಇಬ್ರುನು ಯಾಕೆ? Let us look at the issue of law. So 21st we have to exclude. Clear? 28th is the election. That do clear, no dispute.
Please.
So 22nd is the first day. 23rd, 2, 24, 3, 25, 4, 26. 7 days baratalla.
Not less than. That's why, my lords, not less than 7 days.
That is if we exclude.
7th day ಬರ್ತಾ ಇದೆ.
That is if we exclude.
It has to, my lord, 7th, the first day you can't even count. 21st you can't even count. You start counting from 22nd, my lords.
The coordinate bench has held other way, Mr. Panindra.
Lords, I understand, but that's the rule, my lords. Otherwise, why is the rule there? That's why, my lords, I said.
Already on that.
My lords, rule 3.
Same language.
The rule says, especially in election matters, my lords, we can't give a go-by to these rules.
Can't give a go-by anywhere, but the coordinate bench decision is there.
Not less than notice of date so fixed, not less than 7 days prior to the date of meeting. Date of meeting is 28. So 7 days. Prior to the date of meeting. And please see what has been dealt there, my lord. Service is not dealt in the coordinate bench judgment. Notice date is taken into consideration.
Even worse than.
Huh?
Yes, our case is better than this.
Last moment al bande inna matters ida.
I'm sorry. I'm sorry.
ILR 2004 Karnataka 1102. ILR 2002 Karnataka 3216. 2004 Karnataka 1102. ILR 2002 Karnataka 3216. We are with you, but this judgment is there. We can't.
And my lords, your
say otherwise than that.
Lords, your lordships will have to consider whether that aspect is even considered. Their lordships took date of notice as a consideration. In fact, date of notice, my learned friend referred to in Narsimaya's case. That Narsimaya's case.
At the most, we can refer it to a larger bench.
But then, till then, my lords.
Then we can't do anything.
Lords, if prima facie, if I am able to show that it is within 7 days.
Well, here it is a notice, my lord. But in our case, it is already served.
No, notice.
No. Here it is a case of notice. Notice dated is 13/10/2011. Whether it is served or not, when it is going to be served,
That, my
So
lords,
that
has
seven,
been-
no, sir, please, sir. But in our case, my lord, it is already served. Kindly appreciate, my lord, in the case of Devi Bai case, my lord, notice date has been considered. But in our case, it is in better case, it is already served on 7 days is counted. Even in that case, my lord, this honorable court has taken date of notice, my lord.
That is precisely what Supreme Court says, no, in Narsimaya's case, which my learned friend referred, please see para 10.
In the Narsimha case, my lord, paragraph 19 is also important, my lord, where
And
court said,
the earlier judgments, of course, my lord, the act was a little different. My lords, 1979, the act was different. There also, my lords,
That
That-
is
notice to be
same-
sent.
and that was again notice of no confidence.
No,
3
here, my
days.
lords, the same election rules, there it was a little different. The municipality wise,
Narsimaya.
ಅಲ್ಲ ನರಸಿಂಹಯ್ಯಲ್ಲಿ ಪ್ಯಾರಾ 10 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ನೋಟಿಸ್ ಕಳಿಸಿದ ಡೇಟ್ ಮುಖ್ಯ ಅಲ್ಲ ಅಂತ. Please see para 10 in Narsimha's case.
Narsimaya case is worse for you.
I know, my lords, that's for no
Even
confidence.
for 3 days, 1 day idralunu they said nothing.
The
to it.
slight difference
In
there,
7
my
days
lord.
ಅಲ್ಲಿ 1 day
No,
ಮಾತಾಡ್ತಾ
the slight difference there is you have lost confidence. That's why you have, they take it as a technical thing. Here it's a case of election.
No, that's good.
another judgment where
Probably this is the judgment which, the reasoning is in this judgment which has been referred. Para 7 nodi. This is not excluding, this again, general clauses, first day not.
No, this is all dealing with the no confidence. My lords, I will just submit this.
Because 2 and 4 illa, this is only 7 clear days.
7
so
clear
2 and
days.
4 illa, the date of service to date of the meeting 7 days ಇದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Idರಲ್ಲಿ. Your lordships have dealt with that aspect, my lords, dealing with the election thing itself. My lords, there is a material difference between a no confidence notice and, my lords, a election notice.
This is not no confidence, that is election.
My lords, this is also, my lords, the election. Sorry. Adhyaksha, Upadhyaksha.
We are eschewing everything about no confidence, only on election we are looking. ಇದು ಇನ್ನೊಂದು no confidence ಇತ್ತು ಅದಕ್ಕೆ ಸೈಡ್ ಅಲ್ಲಿ ಇಟ್ಟು.
So just para 8 one ನೋಡ್ತೀನಿ, then I leave it to my lords.
ಕೊಡಿ ಇನ್ನ ಕೇಸುಗಳಿದ್ದಾವೆ.
Lords, I think even here, my lords, this is, if your lordship sees the General Clauses Act, that is very clear, my lords. Para 8, their lordships are again referring to Narsimaya's case. The issue there is whether giving itself notice date, that's what was dealt with the court.
Made out is section 9 will apply only when the word from and to are used, so that there is a reference point.
Lords, if
7 clear days, it has to be 7 clear days. That is why they have taken it as 7 days.
Lords, it says
Exclusion, no, they have
not less than 7 days, not less than 7 days prior to the date of meeting.
ಅದಕ್ಕೆ ಇಲ್ಲಿ ನೋಡಿ, the impugned notice is dated 11/4, served on 12/4, meeting was on 18/4. So 12, 13, 14, 15, 16, 17, 18, 8, 7 days ಇದೆ ಅಂತ. So ನಿಮ್ದು ಅದೇ ಅಪ್ಲೈ ಮಾಡಿದ್ರೆ ಟಚ್ ಅಂಡ್ ಗೋ ಇದೆಲ್ಲ, ಬಟ್ ಸ್ಟಿಲ್.
Lords, Act, it should not, my lords. Otherwise, my lords, we are giving a.
But this one is there.
The provision there, my lord, I'll just check that provision.
And in this matter, what we were dealing with is
that your lordship's
notice 25/1 service 30th, ಅದ್ರಲ್ಲಿ 5 days
5 days
ಕ್ಲಿಯರ್ ಆಗಿತ್ತು.
But then, my lords,
ಏನ್ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಮಾಡಿದ್ರೆ ಇದು ಚೇಂಜ್ ಆಗಲ್ಲ, ಬಟ್ ಇಲ್ಲಿ ಚೇಂಜ್ ಆಗತ್ತೆ.
There, my lords, of course, I'll just see those words in the Panchayat Raj Act. If here.
What you wanted to be listed tomorrow?
No, not at all. Now itself, my lords. No, because, my lords, what I am trying to make out is, if General Clauses Act applies,
ನೋಡಿ, pass over.
just.
But it looks like it's against you. We'll dismiss it and deal with it in detail, so that next time this issue doesn't come.
Just give me 5 minutes.
So that we are very clear that what we have done is correct.
A judgment on court. Lords, may I just go through that one judgment adu?
ಕೊಟ್ಟಿದೀವಲ್ಲ, ಅಲ್ಲಿ ಕೊಡಿ ಅವ್ರಿಗೆ judgment. Yes.
9, Venkatesh Kharvi.
Here in Challenge, award passed by the Lok Adalat. During the pendency of 7 applications. So I am not a party to the Lok Adalat, my lords. That is page number 96 of the order passed by the trial court, my lords. Or by the 96, my lords.
Page
96. 96 ಅಲ್ಲಿ Gangaram is the respondent number 1. Respondent number 1 and respondent number, my lords, 22. 96 page number. OS number 141/24. So respondent number 1 is file suit. Gangaram, that is the plaintiff, is arrayed as the respondent number 1, and defendants
You are
are.
not a party.
Yes, my lords. I am not a party.
This is
So,
regarding survey number 5.
Survey number 5,
What is
that
your
is
interest in
measuring
survey?
2 acre 20 guntas of.
What is your interest in survey number 5?
Mine is, my lords, I have filed 7 application before assistant commissioner against the respondent number 22. They are owners, and they are given, my lords, consent to that we are in possession of the property, and that is still in pending. During the pendency, my lord, he made a sale deed on 2016.
Now Gangaram has substituted the respondents. He'll be bound by whatever is
Yes, my
decided.
lord, we are liberty, my lords, because we are not a party. That is why I have challenged this.
At the most, Gangaram will substitute
Yes,
the
substitute.
landowners.
Yes, my lord.
He is
No,
bound
he
by
has
it.
not substituted, my lords, because the 7A application is filed by me. 7A, that is pending assistant commissioner. So he made an agreement, sale deed with these petitioners, these respondents, 2 to 9. So as per the, my lords, annex J, my lord, they have given consent. I have filed earlier 2016, my lord. In annexer, my lords, that is for annexer J, my lords, page number 62. I have filed, prior to that, my lord, I have filed a suit against them.
Enter the name.
Junction.
Yes, you are appearing for whom?
My lord, I'm appearing for first response, my lord, in this case, my lord. I'm the
Gangaram.
owner of the, my lord, the land.
Purchaser.
I'm the purchaser, my lord. My lord, when the petitioner is disputed regarding the, my lord, the possession, my lord, possession and title, my lord, then he can approach before the trial court and file the suit, my lord.
Are you making a statement that you will be bound by the decision in 7A? And if the order goes against your landowner, you will give the property to him?
It is still pending for the adjudication before the
If
assistant
he
commissioner.
succeeds,
Yes.
you cannot claim any equity. List pendants.
No, my lord, it is not a list pendants, my lord. In the year 2000,
7A is also a list pendants.
please. Because by virtue of the register sale date, my lord,
Yenappa, you will agree that you won't claim equity na, you want to contest his claim.
want to
ಎರಡರಲ್ಲಿ ಒಂದು ಹೇಳ್ಬೇಕು ನೀವು.
lord, want to contest, my lord.
Contest.
It's covered by this honorable court judgment, my lord.
Yes.
Regarding my lord.
Issue notice to respond number 2 to 9 ಆಗಿದೆಯಾ?
Other respondents.
2 to 9 ಎಲ್ಲ ಆಗಿದೆಯಪ್ಪ?
Other respondents ಇಲ್ಲ.
Please, my lord.
Interim order ಆಗಿದೆಯಾ?
ಆಗಿದೆ. Interim order ಆಗಿದೆ.
Interim order is
Only
there,
my
my
lords, apprehension is my lords.
ಇವತ್ತೇನಕ್ಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ?
We are in possession of the property. Now we are grown up that sugar cane, my lords. They have threatened the others, my lord, workers not to come to the land. We are in possession since from 1998.
ನೋಟಿಸ್ ಟು ಇವರು ಆಗಿಲ್ವಲ್ಲ?
ಆಗಿತ್ತು ಸರ್, ಅದು ತಗೊಂಡಿದೆ ನಾವು. ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿದ್ದೀವಿ.
ಕೇವೇಟರ್ ಅಷ್ಟೇ.
ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿದ್ದೀವಿ.
ಕೇವೇಟರ್ ಅಷ್ಟೇನಪ್ಪ?
ಕೇವೇಟರ್.
Issue notice to the main person you have to take notice ಅಲ್ವಾ? Issue notice to respondent 2 to 9 written by 28 April.
ಅಲ್ಲ ಉಳಿದವರು ತಗೊಂಡಿದ್ದೀನಿ. On my lord.
ಆರ್ಡರ್ ಆಗಿಲ್ಲ, ನೀವು ಹೆಂಗ್ ತಗೊಂತೀರಾ?
ಆರ್ಡರ್ ಆಗಿಲ್ಲ ಸರ್.
Please.
The operation of the order passed by Lok Adalat dated 16/3/2024 and OS number 141 of 2024 is stayed till the next date of hearing. Both the petitioner and respondents are restrained from any manner dealing with the property, transferring or alienating the property subject matter of the above petition till the next date of hearing.
Please.
Process fee and copies to be paid by end of day 28, filling which the interim order will stand out.
Please.
Lord, date may fix it.
Meanwhile, office objections to.
Please.
10, Praveen Puchareddy.
This is election matter. Voting rights were granted in terms of interim order. Now election has completed. Result of Lord, the elections to be announced.
No, my lord. As per the interim order, your lordship, the eligible candidates' results were ordered to be announced, your lordship. This will become infructuous, your lordship, then.
ಇನ್ನೇನ್ ಇವಾಗ ಏನಕ್ಕೆ ಮೂವ್ ಮಾಡಿದೀರಾ?
ಅಲ್ಲ, election results ಅಲ್ಲಿ ಅನೌನ್ಸ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ, eligible candidates' results were announced, your lordship.
ಇನ್ನೊಂದು ಬಾಕ್ಸ್ ಅನೌನ್ಸ್ ಆಗಿದೆ.
ಹೌದು. ಇದು petitioners candidates.
ಇದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಅಂತ.
That has to be heard.
Please.
ಏನಕ್ಕೆ ಮೂವ್ ಮಾಡಿ? Released on 11th March. ಅಷ್ಟೊಳಗೆ ನೀವು ಏನ್ ಸಬ್ಮಿಷನ್ ಹಾಕಿಲ್ಲ?
ಅಲ್ಲ.
11, ಮೃತ್ಯುಂಜಯ್ ಟಾಟಾ ಬಾಂಗಿ.
My lord, the proceedings under surface have been initiated without there being any installment unpaid as on today, my lords. There are no pending installments as on date. After my account, land loan account has been classified as NPA, the bank has received around 7 installments. There are no pending installments as on today according to their own statement, my lords. Page number, my lord, 41, my lord.
Bank standing counsel here.
My lord, I verified, my lords.
Yaru, who is the standing counsel?
No information with respect to that, my lords. I try to ascertain who is the standing counsel.
If you don't give, then only notice will be ordered.
Let's,
There's no point then. Annexure D. Annexure D was issued on October 3rd, 24.
Please, my lords. That was
After that you have paid Antira.
Please, my lord. After October, I have paid till February too. February, I have paid, my lords. Till February, I have paid. They have acknowledged the same.
As on that date, 1,34 lakhs was pending.
Please.
ಎಷ್ಟು payment ಮಾಡಿದಿರಾ?
My lords, page number 41, my lords, annexure G. Loan account details as on 18th Feb 2025, my lords. My lord, rate installments paid are 24. Installments pending 0. Future installments 163. I also produced my bank statements to show that I have paid the EMIs on time.
Where is that?
My lord, annexure H, my lords. My lord, starting from page number 50, my lords. 51. That is when my account was classified as NPA. That is 6/8/2024. On 6/8, I have paid EMI. My lord, 4/9, I have paid EMI. My lord, page number 53, 4/10, I have paid the EMI. And annexure H1, my lords, page number 55. For the month of November, I have paid. And for page number 57, my lords, that is forthcoming, 9/12, ICICI Bank, I have paid.
Standing counsel. 8/1/25 also is paid.
My lord, as on even on page number 59, my lords,
Issue
4/2/2025.
to the respondents returnable by 18th March. The operation of the execution of the notice dated 3/10 bearing so and so at annexure D and 13/2/25 issued by third respondent annexure E and 17/2/25 so and so at annexure F as stated till the next date of hearing. Take into consideration the bank statement which have been produced by the petitioner, which should indicate that the petitioner had been making payment of a sum of rupees 1,49,163 on a regular basis from April 24 till now, and that the statement issued by the bank itself indicates that there is no pending installment on part of the petitioner. Please, process fee and copies to be furnished by end of day 28, failing which interim order will stand automatically vacated.
Grateful, my lords.
12, Vinayak Megundi.
My lords, for the petitioner, my lords, I challenge the disqualification of the respondent number 5, my lords. He is one of a participant in the tender process which is initiated by the respondent number 2, my lords. My
What is
lords,
the reason for disqualification?
My lords, the tender process is governed by the provisions of the Karnataka Transparency in Public Procurement Rules, my lords.
Yes.
My lords, the respondent number 5 had sought for the details of our tender, my lords, my tender. So, my lords, it amounts
For
to
seeking for disqualifying of respondent number 5.
respondent number 5, my lords.
It's not challenging your.
Not challenging.
Without hearing them, how can we do it?
My lords, now the work order is being issued, my lords. So
that will.
My lords, further no precipitation.
ನಿಮ್ದು ಏನಾದ್ರು ಪ್ರಾಬ್ಲಮ್ ಇದ್ರೆ ನೀವು ಬನ್ನಿ, ಬೇರೆಯವ್ರಿಗೆ ಪ್ರಾಬ್ಲಮ್ ಮಾಡಕ್ಕಲ್ಲ ಬರೋದು.
My lords, but they have curtailed my rights, my lords.
They are not curtailed your right.
My lords, they have
You are
sought
seeking for.
My lords, they have sought for the documents which are produced in the tender process.
Then you have to challenge the tender, not asking for disqualification of respondent number 5.
My lords, if you see annexure E, my lords.
Application was made by the my lords, respondent number 5 seeking information. We have rejected that application on the ground that my lords, it will violate the my lords rule 23(1). Information kotilla. His case is that as he filed an application under RTI, he should be disqualified. No information is provided from the our end.
Documents are now being uploaded on the net, and AG accepts notice for respondent number 1 to 4. Issue notice to respondent number 5 returnable by 25th April.
My lords, until then, some.
Not at all.
13,
Pledged.
Shantaf Gaudar.
Here is a case of illegal seizure of the vehicle.
Illegal
seizure? Yeah, I have availed the various financial assistance from the respondent bank.
Who has seized it?
Canara Bank, the requiry age.
Standing counsel.
Canara Bank MB remit.
We can't grant this released by now. Yeah.
MB remit.
Mallikarjun B. Remit.
Mallikarjun B. Remit is directed to accept notice for
There's
respondent.
2 luxury vehicles.
Released tomorrow.
Refreshment.
14, Ajay Katkol.
My lords, I appear for petition in this matter, my lords,
Yes.
on behalf of Mr. Ajay Katkol. Seek for a pass over, my lords. He's on his legs and
Pass
he
over.
will oblige, my lord. Grateful.
Submission minute, serial number 13, fresh matter. 13 ಈಗ.
ನಾಳೆ ಏನ್ ಜಾಸ್ತಿ ಇಲ್ಲ.
15, VS Kalsurmat.
Please, Lord, here the petitioner herein has challenged the order passed by the first respondent and second respondent, wherein, my lord, they have stated that the property which was owned by my deceased father, it belongs to the panchayat, and now they are trying to put up the construction of the Anganwadi Kendra, stating that that property has been already notified under the resolution passed by the Gram Panchayat that there.
This is your
My lord, I have produced the tax-paid receipts and the DCR register which has been mentioned 2006 to 7. Page 20, annexure C. Since 2006, my lord, my name is entered. Bulkondi Hampam Pampanna. Their tax-paid receipts.
ಇವಾಗ ಈ ಕಡೆ ಬಂದಾಗ ಅರ್ಥ ಆಗತ್ತಲ್ಲ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಅಂತ.
And they have also.
Bellary.
My lord, V. Shivraj Hiremat.
V. Shivraj Hiremat is directed to accept notice for respondent number 1 to 3. The further proceedings pursuant to the order dated so on, order bearing number so and so, as per respondent number 1 dated 4/2/2025. and order bearing number so and so passed by respondent number 2 dated 12/1/24 at annexure A and B is stated till the next date of hearing.
Please.
16, MB Reddy.
I'm for the petition school, my lord.
Yes.
I've been into the education, been providing the education since 2006, my lords. And timely we have been renewing the registration. And for 23-24 year also it was renewed, my lords. But the R3 is denying this registration renewal for 24-25 for the year, academic year 24-25.
What are you seeking for? To cause the show cause notice.
Yes, my lords. They have issued show cause notice and we have to them.
Show cause notice reply ಮಾಡಿ.
ಮಾಡಿದೇವೆ ಸರ್, ಮಾಡಿದೇವೆ. ಆಮೇಲೆ ಅಪ್ಲೈ ಮಾಡಿದೇವೆ, ಆನ್ಲೈನ್ ಅಪ್ಲೈ ಮಾಡಿದೇವೆ ಫಾರ್ ರಿನ್ಯೂವಲ್ ಅಂಡ್ annexure J, my lords.
Copy ಕೊಟ್ಟಿಲ್ವಾ?
R1 has issued a notification stating that all the schools which have to be renewed, the relevant documents to be collected from them and be renewed by 28th of this month, my lords. And based on that notification, on 18th February, we have again uploaded our documents, but R3 has again rejected, my lords.
8/1/25.
Yes.
Then 16/1/25, again they issued a notice.
16/1/25.
The matter may be taken tomorrow. I will ascertain and make.
This is what we are going to do.
Yes, yes.
They were applied for on this one, the RM SATS portal.
Yes, my lords.
And AGA accepts notice for respondent number 1 to 4. He seeks for a day's time to obtain.
Interim order
make a Release tomorrow.
Please.
Nade.
17, Gangadhar Oskiri.
The petitioners are the members of District Consumer Commission, my lords. My lords, the petitioners were appointed in 2020, my lords, for 5 years term. My lords, in view of amendment to 2020 rules, my lord, annexure D, my lord.
When is your term coming to an end?
My lords, March 3rd, my lord.
March 3rd.
Please.
ಮತ್ತೆ ಇಷ್ಟು ದಿನ ಯಾಕೆ ಸುಮ್ಮನೆ ಇದ್ರಿ?
My lord.
Last moment ಅಲ್ಲಿ ಒಂದು pressure ಹಾಕಿ.
No, my lord. Sorry.
What is the stand of the state?
In view of that post, my lords, it is a honorary post. They cannot seek as a matter of right. They cannot seek as a matter of right. Continuation ಮಾಡ್ಬೇಕು ಅವ್ರಿಗೆ. But as a matter of right, they cannot.
But annexure D ಏನಿದೆ?
Annexure D is, my lords, the amendment. My lord, sub rule 2 of rule 10, my lords. Every member of the state commission and the president and every member of the district commission shall hold the office for a term of 4 years or up to the age of 65 years, whichever is earlier, and shall be eligible for reappointment for another term of 4 years, subject to the age limit of 65 years.
Shall be made on the recommendation of the selection committee.
Please, my lord. And in the teeth of the order passed by the Honorable Supreme Court, my lord, that is annexure E, my lord.
Yes.
In identical case, my lords, where in the, I will take my lords to page 39. Second para, my lord. This is our first term, my lord. We have perused the interim orders dated 10th November 2023. We make it clear that the benefit of the interim order will be available to those presidents, chairmen, and the members who were actually in service on the date of impugned judgment 20th October 2023, provided their second term has not expired. We make it clear that the benefit of interim order granted with a order dated 10th November 2023 will not be available to those who have completed their second term. It is our first term, my lord. We also make it clear that those who are yet to complete their second term may complete it in terms of the interim order, but they will not cease to be the president or member as the case may be immediately on completion of their second term. It is our first term, my lord. In short, no one is entitled to continue for the third term extension on the basis of the interim order of this court. My lord, Supreme Court has categorically held, my lord, in view of the Supreme Court order, my lord.
This order will be applicable to them also.
Please,
you can't
please
relieve them. If you do this, you are in contempt of Supreme Court order.
Supreme Court.
ನಮ್ದೇನಕ್ಕೆ ಬೇಕು ನಿಮ್ಗೆ ಆರ್ಡರ್?
My lords.
ಏನಕ್ಕೆ ಬೇಕಿದು? You
No, my
don't
lords,
require this.
my
order.
lord, they will relieve, my lord.
You don't require this order.
My
Supreme
lord
Court
is
order ಇದೆ.
my lord is Supreme Court for me, my lord.
ಹಿಂಗೆಲ್ಲ ಹೇಳ್ಬೇಡಿ. Supreme Court order is.
No, my lord. In view of that, my lord.
Lord, AGA accepts notice for respondent number 1 to 3. 3 ಗೂ ನೀವು ತಗೊಂತೀರಾ?
Please.
Commission. 1 to 3. The relief sought for, the interim relief sought for by the petitioner was actually not required to be sought for in view of the explicit order passed by the Honorable Apex Court in SLP number 25612 of 2023, produced at Annexure E. It would be for the respondents to act in terms of the said order.
Please.
And not relieve the petitioners till they complete their second term.
Please, deeply obliged. May I pray for hand delivery?
ಏನಕ್ಕೆ hand delivery?
Third, please, deeply obliged.
No. ಇನ್ನ ಎಷ್ಟಿದೆಯಾ?
Just finish it.
230 mood matter. 1, Sridhar Prabhu.
This matter, my lord, is regarding extra neutral alcohol. Page 89, my lord, a series of orders are passed, interim orders are passed. In view of the Honorable Apex Court judgment, my lord, in Lalta Prasad's wage case, 93, my lord, is the detailed order. In view of that, my lord, I'm praying for a stay of annexure A.
Yeah, where is the detailed order?
Page 93, my lord. Last page of the petition. Lordships will get, my lord,
Mr. Sharad, same order. And AGA accepts notice for MB Kanvi for
Please. ಕಣ್ವಿಗೆ ಮಾಡಿ sir. He's
MB
looking after that sugar.
Kanvina ನೀವಾ?
ಕಣ್ವಿ.
MB Kanvi for 1 and 2. 1 to 3. AGA for respond number 4 and 5. In view of the order passed by the coordinate bench of this court dated 17 to 2025 in WP number 101112 of 2025. The respondents are directed not to take any precipitative action during the pendency of the above petition. Not to take any precipitative action till the next date of hearing. Connect the above matter with so and so and relist on another date idya?
ಇಲ್ಲ, I don't know, my lord, I'll connect it ಅದ್ರ ಜೊತೆ ಬರ್ಬೋದು.
Relist on 16/4. Meanwhile, objections to be filed.
2, Kishore Sutar.
Please, my lords. Page number 26, my lords. Agreed by the issuance of warrant, my lords.
Warrant, EPL.
Attachment, my lords.
Yes,
Outstanding amount is, my lords, 11,84,681.
ಎಷ್ಟು ಕೊಡ್ತೀರಾ?
It's 3 lakhs, my lords. I'll deposit.
ಆಮೇಲೆ
Lords, I'll pay within 4 weeks. I'll pay the entire amount, my lords.
entire amount. Issue no, ಯಾರು ಕೆನರಾ ಬ್ಯಾಂಕ್ ಯಾರು?
Canara Bank.
Mallikarjun Swamy B. Remat is directed to accept notice for respond number 1. The submission of the counsel for the petitioner is that due to financial stringency, the petitioner could not make payment of the due amounts. Given 15 days time, a sum of rupees 3,00,000,000 would be paid and the balance amount would be cleared within 30 days thereafter.
Please.
Placing his submission on record, the operation of the order date 3/2/25 in commercial execution number 11 of 2024 passed by the principal district and session judge Belgavi state till the next date of hearing. It is made clear that in the event of default in any of the above payment,
Please.
that is, if the first payment of 15 lakhs is 3 lakhs is not paid by 13th March and the entire amount not cleared by 13th April, the interim order passed would stand automatically lapsed.
Grateful.
3, Prithvi KS.
Seeking transfer order. In spite of, my lords, the petitioner handovering the charge on 19/2, my lordship has, my lords, in interference on the ground that, my lords, the petitioner in, my lords, is the chief officer, grade 1, my lords, grade 1 group A, and my lords, the respond number 3, my lords, wherein the charge has been allotted. He is a, my lords, group C, grade 3, my lords, wherein this honorable court, my lords, in the, my lords, page 122, in before the, my lords, principal bench, the DMA, my lords, has filed affidavit, my lords, by stating that, my lords.
Any disciplinary proceedings taken?
Please, my lords.
Any disciplinary proceedings against the
Please. Affidavit ಹಾಕಿದ್ದಾರೆ. By stating that, my lords, may I read, my lords? Page 122, may I request, in the order, my lords. In that view of the matter, in Director of Municipal Admin, he directed to initiate action for.
122 na?
Please, my lords, 122.
8 ಬರುತ್ತಲ್ಲಿ.
Para 8 ಮೇಲ್ಗಡೆ, my lords, in the relevant portion, my lords, in 7th line, my lords.
Yes.
In that view of the matter.
Yes.
Director of Municipal Admin, he directed to initiate action forthwith to ensure that ineligible officers are displaced from the responsible post of Commissioner Chief Officer of CMCs, and only officers who are eligible to hold the post are placed therein. The second respondent shall ensure compliance with the above order and file an affidavit reporting compliance within a period of 2 weeks. It is open to the rest to reiterate the order made in favor of third respondent. Thereafter, my lords, they have filed affidavit and disposed of, my lords, by the division bench. And this honorable court, my lords, in the same writ petition, my lords, my lordship, order, my lords, has 132, my lords, may I request.
Yes, madam. If he is eligible, then
Please, your lordship. The third respondent, your lordship, he's been deputed as chief officer, your lordship. Moola hudde, your
he is
lordship,
not of
39
that
page.
grade.
Please, your
He
lordship.
is not of that grade.
Please,
He
your
cannot
lordship.
be appointed. That is what
Now he is holding the office of chief officer,
holding,
your
but he
lordship.
cannot.
Please, your lordship.
And AG accepts notice for respondent number 1 and 2.
1
issue
and
notice
2.
to-
And your lordship,
18 19 2 itself Madi has handed over the charge.
You have handed over.
That's what
I have taken the charge.
You can't hold it.
only 12 days were left to complete his 2 years tenure, your lordship.
2nd March, my lord, the 2 years will be completed.
You are not belonging to that grade. How can you discharge that? The court has clearly stated that.
We will file objections to my lord.
Objections early, but we'll stop this order. The operation and execution of the order dated 18/2/25 at Annexure F is stayed till the next date of hearing. Objections to be filed within 2 weeks from now, released on 27th March.
Please.
4, Venkatesh Karvi.
Wife initiate the complaint against the petitioner, my lords, under section 12 of DV Act, my lords. Petitioner and respondent marriage was solemnized on 23/11/2019, my lords.
Yes.
After the marriage of respondent gave birth to male child, my lords, on 29/10/21, my lords. They are lived in Qatar country, my lords. Since 2021, 2022, they came to India for a celebration of a male child birthday, my lords. After that, petitioner went to Australia, my lords. As per the allegation made in complaint, my lords, kindly see page number 16, my lords. Sorry, 17, my lords.
What
Para
are you
number 4.
challenging now, madam?
My lords,
What are you challenging now?
proceedings against the accused number 1, my lords.
ಅದನ್ನೇ quash ಮಾಡಬೇಕು ಅಂತ.
Yes, my lords.
That cannot happen as a interim prayer ಅದೇ ಕೇಳಿದೀರಾ. Notice ಹೋಗ್ಬೇಕಲ್ಲ. Issue notice to the.
In-laws is concerned, that's stayed by this honorable court.
Huh?
In-laws stay ಆಗಿದೆ. So only ground, my lord, 22 ದಲ್ಲಿ they returned to Australia. 24 she filed.
What is the allegation?
Allegation is, my lord, demanding, my lords, a dowry and that is construction of the house, my lord, charges of.
You are the husband.
That is only in tab number 4 and 8 of the
Complaint.
ಎಲ್ಲಿದೆ ಅದು?
tab number
Kindly see page number 17, my lords.
17.
Para number 4, my lords. It is submitted that in the month of October 2022, the said respondent and his family members are assaulted and quarreled with the petitioner number 1.
Mediation refer ಆಗಿದೆಯಾ?
ಅದು ಇದಾಗಿದೆ, mediation ಆಗಿಲ್ಲ ಅದು. So they are not taken, secure the report of the protection officer, DV activities.
Domestic.
Standard DV Act.
ಅದರಲ್ಲೂ mediation ರೆಫರ್ ಮಾಡಬಹುದು. ಏನಾದ್ರು ಆಗಿದೆಯಾ? Divorce proceedings ಏನಾದ್ರು ಇದೆಯಾ?
See, now is in Australia.
Any other proceedings, divorce proceedings or
ಇಲ್ಲ, agreement ಬೇರೆ ಯಾವುದು?
ಏನಿಲ್ಲ.
ಬೇರೆ ಯಾವುದು?
ಬರೀ DV Act.
Yes, my lords.
Issue notice to the respondents returnable by 26th March. The further proceedings in criminal misdemeanor number 42 of 2024 pending on the file of the civil judge in James Yaliyal. Insofar as the petitioner is concerned, is stayed till the next date of hearing. Process fee and copies to be furnished by end of day 28 February. Acknowledgement of service on the counsel for the respondent before the trial court to be filed on or before 6th March. Failing either of which, the interim order will stand automatically vacated.
5, Ajay Katkod.
My lords, I beg to appear for the petitioner in this matter, my lords.
Yes.
My lords, the order, my lords, passed by the a reference, my lords, in relation to an order that was passed under section 11 is what is impugned before your lordships in this petition. My lords, in 2023, my lords, the government of Karnataka would issue an order, and my lords, under section 11 of the Electricity Act, directing all generators, my lords, to supply electricity in view of the drought. Subsequently, my lords, insofar as the tariff that is payable to the generators, the reference was made to, my lords, the KERC.
Yes.
My lords are aware, when, my lords, the determination of tariff is done, the different components on fixed rates and variable rates, my lords.
What are you challenging here? What are you
The order,
challenging
my
here?
lords, of the order that is passed by the KERC, subsequent, my lords, in relation to the determination. Identical
determined
petitions,
it.
my lords. They
What
have
is the
determined
determination?
it, my lords. My lords, they have
What is it?
determined it, my lords, to a rate of 4.75 per unit, without even taking fixed and variable costs. This honorable court, my lords, in relation to a writ petition that was filed by other generators, my lords, my lords, was pleased to order, my lords, the stay of the order passed by the KERC.
Where is that order?
That's my apologies.
Where
I
is
was
that
able
order?
to lay. No, I was able to lay my hands on that order only today in the morning. That is, my lords, in writ petition number 100565 of 25.
100.
My sincere apologies. I couldn't. 565, my lords, of 2025.
Dated?
The order date, my lords, dated 28th of January 2025.
28/1/25.
Please.
KERC Sri Vivi Kamte, PS Kamte for respond. 1. Jescom Yaru. Who are the councils?
Shivraj Mudhol. Chandrasekhar.
Kadgol.
Chandrasekhar Hiremat.
Chandrasekhar Hiremat for respond number 2. ESCOM.
Shivraj Mudhol.
Shivraj Mudhol. MESCOM.
Bescom.
Mangalore.
Bangalore ille.
Ilva. BESCOM.
We shall take process.
Sumana Naganand madam is appearing.
ಇಲ್ಲಿ ಯಾರಿದಾರಪ್ಪ? 5
ಇಲ್ಲ, ಸುಮನಾ ನಾಗನಂದ್.
6 ಚಾಮುಂಡೇಶ್ವರಿ. Issue notice to respond number 4 to 6 returnable by 19th March. The submission of learned counsel for the petitioner is that a similar matter has been considered by this court in WP number 100565 of 2025, and interim orders have been passed on 28/1/25. He submits that the benefit of the said interim order may also be extended to the petitioner. In that view of the matter, the benefit of the order dated 28/1/25 in WP 100565 of 25 is extended to the benefit of the petitioner. Connect with so and so and relist on 8th April.
I'm so very grateful.
6. Rahul Puntoji.
For petitioner, my lord, challenging the deputy registrar award, my lord. Petitioner availed the loan of rupees 20 lakh in the year 2015, my lord. Now the NP has been passed in the year 2021, my lord.
Yes.
After that, my lord, award has been passed 26 lakh rupees, my lord. Up to date, my lord, I have paid them more than 20 lakh, my lord. Now the attachment order has been issued by the execution court.
Your guest is pending.
30 lakh, my lord. Execution 30 lakh, my lord.
30 lakhs. ಎಷ್ಟು ಕೊಡ್ತೀರಾ?
So already I have paid the more than 20 lakhs, my lord. And the loan amount is also 20
ಎಷ್ಟು
lakhs.
ಕೊಡ್ತೀರಪ್ಪ? ಬೇಗ ಹೇಳ್ಬೇಕು. ಏನು ಕೊಡದೆ ಮಾಡೆ?
No, no. 5 lakhs within.
ಹೇಳಿ.
5 lakhs within 4 weeks, 7.
5 lakh by?
Within 4 weeks, my lord.
Yeah, who is the standing counsel for respondent?
No, no. Stand for.
Issue notice to the respondent written by 9th April.
Please.
By 26th March. The submission of the learned counsel for the petitioner is that due to financial stringency, the petitioner could not make payment of the due amount. Given 4 weeks' time, he would make payment of a sum of rupees 5 lakhs. In that view of the matter, the further proceedings in pursuance of the attachment warrant issued by the execution court, namely the additional senior civil judge and JMFC Atni in EP number 99 of 2022, is stayed till the next date of hearing, subject to the petitioner depositing a sum of, making payment of sum of rupees 5 lakhs to the respondent on or before 20th March. If the payment is not made by then, the interim order will stand automatically vacated.
Please.
7. Sridhar Prabhu.
The matter concerns, my lord, payment under the power purchase agreement. Annexure J, page 201 is my lord's order, wherein, my lord, the operative portion 201, it starts 211, my lord, is the operative portion of the order, that for whatever period have supplied power, it should be paid. Now, my lord, they refuse to obey this order. Page 46. Your lordships will see, my lord, para I. Learned counsel for cogent plant submitted that. Page 46, my lord, lordships are with.
Yes.
Learned counsel for cogent plant submitted that in similar circumstances as in the present case, RP was allowed. Honorable court in so and so has specifically directed to pay so and so. Further, it is submitted that so and so, but they don't obey this order. Lord, next page, that RP so and so pay the tariff and stated that there was no necessity to send back the matter to KERC. Therefore, the direction in RP cannot be applied to the present case. Some skewed logic is given, my lord, that why my lord's order should not be allowed. And on principles of parity, my lord, I am saying whatever period I have supplied power, you pay, and they say KERC there was no necessity to send back the matter for KERC because a coordinate bench, my lord, said that I will not determine the tariff you send back to KERC, same tariff can be applied. Now they are saying, my lord, that they will not apply this order passed by your lordships. In fact, my lord, Honorable Justice Nagprasana's judgment also, page 152.
What is the interim prayer now?
I am only asking, Lord, Annexure B, the excess payment recovered, sought to be recovered from me may be stayed, Lord. That's all I am saying. I'm not
Because
even
that
asking.
payment has not come.
Yes, that they are saying, Lord, that I have to pay them ulta nane duddu kodbeku anta helತಾರೆ. Annexure B.
The BS company for respond number 1, ESCOM yarappa?
ESCOM, Lord.
Shivraj Mudhol. JESCOM?
Chandrasekhar Hiremat.
Issue notice to respond number 2, 4, 5, 7 and 8, returnable by 28th April. The demand notices issued by the respondent number 4 and 5 at Annexure B and B2 in furtherance and the order dated 15th October 24 at Annexure A is stayed till the next date of hearing. Process fee and copies to be paid by end of day 28, telling which interim orders.
8 Joshi
And
Shripad.
they are already stopped the NOC.
Nothing will happen. With so many of them, do you think hand delivery is possible today?
I'm so sorry.
8 Joshi
Lordship,
Prasad.
writ of mandamus, Lordship. The
Mandamus
urgency had the petitioners are corporators of Belgaum city. The respond number 2 passed an order disqualifying the petitioners. And I challenged the said order before this court, your lordship, and your lordship was pleased to dismiss the writ petition, giving me liberty to approach the government, your lordship. Appeal provision. Since there is a appeal provision, I filed appeal before the secretary on 13/2/2025, lordship. Till this day, the case was not assigned with any number and not given any date, lordship. And now the mayor and deputy mayor elections are forthcoming.
Respond number 1 and 2, he seeks fund is granted 3 days time to obtain instruction, make his submission as regards the status of the appeal filed by the petitioners.
Lordship,
Relist on
lordship, one submission,
4th March.
Lordship, one submission. Till this day, the number is also not assigned and
ನೀವು ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಅವ್ರ ಹತ್ರ ಕೇಳ್ಬಿಟ್ಟು ಒಂದು ಆರ್ಡರ್ ಮಾಡೋಣ ಅಂತ.
ನಿನ್ನೆ ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟು ಬಂದಿದ್ದೀನಲ್ಲ ಸರ್. ಈಗ ಮೇಯರ್ ಅಂಡ್ ಡೆಪ್ಟಿ ಮೇಯರ್ ಎಲೆಕ್ಷನ್ಸ್ ಆರ್ ಫೋರ್ತ್ ಕಮಿಂಗ್ ಲಾರ್ಡ್ಶಿಪ್.
ಯಾವತ್ತು?
ದಿ ನಾವು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್
ಯಾವತ್ತಿದೆ ಎಲೆಕ್ಷನ್?
ನಿನ್ನೆ ಲೆಟರ್ ಹಾಕಿದ್ದಾರೆ ಸರ್ ಅವರು.
ಇನ್ನ ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಿಲ್ಲಲ್ಲ. By 4th.
Lordship, the period has ended on 14/12 and the government has written to the corporation commissioner to hold the elections immediately. Given this political.
Is there a date fixed?
No.
That is intimated to the corporation.
That's all. Then Monday, Tuesday.
9 PM Mangdi.
Appearing for the petition in this matter, my lords.
Yes.
Am I audible, my lords?
You are very much audible.
This is a matter, my lords.
Yes.
Yes, my lords. This is a matter, my lords. Virtually, it's a mercy petition. The petitioner is a guarantor for a loan borrowed by given to the second respondent amounting to about 10.25 crores. And he has not.
This relief we can't give you, Mr. Ramana.
My property was worth about 40 crores. I have approached the Honorable DRT.
This relief we cannot give you.
Yes, my lords.
You are asking for quashing of the order of
Yes,
the
my
DRT. This we cannot give you. We can't do this. Ian, what is the amount you are willing to pay?
20%, my lord.
Any amount you are willing to pay?
20%, my lord.
20%. Shri
One month time.
Shri Iramat is directed to accept.
Aviator idare.
Copy also served,
Suresh
my lord.
Gundi yarge?
Okay, Canara
Copy
Bank.
served, my lord.
Canara Bank appear ಆಗ್ತಾರೆ ಸುರೇಶ್ ಕುಂಡಿ. Copy served.
Copy served.
Release tomorrow. ಅವ್ರ ಹತ್ರ ಮಾತಾಡ್ಕೊಂಡು ಬನ್ನಿ.
10 SP Hebbali.
Yes, my lord. In this case, my lords, the respondent number 3 is likely to withdraw compensation amount, my lords. Apportionment proceedings are pending, suppressing that he has filed reference petition, my lords, which is.
Who is respondent number 3?
He is subsequent owner, my lords. We are lease holders. The notice was issued during the period of lease, my lord.
The land has been acquired
Yes, my lord, please.
from you.
Please, my lords. The notice was issued during the period of lease in way back in 2017, my lords. Award is passed, my lords, and apportionment proceedings is pending, my lords. Annexure, we have produced certified copy of the same, my lords.
You are only a leaseholder.
Please, my lords. We are entitled for the compensation, my lords.
How can you be entitled for compensation being lessee?
My lords, land was acquired during the period of lease, my lord.
So what? You want to become the owner? Be a lessee.
Please, my lords.
How can you try to become the owner and deprive the owner of the compensation?
We are not the owner, my lords, but during that period.
Not possible at all. Petitioner is before this court seeking for the following reliefs. The petitioner,
My
the
lords,
AG accepts notice for respondent number 1 and 2. The petitioner who claims to be a lessee or the father of respondent number 3 is claiming that the petitioner is entitled for compensation on account of the acquisition of the land subject matter of the lease. And as such, a proceedings, reference have been filed for apportionment without any orders being passed thereon. Respondent number 3 is now proposing to withdraw the monies in deposit. On inquiry with the counsel for the petitioner, if there is any sale deed which has been executed in favor of the petitioner, he submits that it's only a lease deed. If there is a lease alone which has been executed in favor of the petitioner is only a lessee and cannot seek to substitute the owner while claiming for compensation. In that view of the matter, the petitioner cannot come in the way of the respondent owner withdrawing the compensation amount on account of the acquisition of his property. No grounds being made out, the petition stands
My lord,
dismissed. AGI.
11 Roshan Chabbi.
Yes, Mr. Chabi. Banri bega.
ಬಂದಿತ್ತು
ನಿಮ್ದಲ್ವಾ ಇದು?
ಅಲ್ಲ ಮೂವ್ ಮಾಡಿಲ್ಲ ಅಂತ ಅವ್ರು ಐ ಹ್ಯಾವ್ ನಾಟ್ ಮೂಡ್ ಎನಿ ಮೆಮೋ ಅಂತ.
Who is moved in your name?
I would verify, my lord. I have not moved.
ಏನ್ ಮಾಡೋದು ಇದನ್ನ ಇವಾಗ? ನಿಮ್ಮ ಹೆಸರು ಇದೆಯಾ ಇಲ್ಲಿ? ಇದೆ.
I'll have it tomorrow, my lord. I'll have this tomorrow, my lord. I have not moved any.
Relist on 3rd.
Please.
12
My lord, petitioner purchases a plot of land in the year 2008. Now, after 47 years, the alleged legal heirs of the grantee make an application in the form of an affidavit, and their names are mutated. This is the identical matter with respect to the same private respondents. Please, my lord,
same. ಇದು ಸರ್ವೆ ನಂಬರ್.
Please, my lord.
10 CTS ನಂಬರ್.
This is a different city.
And AGA accepts notice for respondent number 1 to 5. Issue notice to respondent number 6 to 24. Returnable by, what is it? In date is
11th March, my lord.
Returnable by 11th ಎಲ್ಲಿ ಬರುತ್ತೆ?
Released on
28th April.
Same.
The operation of the
Annexure E, my lords.
certification, ಇದೇನಿದೆ? The
CTS
operation of certification of mutation entry by respondent number 4 and 5 dated 10/10/2023 in respect of CTS number 7204 situated sector number 10 Ainanagar Belgavi in the name of respondent number 6 to 24 at annexure E is stayed till the next date of hearing. Connect the above matter with WP number 101008 of 2028. The respondent number 1 would have to file a detailed affidavit as to why such certifications are being made after the land has been acquired and plots have been formed. decades ago.
13, G. Gachirmat.
Petitioner, my lords, the respondents have called for tender, my lords. The tender bid document, my lords, standard bid document KW3 specifically provides that the tender shall specify the validity, my lords. At page 32, if my lords could kindly see clause 8. It specifically provides that the tender shall remain valid for a period not less than 90 days after the deadline of the tender submission specified in clause 12. A tender valid for a shorter period shall be rejected by the employer as non-responsive. The tender document, my lords, must necessarily specify the validity period, my lords.
Yes.
But if the tender document, my lords, which has been called for by the respondents, if it is perused, my lords, there is no specific period that has been specified. So the mandatory condition.
Have you submitted your bid?
I am the participant, my lords.
You have submitted.
I am participant.
It will be considered.
I have filed my objections, my lords. They are not considering it.
In objections in?
My lords, objections is that, my lords, it does not specify the tender period. It is a mandatory
By
condition.
asking for stay of the tender, what will the point achieved?
Please.
You are asking for stay of the tender.
Yes, my lords. Tender notification has to be
ಒಂದು
stayed.
ಮಾಡ್ತಾ ಇಲ್ಲ, time ಸರಿಯಾಗಿ fix ಮಾಡಿಲ್ಲ ಅಂತ ಇನ್ನೊಂದು stay ಅಂದ್ರೆ
ಅಲ್ಲ, time
contradictory.
No, my lords. If the tender document, if the tender period is not specified, then it will lead to
And
several
AGA
legal
accepts notice
complications.
for respond number 1 and 2.
Section 22 also.
And is granted 3 days time to obtain instructions as to what is the tender period and if the same has been notified. If not, when will the tender be closed?
That, my lords, no, let's kindly see, my lords, annexure C. They have called for tender on Saturday, my lords, to participants, my lords, to get themselves selected. Annexure C may kindly be seen for a moment. Annexure C, page number 63.
You have participated in the tender.
I have participated, my lords.
They'll consider it.
No, my lords. Period has to be specified in the tender document.
Your question is for your bid to be considered. We'll ask them from when they
No,
wish date.
bid is considered, financial bid is open. Then, my lords, now there are 4 bidders, my lords, who have emerged as L1. Through lottery system, they want to select one of the bidder. But the very issuance of the tender notification is void.
ನಾಲ್ಕು ಜನ L1 lottery system ಅಂತ. Fourth.
Please, Lords, may I make a submission, my Lords?
Yes.
That list 1, my Lords, 230 matter, serial number 17, Gangadhar Huskeri matter, my Lords. In view of the Honorable Apex Court order, my Lords, so Lords was directed to same relief was sought before, my Lords, in the principal bench. The division bench was, my Lords, was pleased to pass an order, my Lords. Already committee is constituted for appointment of the, my Lords,
Subject to that, Supreme Court order ಇದೆಯಲ್ಲ.
ಅಲ್ಲ, but ಇಲ್ಲಿ committee constitute ಆಗಿತ್ತು ಅಂತ ಹೇಳಿ dismiss ಮಾಡಿದ್ದಾರೆ.
But the Supreme Court order has not been brought to notice.
As the government advocate has filed a memo that already committee is constituted.
The public interest litigation to fill up the vacancy. Where you have said that you have issued this one.
A committee has been constituted.
This is something else. This is for the people who want to continue. And Supreme Court has passed an order saying 2 terms you have to continue.
Like committee is constituted, my Lords, and already if anybody is selected, because their term is, my Lords, about to come to an end on the 3rd.
But the Supreme Court order is much prior to your constitution.
Please.
You want to violate the Supreme Court order? You want to make us violate?
No.
Lords, may I request for 3rd, my Lords, instead of 4th.
3rd.
And subject to result. The process, my Lords, is held on Saturday. That is subject to result of the petition.
The tender process will be subject to result of the petition.
3rd.
List 1.
Lords, may I make a request, my Lords?
8. Correct.
4 password.
My Lords,
Number
may I
8, Murtunjay Hidikit.
And one more judgment where Narsimhaya case is followed in the say Municipalities Act also. The mandate of
the Narsimhaya is for
that is in the no confidence, that is in respect of no confidence motion. Similar analogy has been, similar proposition is followed in respect of the Grey.
Only as regard election.
Please.
ಅವರು ಅದು ಬೇರೆ ಇದು ಬೇರೆ ಅನ್ನೋದು ಬೇಡ.
Lords, I will just submit.
This is also Narsimhaya case they followed mandate at paragraph.
This is the election.
Paragraph 6, my Lord, may I request.
Again, it's motion of no confidence, para 6.
No, that is in the respect Narsimhaya case they followed. Only to indicate that, my Lord, there cannot be any difference between the election, as my lord put it, my lord, election or the no confidence motion. Both are relating to the democratic process. Where following the
That
Narsimha,
is your submission.
please, they're following the Narsimha, this court has interpreted. My lord.
Yes.
Lords, if your lordship saw that judgment, my lords, there the issue, my lords, never arose regarding the exclusion, my lords. There the lordships only considered, the lordships were referring to ILR judgment, my lords.
2002 Karnataka 3216.
There, my lord, the lordships went into, since that was only an issue whether 6 days had been complied from the date of service. That was the only issue. One other judgment I just want to point out and leave it to your lordship's discretion.
Facts
Lords, there also notice was given, but it was served on 12th. Their lordship said from 12th date of service itself, there was 6 days, so it,
7 days.
That the mandatory period, all that is held. Narsimhaya's also is followed there. But the question whether that day has to be excluded never arose for consideration in that. The date of service never arose because their lordships went into that. Only one judgment, my lords, what I wanted to point out.
Yes.
With regard to when the words used are not less than 7 days.
Yeah, judgment.
Supreme Court 1967, my lords. Sorry.
Time ಕೊಟ್ಟಿದೆ ತಪ್ಪ ಇದುವರೆಗೆ ಅಂದ್ರೆ ಇನ್ಯಾವುದೋ ತಗೊಂಡು ಬರ್ತಿರಲ್ಲ
ಅದು ಒಂದೇ then I leave it 1967 that of course and even under the taxation thing straight away if your lordship comes to my lords para 8 my lords there also the issue on not less than 30 days fell for consideration. It's a 3-judge bench judgment of the Supreme Court. Para 8 if your lordship sees. Para 6 is the issue which arose for decision. Serious question which arises.
ಹೇಳ್ತೀನಿ 7 days notice execution notice
ಬರ್ಕೊಂಬಿಡಿ 203 171 of 24 ಕಲಬುರ್ಗಿ ಬೆಂಚಿದ್ದು They said it is reasonable
My lords.
at para 680, page 680.
No, but 8, if your lordship sees, my lords, the lordships interpret when those words, para 8, my lords. It starts with, sorry. It starts with the words not being less than. If your lordship gets at para 8, my lords.
And then they say if sufficient time has been given for invitation. of the
That is, my
applicant
lords.
only for-
No, but if your lordship sees,
In the proviso, then it would serve the object of the.
they are the provision. But what the lordships observe is, the words not being less than 1 month do imply that clear 1 month's notice was necessary to be given. That is, both the first day and the last day of the month had to be excluded.
But in order to decide whether this portion of the proviso is a mandatory provision,
That it's a mandatory,
also which has to be done.
that is on the interpretation. But what they say is they refer to Maxwell's interpretation and say, when not less than so many days are to intervene, both the terminal days are excluded from the computation.
Yes, but in final judgment, what is it, Mr. Panindra?
Let's.
Final
No,
judgment, what is
the
it?
interpretation of how do you interpret this not less than, here there is no proviso. There, my lord, the lordship said.
Interpretation you are referring to section 9 itself is sufficient. But the way it has been interpreted by the courts, we are bound by that.
In fact, my lords, if your lordship sees ILR judgment, there is no argument raised or even considered with respect to General Clauses Act also. Their lordships simply say, their lordships hold it is mandatory. Their lordships hold that it is very important in the election process.
Want us to say something which we won't say. On an appeal, it can be decided, not for us.
Very
to
well,
say.
my lords. I am just saying that was my content.
won't be
Now the
proper
last
for
of the
us.
content. Now, my lords, if your lordship sees today, that I have shown, my lords, there, my lords, all the line of judgment say it is mandatory. It is not a directory principle regarding the notice period. In fact, there also their lordships held it is mandatory. That 7 days period, but their lordships only took it from date of service. There, that contention never arose. Because it was within.
Yes.
That's what I wanted to point out is this never arose, and the Supreme Court says both the days you have to exclude when you mention not less than. That's one, my lords. The last of it, and I'll wind, my lords, taken sufficient time. The last of it is, my lords, today there is no order of disqualification as against the legislature, the councillors. Your lordships have set aside that. They have to here pass an order. So as on date, there is no disqualification order. So everybody is entitled to vote. So my interim prayer, at least the alternate prayer is, allow all of us to participate in the election. That nobody can prevent us under the law. As long as I am a councillor.
Without a notice.
Not
You are
like-
willing to.
No, my lords, I have to. Otherwise, my lords, today, they did not issue me a notice on the ground that I was disqualified at that point of time. Your lordships have wiped out the disqualification order. So once once it is wiped out, I am a councillor.
Regarding the passing of order, there is no information. Right? And in the first petition, kindly recollect, there is no prayer in respect of challenging the voter list. There is no prayer. There should be a consequence.
But it is a natural
No,
consequence.
there should be a prayer, my lord.
That once the disqualification is set
I
aside.
don't, regarding that, my lord, regarding whether it's passed an order, I don't have any
If
insight.
an order is passed, that's different.
Please.
But if the
but
disqualification order which has been set aside by this court continues to be valid, then the appeal that has been filed by you, that there's no order.
But my instructions are that, my lord, whether it's passed or not, I don't know, my lord. That is
So long as the disqualification regional commissioner's order continues to be set aside and there's no order of disqualification, they should be allowed to vote.
But I don't know, my lord, whether the order has passed.
We also don't know.
It is fixed. Even I
Lordships
don't.
can observe.
That is not subject.
No,
That is
that's
not
in their
subject
hand.
matter of this writ petition.
No, there is a
That
prayer.
that is only interim prayer. Regarding the disqualification is concerned, there is no mentioning of anything under the
Lords,
writ petition.
The state has to be fair
No, no,
enough.
sir,
The
sir,
state can't
sir,
say.
Sir, there is no.
Please. Once the disqualification order has been quashed, they are qualified.
Well, subjected to the what is the order passed by the regional commissioner. If they pass an order, my lord,
Petitioner is before this court
please.
in service Saitala and AGA for respond number 123, Shri Harsh Desai for respond number 4. The petitioner is before this court seeking for the following reliefs. The petitioners 1 to
6
claim to be councillors of elected councillors of respond number 4. Petition number 7 to 9, though were elected councillors had been disqualified by an order of the regional commissioner, which has been quashed by this court by its order dated
24 to
24.
24 to 2025 in WP number
101414 of 25.
10
101414 of 2025.
1414 of 25.
fancy now.
The petitioners are before this court now contending that the notice which has been issued fixing the date for holding the election for the post of Adhyaksha and Upadhyaksha of the respondent number 4 council is not in accordance with law, and as such the said notice is sought to be quashed. The submission of Shri K.N. Panindal and senior counsel appearing for the petitioner is that in terms of
Rule 3.
Act 40. Act 8. That in terms of clause B of Rule 2 of the Karnataka Municipalities President and Vice President Election Rules 1965, the election officer has been defined. In terms of clause 1, insofar as subclause 1 of clause B above, insofar as city municipal councils are concerned, which respond number 4 is, the deputy commissioner or the person performing the duties of the deputy commissioner for the time being would be the election officer. Placing reliance on the same, his submission is that by
Page 24.
way of Annexure C, the deputy commissioner has virtually delegated his authority to the assistant commissioner. The assistant commissioner cannot be said to be the deputy commissioner or a person performing the duties of the deputy commissioner. As such, the nomination and or delegation of the delegation of authorities by the deputy commissioner to the assistant commissioner by way of nomination is bad in law. Consequently, the notice dated 20 20th February 2002-2025 issued by the assistant commissioner at Annexure D is non-est, contrary to the rules of 1965. There could be no delegation which could be made by a deputy commissioner. This he juxtaposes with clause 2 and clause 3, subclause 2 and subclause Roman 3 of clause B to contend that in terms of clause 2, Roman 2, it could be an officer nominated by the deputy commissioner, not below the rank of assistant commissioner, who could be the election officer. There is no such nomination facility provided under clause 1, subclause 1 of clause B of Rule 2, and as such he submits that both the nomination by the deputy commissioner and the notice issued by the assistant commissioner are bad in law, requiring the same to be quashed. Secondly, he submits that the notice at Annexure D, though dated 20/2/2025, was served on the petitioners on 21/2/2025, and as such, there is no 7 clear days notice in terms of Rule 3 of the Rules of 1965. In this regard, he relies upon Section 9 of the General Clauses Act 1897 to contend that the first day as also the last day would have to be excluded while considering the period of time in respect of Rule 3 of the Rules of 1965. He further relies upon the decision of the Honorable Apex Court in AR 1967 SC 684, more particularly para 8 thereof, which is reproduced hereunder for easy reference. By relying on the same, he submits that when words not less than is used, both the terminal days are to be excluded. That is, the first day and the last day are to be excluded. Insofar as the present matter is concerned, his submission is the notice being served on 21/2/2024. The date of service, that is 21/2/24, is required to be excluded. So also the date of the meeting fixed at 28/2/2020, fixed on 28/2/2025 was required to be excluded. If both 21/2/25 and 28/2/25 are excluded, only the days between 22/2/2025 and 27/2/2025 are available, which provide only a notice period of 6 days and not 7 clear days. On that basis, he submits that the notice, that if the first argument is not acceptable, in terms of the second argument, the notice not being for clear 7 days is required to be held invalid and a meeting be restrained from being held. Lastly, he submits that insofar as petition number 7, 8 and 9 are concerned, though they were disqualified as on the date on which the notice under Rule 3 had been issued, subsequently in view of the order dated 24/2/2025 passed by this court in WP 10/1414 of 2025, the order of disqualification having been quashed, the petitioners number 7 to 9 continue to be councillors, and as such they need to be permitted to participate and vote in the election now scheduled on 28/2/2025. Those are 3 conditions. J. M. Gangadhar, learned Additional Advocate General, appearing for the state, that is respond number 1 to 3, would firstly submit that in terms of the notification bearing number UDD 70 MLR 2004, dated 13/8/2004, by exercising powers under subsection 2 capital A of section 321 of the Karnataka Municipalities Act 1964, the government has delegated the powers of the Deputy Commissioner under Rule 2B1 of the Rules of 1965 to the Assistant Commissioner of the Revenue Subdivision, or the person performing the duties of the Assistant Commissioner for the time being. And it is in pursuance thereof that from the year 2004, the elections insofar as city municipal councils are concerned are being held by Assistant Commissioner. The said notification not having been challenged continues to hold forth, and the said notification not having been challenged in the present proceedings also, the submission on part of the council, on the part of the petitioners, that there is an improper delegation or nomination and or that the assistant commissioner is not the election officer in terms of clause 1, subclause 1 of clause B of rule 2 of the rules of 1964 is not sustainable. By virtue of the said delegation, the assistant commissioner is a competent person. This notification having been issued in respect to a delegated legislation, namely the subordinate delegation, namely the rules, has been properly issued, and as such, the petitioners cannot claim that the same is that the appointment of the assistant commissioner is bad in law. As regards the calculation of the dates, he relies upon the decision
Narasimha. Narasimha,
he relies upon the decision dated of the coordinate bench dated 19th October 2011 in WP number 39290 of 2011. More particularly, para 2 and 3. The said judgment being a short judgment, the entire judgment is reproduced here and for easy reference. By relying on the above judgment, he submits that the notice dated 13/10/2011 having been served on the councillors on 14/10/2011, the date of election being fixed as 20th October 2011, the coordinate bench has come to a conclusion that there is 7 clear days notice to the members. And even if there is no such 7 clear days notice issued, the calendar of events having already been issued and the election scheduled, the petitioner therein, if aggrieved by the outcome of the election, could always challenge the same in an election petition. Thus, he submits that a coordinate bench of this court, having interpreted the said provision and having come to a conclusion that a notice dated 13/10/2011 served on 14/10/2011 as regards a meeting to be held on 20th October 2011 as clear 7 days would imply that the same would be true for the present case, and this court would have to hold that 7 clear days notice has been issued. There is no requirement to apply section 9 of the
rules,
General Clauses Act to exclude the first and the last day, more so when this court has already considered the said provision and delivered a judgment. He also relies upon the earlier judgment of another coordinate bench of this court in ILR 2002 Karnataka 3216, which has been relied upon in Devi Bai's case. Insofar as Jitendra Manulal Dubey's case, he relies upon para 7 and para 8 thereof, which are reproduced here under for easy reference. He submits that that was also a case relating to election of the Adhyaksha and Upadhyaksha. A notice dated 11/4/2002 having been served on the councillors on 12/4/2002, and the election proposed to be held on 18/4/2002. It was held that 7 clear days was available. The contention of the petitioner therein that if the calculation of the number of days is made from 12/4, from date of service, that is 12/4/2002, by excluding the date of the election, that is 18/4/2002, there were only 6 clear days notice. The coordinate bench came to a conclusion that service having been effected on 12/4/2002, the period would start to run from 12/4/2002, and 7 clear days would be completed by 18/4/2002, and thus held that the notice issued therein is proper and correct, providing 7 clear days. On that basis, he submits that the provision concerned having already been interpreted by 2 coordinate benches, the said orders would be equally applicable and binding on this court, and there would be no need to further interpret the same by applying Section 9 of the General Clauses Act. Insofar as petition number 7 to 9 are concerned, his submission is that they having been disqualified as on the date on which the election was notified, there was no need to issue any notice to them, and no notice having been issued to them, the question of them participating in the election would not arise. And as such, he submits that the exclusion made of petitioner 7 to 9 is proper and correct. Heard. Ms. Desai, what do you have to say?
Since they filed a writ appeal, my lord, against that order, and also your lordships have fixed a timetable, my lord, that it had to be heard at 3 p.m. today. That's all. That
The
page is
Desai,
noted.
learned counsel for respondent number 4, also reiterates the submissions of the learned additional advocate general, and further submits that the order date, our challenge ಮಾಡಿದ್ರು.
ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು. ದೇವ್ ಚಾಲೆಂಜ್.
ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಬೇಕು.
ಇಲ್ಲ ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು.
ಅವ್ರ ಫೇವರಬಲ್ ಆರ್ಡರ್ ಅಲ್ಲ.
ಅವರೇ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
My instructions are not that going and appearing, that they want to pass an order today itself without an opportunity.
But they had challenged.
Lords,
We thought they stated challenge our order.
no, they are, my lords, the intention is that they pass an order this.
Both of you challenged. The petitioners having challenged the order dated 24/2/25 in WP 101414 of 2025, the said appeal having been dismissed.
No interference.
Interim order
Only
having been passed therein.
With some observations.
some observation to seek the clarification before this honorable court, if they want it, because they sent consent.
ಅದೆಲ್ಲ ಹೇಳ್ಬೇಡಿ ಮತ್ತೆ ಅವ್ರು
Observations andre saaku, my lords.
but observations having been made. Petition number 7 to 9 would not be entitled to participate or vote in the election. Heard Shri K. N. Panindra, learned senior counsel for the petitioner. Shri J. M. Gangadhar, learned additional advocate general for respondent number 1 to 3. Shri Harsh Desai, learned counsel for respondent number 4, peruse papers. The points that would arise for determination in the present matter are: 1.
Can I take leave?
You would.
There'll be less disturbance for your lords if I leave.
That is true.
That's why I'll have
First
to.
time you are right.
But except the last one is what I had pressed on.
Last, subject to no disqualification order, will permit.
Please.
ನೀವೆಲ್ಲ ಹೋಗ್ತೀರಿ? ನೀವು ಅವ್ರ ಜೊತೆ ನಾಳೆ ಇಲ್ವಾ? Whether the notice issued by the Assistant Commissioner at Annexure D is in terms of Clause 1, Subclause 1 of Clause B of Section Rule 2 of the Rules of 1965. Whether the notice is in compliance with Rule 3 of the Rules of 1965, whether petition number 7 to 9 are required to be permitted to participate in the election and cast their vote. For what order? Answer to point number 1. Rule 2 of the rules of 1965 is reproduced hereunder for, clause B of rule 2 of the rules of 1965 is reproduced hereunder for easy reference. A perusal of subclause 1 of clause B of rule 2 would indicate that in the case of city municipal council, the deputy commissioner or the person performing the duties of the deputy commissioner for the time being would be the election officer. It is on this basis that Shri K. N. Panindra, Learned Senior Counsel, has submitted that it is only the deputy commissioner who could be the election officer. The assistant commissioner, being a subordinate officer, could not be the election officer. Insofar as this aspect is concerned, the Additional Advocate General has relied upon the notification dated 13/8/2004. The said notification is reproduced hereunder for easy reference. A perusal of the said notification indicates that by exercising powers conferred under subsection 2 capital A of section 321 of the Karnataka Municipalities Act 1964, the government has delegated the powers of the deputy commissioner under Rule 2B1 of the rules of 1965 to the assistant commissioner of the revenue subdivision or the person performing the duties of the assistant commissioner for the time being. Section 321 reads as under. A reading of section 321 would indicate that the government has the powers to delegate to the Director of Municipal Administration, Deputy Commissioner, Assistant Commissioner or Tahsildar such of its powers under this Act except the power to make rules. And by the government may also by notification delegate to the Deputy Commissioner any of the powers conferred under the Act on the Director of Municipal Administration. It is in pursuance of these powers to delegate under section 321 of the Municipalities Act 1964 that the notification dated 13/8/2004 has been issued, wherein a specific delegation has been made of the powers of the Deputy Commissioner under subclause 1 of clause B of Rule 2 of the rules of 1965 to the Assistant Commissioner. Neither the powers under section 321 nor the notification dated 13/8/2004 are under challenge in these proceedings. Be that as it may, there is a notification which has been enforced from 13/8/2004 delegating the powers of the Deputy Commissioner to the Assistant Commissioner of the Revenue Subdivision, delegating the powers of the Deputy Commissioner to the Assistant Commissioner of the Revenue Subdivision to act in pursuance of Rule 2B1 of the rules of 1965. Thus, the contention of Shri K. N. Panindra, Learned Senior Counsel, that it's only the Deputy Commissioner who can act as the election officer in the face of the notification dated 13/8/2004 cannot be accepted. I answer point number 1 by holding that the election officer in terms of clause 1, subclause 1 of clause B of Rule 2 would include the Assistant Commissioner of the Revenue Subdivision or the person performing the duties of the Assistant Commissioner for the time being, and thus the notice issued at Annexure D is proper and valid, and there can be no infirmity found therewith. Answer to point number 2. Much argument has been advanced on the notice not providing 7 clear days as required by under Rule 3 of the rules of 1965. Rule 3 is reproduced hereunder for easy reference. The perusal of the aforesaid rule indicates that the election of the president and vice president shall be held in a meeting fixed by the election officer, and the election officer shall thereupon send to every councillor notice of date so fixed, not less than 7 days prior to the date of the meeting. It is now not in dispute that the election officer has issued the notice and the date has also been fixed by the election officer. The receipt of notices by the councillors is also not in dispute. What is only in dispute is as regards the 7 days prior notice in terms of Rule 3. The submission of Shri K. N. Panindal and Senior Counsel is that the notice being dated 22/2025